ಮುಂದೆ ಮೂವ್ ಮಾಡಿ ಸೀನಿಯಾರಿಟಿ ಬರ್ಬೇಕು ಮಾಡಿ.
ಇಲ್ಲ ಪ್ರದೀಪ್ ಹಿರಿಯೂರವರು ಸಿಂಗಲ್ಲ ಪೂರ
ಆಯ್ತು ಹೋದ್ರೆ ಹೋಗ್ತೀಯ Yes. Settlement. Yes, tomorrow. No, review petition. For what? In which matter? Of the FC. Yes, next week, Monday or Tuesday. Tomorrow. Yes. Class examination next week, Monday or Tuesday. What will happen? They will not pass any order. Yes. Tuesday. Yes.
Lordship, commercial execution, Your Lordship.
Others are opposite file disputed the relationship. Then I will secure the document to show that she was the wife of the deceased and produce the document and write an application to recall PW1 that is rejected and posted to Saturday and tomorrow.
For what?
For the argument.
Argument. Tomorrow.
Lord, my lord. The entire series consideration. Now
I
I
know.
want final presentation of the property. Now trying to integrate the property.
Monday, yes.
Your lordship, commercial execution, your lordship. Attachment of removal is ordered. At this display tomorrow before the.
Then when ordered for attachment,
December it was ordered. Your
then what are you doing all these days?
Right. 15 instances were filed it, your lordship, but filed a memo last time. It was
Yes.
not posted, your lordship. I'm moving it today, your lordship.
Tomorrow.
Typo. The petitioner.
No, why it is coming before this court, clubbing? Yes, Monday. For what? Arguments tomorrow, yes.
My lord, petitioner is.
Tuesday.
My lord, petitioner is,
Yes, Tuesday.
lord, petitioner is,
Monday.
my application rejected. What?
21-1, yes, Tuesday.
20th judgment.
Hmm. Next week, 30. No, there is no urgency matter. See that
My lordship,
Huh?
what a matter is set on for.
19th ಗೆ ಏನಕ್ಕಿದೆ? ಏನಾಗುತ್ತೆ ಹೇಳಿ? Yes. ಆಯ್ತು, let us be, yes, we will
My
say
lordship.
that if there is an order. No, that Wednesday. IA for what? Tomorrow for what? Tuesday. Hmm. Withdrawal, next week ಅಲ್ಲಿ ಯಾವತ್ತರ? Monday, yes. Next week alta.
My lordship,
It could be urgent in the.
Tomorrow.
That.
my lordship, in this case.
RFA.
Yes, let it be there, objection. There is lot of things has to be done after objection. There is no urgency.
Tomorrow pronouncement
They
of
will.
judgment.
Urgent.
My lordship, in this case.
All matters. See, all matters will given a date and send it to that branch, 1 or 2 weeks. But if there is any urgency, tomorrow you move.
My
Otherwise,
lordship
simply
is very much urgency, my lordship.
Yes, what is that?
So-
All memos, don't worry, we'll give a specific date, 1 or 2 weeks. Only something will happen tomorrow or day after tomorrow move. Otherwise, I could have start by
Tomorrow maybe, my lordship.
1 by 1 will come. Yes. Tuesday. No, Tuesday. ಆಯ್ತು ಇರ್ಲಿ, ಏನಾಗಲ್ಲ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ನಾವು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದೀವಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಏನಾಗಲ್ಲ ಗೊತ್ತಿದೆ. Then Wednesday,
Tomorrow,
Tuesday.
tomorrow
Yes.
matter is set on for.
Next week, yes. Recalling what? No, evidence is over. Then posted for what? When? Next, yes, Wednesday.
Tomorrow is pronouncement of judgment.
What is that?
My lord,
Now, my application was rejected. There is a small survey number error ಆಗಿತ್ತು sir. That application rejected.
Application for what?
Amendment of line
When it is rejected?
was rejected in the 2023 manner.
Then what are you doing?
Restart
that?
ಆಗಲಿಲ್ಲ.
Huh?
Restart ಆಗಲಿಲ್ಲ.
What to do that?
ಬರೋબર.
Next week? No, mister. One
ನಾಳೆನೇ
year you are kept quiet, nothing doing.
ನಾಳೆನೇ judgment ಇದೆ.
ಆಗ್ಲಿ ಬಿಡಿ, ಏನು ಮಾಡಕ್ಕಲ್ಲ. That is for your fault. You have not done anything
My
for
lordship.
1 year, mister. Yes.
So in this case, I'm up.
ಯಾವಾಗ? When it is rejected, madam? 15/11? 15/11/2024. Tuesday. No, Tuesday, yes.
My lord. This matter, my lord, that we have filed compromise petition, compromise has been recorded, but deferred the matter by the trial court. Respondent also appeared. Have it tomorrow and we will close, my lord.
You are compromising that.
Compromise petition filed
Hmm.
and recorded by the trial court, but they have deferred to pass order.
Why?
There is no reason has been given, therefore we have filed petition, both parties present before this.
No, we'll direct the trial court to.
Therefore, have
Yes,
it tomorrow.
Yes.
For DNA for the thing of.
Hmm.
22nd, airport has given the statement.
For what? Huh?
Dependent.
Yes, next week. Yes, next week date ಕೊಡಿ. ಆಯ್ತು, ಏನಾಗಲ್ರಿ. ಏನು ಆಗಿಲ್ಲ, ಏನಾಗುತ್ತೆ ಈಗ? Next date has been. ಆಯ್ತು, see Monday, yes.
Without impeding sisters and partition.
Hmm.
Now he is going to withdraw the amount. Therefore, there is urgency in that.
Tuesday, yes.
Here, connected back.
Yes. Next week, yes. Yes, date ಕೊಡ್ತಾರೆ. Yes. Yes. Tuesday. Yes, 22nd. Yes, 22nd. Let us see on that. Yes.
The petitioners were unaware of the FTP proceedings.
Hmm.
Now, on 18th, the ADLR is coming to the spot and demarcating the scheduled property.
Hmm.
Without my notice, there was no service has been done towards me. There is no summons has been issued, nothing whatsoever.
Hmm.
The ADLR
Suit for,
suit for partition and separate portion.
you are not a party.
No, madam.
Then no,
They have made me as a party, but no service has been done. There is no summons upon me. There is a mentioning of wrong address.
no, in that YS you are made in a party, but notice has been served.
No, ma'am.
I will challenge that degree.
Please, madam, I have challenged.
What is that?
RFA as outcome has come, my lord.
Hmm.
Where my address, I have changed my house, my lord.
See what has happened to that appeal you have filed against the degree.
Allowed.
Hmm.
Allowed, my lord.
Then what is that execution now?
For executing, I have not filed I have not participated in the proceedings itself, FTP.
Mr. Counsel, you said that degree has been set aside in that appeal.
For the decree holder side, my lord. I am for the judgment debtor.
Hmm.
There is no summons has been issued for me, my lord. I have
Then
not filed my objections.
I
Where I am
pray-
residing
you are-
in that property.
No, if you are not served summons after coming to your knowledge, have you challenged the degree?
My lord, now I came to know, my lord, after the ADLR issued the notice saying that I am demarcating your property.
No, you have not challenged the degree as on today.
There is an order by the trial court, that's all, my lord.
What
As
is
of
that?
now.
No,
The court commissioner has been appointed. The court commissioner is the ADLR.
no, that is different, Mr. You said that in the degree, there is no notice has been served.
Not
No.
in degree, my lord, in the FTP proceedings.
FDP proceedings notice is not served.
No, my lord.
Now, what is that it is posted for?
For demarcating of the scheduled property for division.
Wait, no, Monday. Yes,
Tomorrow, my lord, because on 18th he is coming to the spot.
Monday, yes.
I mean, ನಾಳೆನೆ ಬರ್ತಾವ್ರೆ.
Barley, Monday.
Demarcate ಆದ್ರೆ my entire scheduled property will be.
Nothing will, they will submit a report, that's all, Mr.
Please, my lords, but I have not filed my objections also tomorrow.
We'll see on Monday, yes.
They obtained the degree, my lord. After the death of decree holders, the LRs have filed the execution, my lord, without obtaining the succession certificate, my lord. Now it is issued for the warrant.
Monday.
My lord, office serial number 32 office objection ಇದೆ seats
Yes.
1 week.
Hmm.
I filed the reading application, or having a share of 2 acres out of 5 acres.
Yes.
Now, application is rejected, and the evidence is put to the next.
When is that evidence?
24th itself.
Yes, leave this matter on 23rd. Yes. Yes.
Next week.
For page wise adjournment, list number 1, page number 1, serial number 1 to 3,
Yes.
adjournment.
Respondent.
Page number 2, serial number 4 to 30.
Yen Bekapa. You are appearing for whom? Yes, you are appearing for? Yes, at the request of counsel for the respondent. Leave this matter next week. Yes.
Page number 2, serial number 4 to 13.
Matter after 2 weeks. Yes.
Page number 2, serial number 4 to 13. ಹೇಳಿ ಮುಂದೆ ಮೈಕ್ ಹತ್ರ ಬನ್ನಿ ಸರ್ ಅಡ್ಜರ್ಮೆಂಟ್ ಅಷ್ಟೇ ಅಡ್ಜರ್ಮೆಂಟ್
Yes.
ಪೇಜ್ ನಂಬರ್ 3 serial number 14 to 23, page number 4 serial number 24 to 33.
33 ಬಂತು.
Hmm.
ಹೇಳಿ.
Have you informed other side? Then you have to inform and move that matter, madam, at the request of counsel for the
My lord, serial number 32 office
ಸರಿ ಸರ್ ಪೇಜ್ ವೈಸ್ ಒಂದು ನಿಮಿಷ wait.
serial number 16 at the request of counsel for the respondent. Leave this matter next week.
Page number 4 serial number 24 to 33 ಹೇಳಿ
my lord, serial number 32 office objection ಇದೆ my lord, 1 week time.
Yes, all 1 week. Non-complaints.
from serial number 27 to
35.
36.
You comply office objection, why you have not complied all this day, madam, till that matter has to be posted for argument. When you have filed this petition?
ನಿನ್ನೆ ಬಂದಿತ್ತು ನಿನ್ನೆಯಿಂದ ಇವತ್ತಿಗೆ ಆಗ್ತಿತ್ತು
Hmm.
ಇವತ್ತು comply ಮಾಡಿ.
Appellate number 1. Son of Patel Anmay.
Yes, 34, 35 tomorrow. When you have filed this petition?
Appellate number 1. I'm father of appellate number 2.
$15? Yes, password, yes.
Serial number 27 to 30.
Other matters 2 weeks. 36 also 2 weeks.
Page number 5 serial number 37 and 38.
What is that office objection is there? Password, 28 also password, 29. Yes,
29.
password.
Page number 5 serial number 37 and 38. Page number 6 serial number 39 to 41.
My lord, serial number,
Serial number 41, I appear for the petitioner's counsel. 2 weeks' time in this matter because the interim order has been in existence from July 23. It's nearly 2 years now.
Yes,
And
that's
the
the
application for vacating stay was filed early last year. I'm
Yes,
told
at the request of counsel for the petition.
still there are office objections also.
Is this matter next week? Yes,
2 weeks.
serial
please.
number 40, my lord.
Interim order will have to be extended.
yes. Interim order granted earlier is extended next date appeal.
Serial number 40, my lord. I am for respondent in 40 and 40.1. I am the petitioner. I have intimated to the other side, my lord. It may be taken up on Monday, my lord.
You have to pay that process, mister.
That is a petitioner, my lord. I am respondent in that. In 40.1, I am petitioner.
Yes, 40 weeks time is granted to do the needful. Yes,
Interim order may be extended, my lord. 40.1.
interim order granted earlier is extended if any.
Grateful,
Page
my
number 7, serial number 42 to 45.
Serial number 43, my lord. Please, week time.
Yes, week's time is granted to do the
IO may be extended.
interim order granted earlier is extended till next date of hearing.
Page number 8, serial number 46 to 49.
Week's time to do the needful interim order granted. No, that they have to pay the process service is not. If you take notice, we'll complete that and fix. Yes, week's time is granted to do the needful. Use this matter next week. Interim order granted earlier is extended till next date of hearing.
Page number 9, serial number 50 to 53.
53, my lordship.
Yes,
I seek for 1 week adjournment, my lordship.
awaiting service of notice.
Yes, my lordship. Personally, I have not served my lordship. Through court, it is served. Personally, I have not served my lordship. So I have seek for 1 week time, my lordship.
Yes, yes,
TI can be extended, my lordship.
interim order extended, if any. Yes,
Page number 10, serial number 54 to 58. Page number 11, serial number 59 to 64. Page number 12, serial number 65 and 66. Page number 13, serial number 67 to 69. Page number 14, serial number 70 to 76.
Lords, appearing for the 72nd matter for the petitioners, my lords. The other side has been intimated. 2 weeks' time may be granted, my
the
lords.
request of.
They're exploring the chance of settlement in this matter, so 2 weeks' time, my lords.
Yes, leave this matter on fifth.
Lords, interim order is there, my lords. Interim order.
Interim order granted earlier is extended till next date of hearing.
Page number 15, serial number 77 to 82.
Serial number 80, your lordship.
Yes,
Serial number 80, a week after next, it may be taken up.
you are appearing for
I'm for the petitioner in this matter.
the request of counsel for the petitioner. Please this matter of.
Interim order may kindly be extended.
Interim order granted earlier is extended till next date of hearing.
Much.
I am for the respondent number 1 to 4, caveat respondent.
At the request of counsel for the petitioner, leaves this matter next week. Interim order granted earlier is extended till next.
Kindly fix the date, lordship.
29th.
29th of this month,
Yes,
please. Ma'am.
Page number 16, serial number 83 to 90. Page number. List number 1 for preliminary hearing, serial number 1 adjourned, serial number 2 Vivek R for petitioner.
For the petitioner in matter, my lords.
yes.
Lords, this is a plaintiff's petition challenging an interim order of refusal filed under Order 38, Rule 5, my lords.
For
Suit for specific performance.
Hmm.
The total sale consideration under the agreement was 10 crore 75 lakh, my lords, for purchase of an agricultural plot of
Oh.
5 acres.
whom you want to implead?
Not implead, my lords. It is attachment before judgment, my lords.
Hmm.
38 Rule 5 application has been rejected.
Hmm.
I had paid a total sum of 3 crore 35 lakhs. Earlier, at the time of filing the suit, I had also filed an injunction application. That said application was rejected on the ground of limitation. However, the same has been challenged before this Honorable High Court, my lords, and it is still pending for consideration, my lords. In terms of the present application,
No, what is that earlier application?
under injunction, my lords.
For
Seeking-
what? Injunction means what?
Injunction not to alienate the
Not to
property.
alienate.
Yes, my lords. Since I have paid a substantial amount of consideration, around 3.35 crores, the defendant is refusing to either execute the sale deed or return the money, my lords. Therefore, my lords, I filed an application.
Suit itself is pending. How you will execute, mister?
Indeed, my lords. The reason is, there are certain sale deeds which have been executed.
This has to be decided in that. If it is
Indeed.
executed, what else remains in that suit?
Exactly, my lords. That exactly is the reason why I filed this application, because my consideration that I've paid, around 3.35 crores, is stuck with them, my lords, and they're not even returning back that to me.
No,
So-
you want money back or you want to execute the specific performance?
My lords, as of now, because it's a 2012 agreement, my lords, they have already moved on and they're not even refunding my money, my lords.
Is it your prior that refund of
Yes,
money?
yes. I have filed it in the plaint, my lords. The plaint can be found at page number 38 onwards, my lords. More specifically, the relief
No,
for
that,
the plaint.
attachment cannot be, but not to alienate, which is that writ petition? We challenge.
It's a MFA, my lords.
You press for that?
Indeed, my lords, indeed, my lords.
If not to alienate, then this will not be come in their way.
My lords, the problem here is if in case they alienate, my lords, my remedy will be frustrated, my lords.
No, that is what that is the right case where you have filed for application. Normally, there will be an order to not to alienate that or create third party. You press for that MFA.
My lords, a notice may be issued, my lords. The reason is, my lords, if in case they keep on selling the property, my lords, my remedy will be frustrated, my lords.
No, you have.
I will anyway contest before this honorable court in,
What has happened to that MFA?
my lords, I'll check the status, my lords, once.
You move on, they get it order, mister. Otherwise, he is going to alienate. Yes.
I will do that.
Issue notice.
Much obliged.
Serial number 3, Satya D for petitioner, Raghavendra Ji.
Permitted to appear on behalf of the petitioner.
Yes.
My lord, P and SC proceedings, my lord, have been initiated by the petitioners. My lord, the claim is, the first petitioner claims to be the wife of the deceased by name Gopal. And the second petitioner is the daughter.
Yes.
My lord, when the petition, my lord, was being prosecuted, an impleading application, my lord, came to be filed by the sisters of the deceased, seeking that they must be impleaded in the matter. My lord, their contention is the first petitioner was already divorced with the deceased, and hence she will not be able to maintain the petition. Now, as far as the second petitioner is concerned, my lord, lot of documents were produced before the court below. Right from, my lord, her birth till, my lord, now the SSLC certificate, which reflects that she is the daughter of the deceased. Now, the daughter, my lord, is there before the court, seeking for the succession certificate. Now, the sisters, my lord, are not even the class 1 heirs to be impleaded. They do not have any right over the property as long as the daughter is there. Now, notwithstanding this said fact, my lord, the impleading application is allowed. Now, my lord, it gets only complicated, and my lord,
No, in
now,
the service records, who is the nominee?
nominee, the sisters were shown as the nominee.
And they are necessary party.
No, but now, my
No,
lord,
this is not that they are granting that any relief, but they are
Yes,
the
my lord.
necessary party. Let the court decide. See, they have to prove before the court.
Yes,
See,
my lord.
admittedly, you are in a wife.
Yes, my lord,
Then
please.
they have to prove that where is the divorce? Divorce cannot be by writing and all. There should be an order of the court.
My lord, there is a divorce.
It's an
As far as the first petitioner is concerned, there is an order of divorce.
But there was
As
a-
far as the second petitioner is concerned, my lord, she is the daughter. Now, there is no contest, my lord, as far as this proposition is concerned. Now, when the daughter is there and when she is seeking a relief, my lord, the paternal aunts cannot come and start obstructing
No,
it.
no, see, nominee has been made as a sister.
Yes.
Then she is a necessary
My lord,
party.
nominee is only, my lord, for the reason that she must
No, no,
be
the
able to
nominee
get the.
is for the benefit of that retirement.
No, the nominee is, my lord, if in case of the death, in whose favor the money could be paid is the only thing, my lord, for which the nominee
Now,
is
that
made.
is what happened. He has died in the service or
He has died during the course of the service.
then no, nominee is entitled.
Nominee, no, the question is now, my lord, the heirs are entitled to. Now, when the heirs make their claim, the nominee, my lord, cannot come and make a claim.
In the service rules, I think nominee is who has made as a nominee is an unnecessary. Yes.
No, it is for this reason, my lord, that I filed this petition.
Now, nothing will happen by impleading.
Now, what happens is, no,
Court
no.
is not granting that P&S certificate to that nominee unless after hearing that.
No, the reason is this,
See?
my lord, if at all there is a disputed fact that they raise, my lord, for the purpose of disputing it, then, my lord, this will have to be converted into an original suit and the trial will have to take place.
The prima facie, she has been made as a nominee in that.
My lord, the making of a nominee, my lord, will not change anything. That is the reason why, my lord, I have taken the proceedings.
Yes.
Now, if at all there is any independent share that they get it, my lord, it is for them to establish it by filing an appropriate suit. But in my proceedings, when myself, I have a daughter, am coming, and my lord seeking a succession certificate, my lord, the court, my lord,
Certificate for what?
concerning the death benefits, my lord, that is accrued to him.
Then
And there are certain properties also. Now, the trial court, my lord, will not even,
order of the trial court.
please, my lord, the trial court will not even appreciate these aspects.
Yes.
Page number 71, my lord, is where the reasoning part would begin with.
Yes.
My lord, page number 71, my lord, got it.
Yes.
My lord, paragraph number 10, my lord, the citation, my lord, is referred to regarding the impleading of the parties. Now, 11, 12, and 13, my lord, are dedicated for the purpose of answering the issue. 11, my lord, so in the light of the above ratio, if the present fact and situation are analyzed, herein, please.
Serial number.
My lord, page number 72, paragraph number 11, my lord.
Nice.
Please. So in the light of the above ratio, if the present fact and situation are analyzed, here in this case, on perusal of the records, they reveal that applicants being the sisters of the deceased K. Gopal and applicant number 2 also being the nominee, have approached the Honorable High Court of Karnataka in WP number 201 of 2023, seeking writ of mandamus for directing the Honorable Registrar General to release monetary benefits of deceased K. Gopal in favor of these applicants, and the said petition is still pending before the Honorable High Court. Records further reveal that late Shri Gopal had filed MC number 974 of 2006 before the learned third additional principal judge, family court, against petitioner number 1, seeking for dissolution of marriage under section so and so of the Hindu Marriage Act. And Honorable Family Court is pleased to allow this petition and dissolve his marriage with the first petitioner as per judgment dated 29/6/2009. So on considering these facts and situations and the rival claim between the applicants and the petitioners, I am of the opinion that the proposed applicants are necessary parties.
That now that what has happened to the writ petition?
It is
Writ
pending.
petition is still pending.
Then
No, my lord, I have produced the documents. My lord, I'm
no,
quite
now
see.
that we'll call this matter along with the writ petition.
Please.
Suppose if writ petition is allowed, then
My lord, there is no question of that being allowed because, my lord, I being here, my lord, I am seeking a claim over it.
before the court, you can't make any judgment saying
My lord, I'm making a respectful submission. I'm not, my lord, for a minute.
pursue
saying
the
that.
writ petition. You are the
No,
party.
he is the petitioner there.
You have not.
I
included.
have filed an impleading application in that petition and the matter is pending.
Then that has to be decided. If the court has decided that yes, she is entitled, then everything is ends there.
My lord, may call this with that petition, my lord, I'll just.
No, we'll call after that disposal of the.
No, please, no, the reason is matter is posted tomorrow and my lord, I need to amend the pleadings.
Yes.
My lord, that will be the difficulty.
Please
My lord,
this
my
matter-
kindly.
Please this matter along with that. WP 201 of 2023. Yes.
In the meantime, let there not be any, this is my suit ultimately, this my petition.
What you
Let
want?
there not be any precipitation in the matter because I need to
Any order?
amend, my lord, the pleadings tomorrow.
Amend
No.
it. You not go further that.
Now the next stage, my lord, is they'll start filing the written statement. Issues is how it goes. My lord, until then, my lord, let there be a stay of the proceedings.
Return statement akli, evidence akli. Nale tomorrow, if there are not necessary party, then you can proceed. If there are a necessary party, then all these times can be saved by that filing in a return statement and all.
Please, that's right.
That is what you can also. Yes.
Very well, madam,
Yes.
please. I request for a date, my lord. So that I expect.
No, that we don't know that.
The
that
roster, my lord, is absolutely
it is classified as what?
service rest.
Service.
Yes.
Here we go. Or we'll say, stay further proceeding the suit and it will be posted after that.
Please, my lord, please.
There may not be any order.
Or we have to club together.
Yes, my lord. My lord, my order for clubbing.
Yes,
may not
and
be any-
this matter along with that so and so.
Please.
Office is directed to take necessary order from Honorable Chief Justice and post this matter before the appropriate branch
Please.
next week.
Very well, please. But I'm seeking stay of my own petition. They might have not difficulty.
See, let it be before that. We don't know
Please.
which court it will come.
Please, ma'am, please.
Serial number 4, Narayana S for petitioner.
Yes.
My lord, without inquiry, the trial court passes an order
Hmm.
directing the police assistance. There is an interim order, no doubt.
Now suit for,
Suit for very injunction.
you are the defendant.
I am the defendant.
What is that?
The site, both are sites only.
Hmm.
There is no question of interference, what kind of interference he has done and all that, no inquiry.
Yes.
Straight away, the police help is sought and it is given.
No, that is there any interim order?
Yes, yes.
What is that injunction?
Restraining from interfering with his possession.
Hmm.
My site is open site. His site is also open site.
Hmm.
What kind of interference that I have done, he does not say.
No, have you challenged that order passed by that injunction order against you?
Yes, yes, it is there operating.
Then they have to protect that order.
No,
But
protect
you
it.
can't say no that.
My lord, there should be some inquiry whether I have interfered or not, because order 39 rule 2A contemplates
Hmm.
action, not under 151. They have not filed any such application that order 39 rule 2A stating that I have interfered and there is a violation of the interim order.
Hmm.
State they file an application to give police protection. My submission to my lord is, when I deny that interference, both are vacant site. What kind of interference should he say? And if he
No,
says,
in section, in rule 2A, that inquiry is required.
yes, yes.
Could he?
ಅಲ್ಲ ಇದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು 151 ಅಲ್ರಿ 3
ಅಲ್ಲ.
ನಲ್ಲೂ ಹಾಕಿಲ್ಲ.
Non-mentioning of that provision, it will not vitiate that.
No, I am not say for a moment saying that.
See, no, if that 2A, suppose, presumes that it is under 2A, it requires that after inquiry, find that there is a violation, then police protection has to be given. Then,
In a case of a decree,
Hmm.
order 21 governs that inquiry is a must. Even in a case of a decree of injunction.
no, what is that 2A says?
2A says
39.
disobedience of the
39.
order. May I take my lord's attention to consequence of disobedience of breach of injunction
Hmm.
is order 39 rule 2A. In the case of disobedience of any injunction granted or other order made under rule 1 or rule 2 or breach of any of the terms in which the injunction was granted or the order made, the court granting injunction or making the order or any court to which the suit or proceeding transferred may order property of the person guilty of such disobedience or breach to be attached, properties to be attached, and may also order such person to be detained.
That means
in
it
civil-
requires some inquiry.
Civil, yes, my lord.
Now that there is no such any,
Nothing of the kind. Straight away the,
where is that order?
please, my lord. My lord finds it. Annexure F, my lord. May I take my lord's kind attention to page, my lord, 42, my lord, which commences. The operative portion, my lord, finds it on page.
What is that order? No, they have passed, no, it is more than 8-9 page order. I think inquiry is, they find that you have submitted that now new survey number belongs so and so, defendant, he family members enjoying the same, though that land belongs to.
My lord, may I seek page 50, my lord, point number 1 for consideration.
Yes.
Absolutely, I may say with great respect, there is no such inquiry. And what they say is, a reported decision they refer to, the Honorable High Court of Karnataka in the above said ruling held, when the court has prima facie considered the matter and granted temporary injunction in favor of the plaintiff after hearing the defendant, the court has to enforce the same, and contention of the defendants that he is in possession cannot be accepted at this stage. If the court had no power to implement its own order, then there is no purpose in the court's passing order in matters coming before them. It is clear from the conduct of the defendant that the defendants are trying to violate the order of temporary injunction. What is the nature of interference? Nowhere they say. Having regard to the fact both are sites adjacent to each other.
No,
My lord,
police has been directed,
howದು? Police,
enforce the order ಅಂತಂದ್ರೆ not to interfere ಅಷ್ಟೇ. Why do you worry if you are not interfering?
my lord, why the police should interfere, my lord, in the matter?
No, police is not interfering your property. Police is protecting that property of the plaintiff where that injunction has been granted. If you are not interfering, don't worry that.
No, question is, my lord, what kind of interference they
No,
should?
you forget about that. See, if police are coming and threatening you, even though if you are interfering, it's different. Court said protect that order, seeing that a scheduled property has to be protected, nobody is interfere. If you are interfering tomorrow also, police can take an action. But if you are not interfering, it's
Yes.
well and good.
Well and good, and they will come and trouble me.
No, they will not trouble if you are in your position.
No, again,
If
I
you
have
are trying to interfere into the suit scheduled properties, then they will trouble.
ತಾವು ದಯವಿಟ್ಟು ಪೇಜ್ 16 ನೋಡ್ರಿ, ಶೆಡ್ಯೂಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಕ್ಕಪಕ್ಕದ ಸೈಟ್ ನೋಡ್ರು, ನಾವ್ ಏನ್ ಇಂಟರ್ಫಿಯರ್ ಮಾಡ್ತೀವಿ?
ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ ಇಲ್ಲ, ಮಾಡಬಹುದು.
ಅಲ್ಲಿ
ನೀವು ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಅಂದ್ರೆ it's well and good. See,
ಮಾಡಬಹುದು ಅಂತಂದ್ರೆ ನಾನೇನಾದ್ರು ಅದರಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಬೇಕು ಅಥವಾ ಇನ್ನೇನು ಡಿಗ್ ಮಾಡಬೇಕು, ಸಮಥಿಂಗ್ ಲೈಕ್ ದಟ್. ದೇರ್ ಇಸ್ ನೋ ಕಂಪ್ಲೇಂಟ್ ಲೈಕ್ ದಟ್.
no, see, in your property, if you do whatever you want, but suit scheduled property, if you are trying to interfere, protect, that's all.
ಅಲ್ರಿ,
It is not that.
ಅಲ್ಲಲ್ಲ, ಇಂಟರ್ಫಿಯರ್ ಅಂತಂದ್ರೆ he must explain what kind of interference I am making. If it is a house, that and this trespass, this is all that, my lord. Mine is also vacant site.
You file an affidavit before this court saying that you are not interfering into the suit scheduled property, you are not doing any attempt to interfere, then I will consider.
ಸ್ವಲ್ಪ ನೋಡಿ, page 16
So
ಅಲ್ಲಿ.
if you file an affidavit, tomorrow it will be content of this court if you do it, then we can protect. You file an affidavit saying that we are not interfering into the suit. See, otherwise, what is the sanctity of the court order?
I am,
The sanctity, if there is no interference, I don't think somebody will simply
My lord.
file
I only say, it should be explained.
no, you file an affidavit before this court saying that we are not interfering into the suit scheduled property, we are not making any attempt. Then I will take it and grant it.
I could say
Then
all,
something is happen, I can appoint a commissioner, find out and this.
even today, my lord may appoint a commissioner to find
No,
out.
no, no,
what
we are
kind
not
of-
doing that. You file affidavit is enough. After that, we'll
Huh?
see. If parties are
Okay,
not
ಈಗ-
violating that order.
No, of course, apart from that, the vendor of the plaintiff himself has filed a suit for declaration and it is pending.
No, that is
They
different.
themselves may
Yes.
fight each
No.
other.
We are not on that. We want to see that protect the order of the court. Because order injunction granted, you have filed an appeal is also confirmed. I read now.
Yes, that's what I
Yes,
submitted. my lord.
now, if you are not protected, what is the use in granting any order, Mr.?
I may say,
And on the other hand also will protect you. Suppose if you are not violating or not interfering into the suit scheduled property, give an affidavit before me, I will grant an order, stay that police.
ಕೊಡ್ತೇನೆ ಅದೆಲ್ಲ ಕೊಡ್ತೇನೆ ಅದ್ರ ಬಗ್ಗೆ ಏನ್ ತೊಂದರೆ ಇಲ್ಲ
230, you file an affidavit of party 230, I will stay that.
ಅಲ್ಲ 230 ನಾನು of course I can't get my client.
Hmm.
Kindly see page 16.
No, I read that. That is the only.
Open
now-
sites. ಓಪನ್ ಸೈಟ್ ನಲ್ಲಿ ಏನ್ ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಮಾಡ್ತಾರೆ ಅಂತ ನಮಗಂತೂ ಅರ್ಥವಾಗಲ್ಲ.
ನೀವು ಮಾಡೋದಿಲ್ಲ ಅಂದ್ರೆ ಕೊಟ್ಬಿಡಿ.
ಅಲ್ಲ ಮಾಡಲ್ಲ ಅಂತ ನಾನು ಕೊಡ್ತೇನೆ. ಬಟ್ ನಾನು ಹೇಳೋದು he is not there at all.
You don't know what is happening there. Still will accept your submission, but I want that affidavit of the parties. See, I can accept that submission of that Sadashivappa, not that parties, because they should have to file an affidavit before this court. We don't know what is it in Bangalore?
ಹೌದು.
Then
ಇಲ್ಲೇ
Bangalore, anything can
ಬೆಂಗಳೂರು
happen. Yes.
ಬೆಂಗಳೂರಲ್ಲಿ ಅಲ್ಲ ಪೇಜ್ 16 ನೋಡಿ.
The thing is that if they give an affidavit, tomorrow they have done it anything, I can initiate that contempt.
My lord, in the guise of
Tomorrow, when do you want file it?
ಅಲ್ಲ in the guise of police cell, they should not interfere with my site which is adjacent to it. That's the problem.
You file in a suit, you have an
ಅಲ್ಲ
right.
again another litigation.
ಮಾಡ್ಲೇಬೇಕು ಮತ್ತೆ ಈ ಅವ್ರ ಕೇಸಲ್ಲಿ ನಿಮ್ ಪ್ರಾಪರ್ಟಿನ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ ಅದು ಸೈಟ್ 16 ನೋಡ್ರಿ ತಾವು ಶೆಡ್ಯೂಲ್ ತಾವು ದಯವಿಟ್ಟು ನೋಡ್ರಿ.
No, you given your party, if you are so confident that your party is not interfering, give an affidavit, I will, even if they are appear also, they can't do anything if they are given an affidavit.
ಅಲ್ಲ 16 ಅಲ್ಲಿ ತಾವು ದಯವಿಟ್ಟು ನೋಡ್ರಿ.
Yes.
ಈಸ್ಟ್ ಸೈಟ್ ನಂಬರ್ 8 ರೀ. ವೆಸ್ಟ್ ನಂದೆ ಡಿಫೆಂಡ್ ನಂಬರ್ 1's ಪ್ರಾಪರ್ಟಿ.
Yes.
Both are vacant sites. Nobody has done anything.
No, that's.
It is all a revenge. Personal grievances they are ventilating. Through police they want to ventilate.
No, you give that affidavit, I will ask the police not to give effect to this order.
Okay. Will
Yes.
sir.
When do you want?
3 days, my lord.
Yes, leave this matter on Wednesday,
Next week. 3 days.
next Wednesday, yes.
Huh?
Yes.
Cell number 5,
You got it.
Jayalakshmama.
Or you want to, in the meantime, take an hand summons to that party also, other side.
ಇಲ್ಲ ರೀ ಅವೆಲ್ಲ ಡಿಫಿಕಲ್ಟ್ ಇನ್ ಬೆಂಗಳೂರು.
Yes.
ಒಟ್ಟಾಗ ತೊಗೊಳಕ್ ಹೋದಾಗ ರೆಫ್ಯೂಸ್ ಮಾಡ್ತಾರೆ. ನಮ್ಮ ಅಫಿಡವಿಟ್ ಹಾಕ್ಬೇಕು ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರು ಅಂತ.
So now that, that will give that some helpful to you.
Yes.
We can ask them also that what is that interference and also
Yes.
the document. If you
Well,
want,
From the pleadings, absolutely no interference.
no, if you want, if they are appear, I can get that information also. If they are not appear, to protect that order, I need that affidavit. Which one you better you, this thing.
Please.
If you want to take hand summons, I will give it.
ಇಲ್ಲ better now.
Yes. You file an
Well-
affidavit, yes,
Serial number 5, Jayalakshmama KB.
yes.
Speedy disposal, my lord. The petition number 1 and 2 are the aged about 72 and 62 years, my lord.
What is the suit for?
Suit for partition and separate portion filed by the plaintiff. The respondent, the defendant number 1 to 5 have denied the relationship of plaintiff with the deceased Ravi, my lord. They denied that she is not the wife of the deceased Ravi, my lord.
There is the plain,
Plaintiff, my lord. Annexure B, my lord, page number 44, my lord.
the plaintiff or a defendant.
I am the impleading applicant. I am the purchaser of the land, my lord, in the year 2019, my lord.
You are,
After purchase, my lord, she has filed the suit for partition and separate portion. my
you
lord.
are defendant number.
6 and 7, I am impleaded ourselves, my lord.
What is the stage in that?
Stays, my lord, one or the other reason by filing application. they are postponing the same, my lord. Now till now the issues are framed and plaintiff evidence has to be started.
Yes.
Start, my lord.
This petition is filed by defendant number 6 and 7, seeking direction to dispose of the OS number 118 of 2019, the file of which court, madam?
Principal Civil Judge Junior Division JMFC Gauri Bidunur, my lord. Gauri Bidun Chief.
Civil Judge and JMFC Gauri Bidunur.
Please.
Respondent plaintiff has filed in a suit for partition and separate position. Petitioner defendants are purchaser of the property. They have been impleaded subsequent to filing the suit. Now they are defendant number 6 and 7 in the original suit. Since suit of years 2019 till it is in the evidence stage.
Yes.
Therefore, the petitioner approached this court for early disposal of the suit. Since suit is of the year 2019, without expressing any opinion of 2019, it is already 5 years over. Without expressing any opinion on the merit of the case, the trial court is directed to dispose of the suit as expeditiously as possible, not later than 1 year from date of receipt of copy of this order. With that observation, the writ petition is disposed.
God bless me.
Serial number 6, Umesh MN.
Petitioner,
Yes.
please. Amendment, amendment application filed by the defendant has been rejected by the trial court on the ground that it is filed after at a belated stage. Though the stage is still at the stage of cross-examination of PW1.
You are a
I am the defendant. Defendant number
suit
2.
for
Suit is for specific performance of contract.
specific performance of contract.
Yes, please. So first defendant is the is my vendor, and the plaintiff claims that he has entered into an agreement with the plaintiff, first defendant, and the first defendant has sold the property way back in the year 2014. And
So what is that amendment you want?
Amendment, may I request your lordship to kindly turn to ink page number 33, Miller. 2 paragraphs I wanted to add. The defendant number 2 submit that he is a bona fide purchaser of the suitable property from defendant number 1 for valuable consideration without the knowledge of alleged agreement to sell said to have been executed in favor of plaintiff by the defendant number 1. As such, plaintiff is not entitled for the relief of specific performance. Without prejudice to the above contention, defendant number 2 submit that the plaintiff and defendant number 1 are known to each other and they had some monetary transaction between them. Taking undue advantage of the same, plaintiff and defendant got created the alleged amendment agreement, antedated agreement of sale in favor of the plaintiff much subsequent to execution of the sale deed. These paragraph I wanted to include. And that is rejected on the ground that
Defendant number 1 submits that plaintiff and defendant number 1 were each other. Some plaintiff defendant got created the alleged agreement. Now, what is the stage?
cross-examine further evidence of plaintiff.
Plaintiff.
Oh.
What is the defense in that written statement? First you have filed in a written statement.
ಇದರಲ್ಲಿ ಬೋನಫೈಡೆ ಪರ್ಚೇಸರ್ ಅನ್ನೋದ್ರ ವಿಷಯ ಒಂದ್ ಮಾತ್ರ ಹೇಳಿದ್ದೆ. ಇವರಿಬ್ಬರ ಮಧ್ಯೆ ಮಾನಿಟರಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿತ್ತು ಅನ್ನೋ ವಿಷಯ ನಾನು ಹೇಳಿರಲಿಲ್ಲ. This is what I wanted to state in my additional.
Why that trial court rejected?
May I request your lordship to kindly turn to ink page number 15, Mela. Ink page about 5 lines. It was created by making use of the old stamp paper with an intention to gain illegally. Defendant number 2 has filed written statement on 10/4/2017
The application is filed in 2024. There is inordinate delay in, to file the present application. This is the reason.
No, 2017 you have filed a written statement. What are you doing for that 8
ಅಲ್ಲ, ನನಗೆ ಈ
years?
ವಿಷಯ ಗೊತ್ತಿರಲಿಲ್ಲ. ಅವರಿಬ್ಬರ ಮಧ್ಯೆ ಮಾನಿಟರಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಇತ್ತು, ಅದರಿಂದ ಇದನ್ನ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋ ವಿಷಯ ನಂಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ.
When did you come to know that?
Recently, I have come to know about it.
Where you have stated that?
In the affidavit, I have stated.
Where is that?
ಅದರಲ್ಲಿ page number 35 ಮೇಲೆ. I have filed my written statement and contested. However, due to my inadvertence, some of the facts which are necessary for decision of the controversy involved in the suit has not been stated in my written statement. Besides this, some of the valid defense available to me to defend this suit were also left out by oversight in my written statement. As such, I am filing this application.
ಯಾವಾಗ ಬಂತು ನಿಮ್ knowledge ಗೆ ಅಂತ ಹೇಳಿಲ್ಲಲ್ಲ ನೀವು.
Specific ಆಗಿ ಹೇಳಿಲ್ಲ.
Then if you have any knowledge,
still,
then you are keep
Your
quiet.
Lordship,
That
I
is
kindly,
delay.
Your Lordship, I kindly appreciate it. Is still at the stage of further evidence of the plaintiff.
It will cause delay one by one. Yes. Or issue notice. Take hand summons, Mr.
Please, I shall take over.
In addition, petitioner is permitted to take out hand summons. Who is the plaintiff?
Plaintiff is the
Plaintiff Estner Ray idರಲ್ಲಿ
Amit Sangi, first respondent.
permitted to take out hand summons to that respondent number 1. You dispense that others. Why?
Please, ma'am, please.
Issue filed in a memo seeking dispensation notice to 2 to 4. 4 and government ಏನದು secretary ಅದು ಮಾಡಿದ್ರು.
Panchayat.
Yes. 2 to 4. Issue emergent notice to respondent number 1. In addition, petitioner is permitted to take out hand summons. Yes.
In the meantime, further proceedings.
What will happen? Let
ಇಲ್ಲ,
the
ಅದು
evidence to be complete.
ಇಲ್ಲ, ಅವರು ನಮ್ಮ ಎವಿಡೆನ್ಸ್ ಪ್ರೆಸ್ ಮಾಡ್ತಾರೆ ಇದು without this amendment. I mean,
Yes. Stay of further proceedings in OS number 454 of 2013 pending in the file of
civil judge, senior civil judge Devanalli.
senior civil judge JMFC till next date of it.
Please.
Serial number 7, Ajit N.
Lord, kindly pass out the case now. Senior will come convince the.
Yes, pass over.
Serial number 8, Abhishek
Petitioner
NV.
in this matter, ma'am. But this matter may kindly be taken up with another connected writ petition. This writ petition is arising out of a common order passed
All
in
this matter along with that so and so next week. Yes. Number ಕೊಡಿ.
Serial number 9, Nanjunda Swami N.
Petitioner. This matter, my lord. The petitioners, my lord, filed a suit for a declaration and my lord, and also other declaration for the sale deeds executed by the defendant number 1 to something and in favor of other defendants in respect of suitable property, my lord, which is pending. My lord, what happened, my lord? The respondents herein, during the pendency of the case, my lord, they filed an application under IA number 24 for impleading them as a additional defendant. My lord, they claims that their father executed a sale deed in favor of the petitioner in the year 1996. In the year 1996. Kindly, what happened, my lord? Suit earlier, survey number 64. And my lord, now, so survey number renumber as 282, measuring totally 3 acre 38 guntas, my lord. Adana, it was purchased in the year 1971 by the father of the respondents, one GH Bangera. Lord, during his lifetime, Lord, he sold 1 acre 11 guntas, Lord, in favor of the petitioner, and another 1 acre 7 guntas, Lord, to one Srinivas K. Another remaining extent, Lord, to one HL Dharani Gowda. Both all the sale deeds, Lord, in the year 1996. He died, Lord, subsequently after 2 years. Lord, till then, Lord, they did not file any suit, Lord, or anything against the either any parties, Lord. Now, Lord, what happened? After that, Lord, they filed a suit in OS number 3844/2010, which is annexure F, Lord, page number 117.
Yes.
117, Lord. Kindly peruse 117. The respondent have filed a suit for partition under separate position in respect of one K Srinivas, ಅದೇ ಇನ್ನೊಂದು ಪೋರ್ಷನ್ ಸೇಲ್ ಮಾಡಿದಾರಲ್ಲ ಅವ್ರ ತಂದೆ, ಆ ಪೋರ್ಷನ್ ಮಾತ್ರ ಪಾರ್ಟಿಷನ್ ಮತ್ತೆ ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ ಹಾಕೋತಾರೆ. ಆಫ್ಟರ್ ಕಂಟೆಸ್ಟ್ ದಟ್ ಸೂಟ್ ಕೇಮ್ ಟು ಬಿ ಡಿಸ್ಮಿಸ್ಡ್. As per an extra
ನಿಮ್ ಕೇಸಲ್ಲಿ ಏನಾಗಿದೆ?
ನಮ್ಮ ಕೇಸಲ್ಲಿ ಏನಾಗಿದೆ, ಅವ್ರನ್ನ ಇಂಪ್ಲೀಡ್ ಪಾರ್ಟಿನ ಇಂಪ್ಲೀಡ್ ಮಾಡಿದ್ದಾರೆ.
What will be happen if they are impleaded?
ಅಲ್ಲ ಕೈಲಿ ಮೈ ಒಂದು ಮತ್ತೆ ಅನದರ್ ಸೂಟ್ they themselves have filed another suit. The respondent have another suit.
Take notice. Yes.
ಅಲ್ಲ ಅದರಲ್ಲಿ ನಾನು ಆರ್ಡರ್ನ ಸ್ಟೇ ಕೇಳಿದ್ದೀನಿ ಅಷ್ಟೇ. ಆರ್ಡರ್ನ ಕೇಳಿದ್ದೀನಿ, ಸ್ಟೇ ಕೇಳಿದೆ.
ಸೂಟ್ ಸ್ಟೇ ಮಾಡಬಹುದು, ಆರ್ಡರ್ ಸ್ಟೇ ಮಾಡಕ್. ಯಾಕೆ ಅಂತ ಅಂದ್ರೆ tomorrow suit is decreed, your petition is dismissed, they will be impleaded. Where they will go?
ಅಲ್ಲ ಆಗಲ್ಲ, ಅದು ಕೈಂಡ್ಲಿ ಮಿಲಾಡ್, ಅದು ಅವರು ಇಂಪ್ಲೀಡ್ ಆಗೋದು ಬೇಡ ಅಂತ ನನ್ನ ಇದು.
ಬೇಡ ಅಂತ ನೀವು ಹೇಳಿದ ತಕ್ಷಣ ಫೈನಲ್ ಅಲ್ಲ.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಮಿಲಾಡ್, ಅಲ್ಲ ನಾನು ಯಾಕೆ ರೀಸನ್ ಹೇಳ್ತೀನಿ.
ನೀವು ಕೇಳಬೇಕಾದ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರು ನೀವು ಹೇಳ್ತೀರಾ,
ನನ್ ಸೂಟೆ ಅದು, ನನ್ ಸೂಟೆ.
ಅದಕ್ಕೆ ಸ್ಟೇ ಬೇಕಾ ನೋಟಿಸ್ ಬೇಕಾ?
ಅಲ್ಲ ಸ್ಟೇಗಲ್ಲಿ ಇದ್ರಲ್ಲಿ
ಆರ್ಡರ್ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ನಾಳೆ ಸೂಟ್ ಡಿಸ್ಪೋಸ್ ಆದ್ರೆ
ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ ಮಿಲಾಡ್.
ನೋ,
ಡೇಟ್ ಮೇ ಬಿ
ಆಪ್ಷನ್ಸ್. ಯು ವಾಂಟ್ ಟು ಸ್ಟೇ ಯುವರ್ ಸೂಟ್ ಆರ್ ಯು ವಾಂಟ್ ಟೇಕ್ ನೋಟಿಸ್?
ನೋಟಿಸ್ ತಗೊಳ್ತೀನಿ, ಅದು ಡಿಫರೆಂಟ್ ಕೈಂಡ್ ಮಿಲಾಡ್. ದಿಸ್ ದ ರೀಸನ್, ದಿಸ್ ದ one thing that
no, Mr.
they have to file another.
I need not explain, but I am explaining each advocate. Tomorrow writ petition is dismissed, where they will implead after your suit is disposed of. This is because of High Court granted an interim order.
ಅದಕ್ಕೆ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ.
No, there is no priority for your case. If you want that, I will stay your suit, or you want to take notice.
ನನ್ನ ಸೂಟಲ್ಲಿ ಸ್ಟೇ ಮಾಡ್ಕೊಂಡ್ರೆ ಪ್ರಯೋಜನ ಆಗಲ್ಲ.
You take notice.
ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ ಮಾಡಿದೆ.
Yes, issue emergent notice.
And also permitted to.
Yes, in addition,
trial court advocate.
Take hand summons.
Hand summons to the advocate.
Advocates ಗೆಲ್ರಿ ಬರ್ತದೆ hand summons. ಎಲ್ಲ ಐತ್ರಿ.
ಅಲ್ಲ ಅದರಲ್ಲಿ
you can serve a copy, not hand summons to that advocate.
ಅಲ್ಲ sorry, serve permitted to serve the copy to the.
Why you are asking?
ಅಲ್ಲ permitted to serve the copy on the advocate.
But one thing, it is not in a service. Tomorrow if he not come again, their problem. Therefore,
but ನಾನು PF ಕಟ್ಟೋದು ಕಟ್ತೀನಿ. Apart from that, I will.
Yes, who is that impleading applicants?
Impleading applicant are the respondents, all the respondents. All the respondents.
Yes. Issue emergent notice. In addition, petitioner is permitted to serve a copy on the counsel appearing for the respondent before the trial court.
Date may fix.
Serve ಮಾಡಿ move ಮಾಡಿ. Yes.
Serial number 10, KV Narasimha.
Yes.
The plaintiff, my lord, is in petition.
Yes.
In a suit for declaration of title and permanent injunction.
Yes.
During the pendency of the suit, my lord, there were the other the proposed respondents. My lord started to interfere with his position.
Yes.
Since, my lord, concerning the very same property, the other adjacent landowners, my lord, started to interfere. An impleading application, my lord, was filed. On the impleading application, my lord, the notice was directed by the trial court. The persons, my lord, whom I sought to be impleaded, they only took up a contention that if at all there is any case of an interference, you have to file a separate suit. Now, they did not say that I will not interfere with your position.
No, that your suit for
declaration of title and permanent injunction. Comprehensive suit is filed.
You have filed
against the three persons, my lord, who were initially named as defendants.
Subsequently, you want to implead them also.
Implead some other persons, my lord, who are also interfering.
Yes.
Now, they did not, my lord, deny that they will not interfere and they are no way connected with my case.
You will take notice.
Please, my lord.
Yes, issue emergent notice.
Serial number 11, V. Vishwanatha Shetty.
Petitioner is a plaintiff before trial court, my lord. He filed application for recall the discard order of PW2, my lord. He was examined, PW2 was examined on 5/3/2021, my lord. Thereafterward, my lord, the two occasions they were cross-examined the PW2, my lord. On 21/6/2023, they took time, my lord. Thereafter, my lord, matter was posted on 22/8/2023, my lord. That day, the trial court has discarded the evidence of the PW2, my lord. Because he was of age old, my lord, that day he couldn't appear because of that.
It is clear that many occasions PW2 was not present and present applicant filed without seeking PW2 present before this court. As already evidence of PW is discarded, he is not present before this court. Application is maintainable, hence it is rejected. Application for recalling that.
Yes, my PW2.
Your evidence.
Yes, my lord.
Your suit.
Yes, my lord.
You don't want to complete your suit?
No, my lord, we have to complete, my lord. That's because, my lord, he is my vendor, my lord. I have to examine him, my lord. For 3 occasions, we have examined that PW2, my lord. On 22/8/2023, he has not appeared due to his ill health, my lord. That day, trial court has discarded his entire evidence, my lord. Now, we filed application for recall that order, my lord. The trial court says that his earlier occasion, he has not appeared for some occasion. So, yes,
Where is that the order for recalling is dismissed?
that page 40, my lord.
40.
Yes, my lord. Ink page. Counsel for a plaintiff filed application under 151 of CPC considering the evidence of PW2. PW2 is absent. On perusal of order sheet, it clearly shows that on many occasions PW2 was not present and present application filed without keeping the PW2 present, my lord.
You could have present on that day itself.
Without same day 21/8/9 we filed application, my lord. That day same day without any further, my lord, he has dismissed our application. That is on 2022, my lord.
Please stay of further proceedings in OS number 8790 of 2019 pending in the file of 43rd Additional City Civil and Sessions at Bangalore till next date of hearing.
Much obliged, my lord.
Serial number 12, Maya Circle Board for petitioner V. Shivakumar.
Yes.
I'm aggrieved, my lord, by the order
Hmm.
passed, my lord, in the MA petition that was filed challenging the IA number 2 order. It's a suit for injunction. I am the plaintiff.
Yes.
Ex parte injunction was granted.
Hmm.
Thereafter, my lords, they filed IA number 2 for vacating the interim order.
I'm appearing for the respondent. I may be permitted to file the wakalat, my lord. Excavator was there.
Yes.
My lord, I have a very limited request
Interim
from this.
prayer. There's no interim prayer. Matter has to be disposed of.
I have a very limited request to the court.
Instructions and make submissions next
Yes,
week.
let us see what is that.
My lord, what has happened is IA number 1 was mine under 39(1) and 2 for an injunction. Ex parte was granted. They filed, my lord, IA number 2 under 39 Rule 4. It's a different matter, my lord, that earlier 2 rounds of litigation has come to the court. Matter has been remanded.
What has happened to that application?
Now, what has happened, my lord, is that the civil court, civil judge allows my IA number 1, dismisses IA number 2. That is challenged by filing an MA before the sessions judge. They are numbered as MA number 34 and MA number 35. MA number 34 is as against the dismissal of IA number 2 for vacating the interim order. The other MA is insofar as IA number 1 is concerned. Now, what has happened is only one of those MAs has been disposed of. That is the IA number 2. The court says that the dismissal of the IA number 2 was wrong. I set aside that order. Now, what happens is their challenge to IA number 1 is still pending before the court. Essentially, IA number 1 and 2 has to be heard simultaneously.
IA number 1 is granting an injunction.
Yes.
IA number 4 is vacating.
IA number 2 is for vacating the interim.
IA number 2 is vacating. Vacating thing is dismissed.
Correct.
Now that that has been allowed. That means to say they have to rehear that application for vacating.
The order doesn't speak anything of that sort. If my lord looks at the impugned order, it is at page.
How, Mr. They can do it?
My lords, all those arguments are only academic for this reason, my lords. Kindly see page 152.
No, now nothing is there. He is also not sought for any
interim prayer.
Now that trial court, which is granted in his favor, that appeal is pending.
Yes.
That you have filed an appeal. Your appeal is pending. Rejection that your application number 2 has been rejected.
Yes.
1 is allowed.
Yes.
You have filed a 2 appeal. Should
Yes.
not be clubbed together and pass an order.
That's right. That is what is the usual course will happen. That
No,
what
by
will happen in
allowing
the
your
usual
appeal,
course. I
by allowing
understand.
your appeal, you will also not get any relief. Because injunction order still is in force.
That's true, my lords. That's why this honorable court said, knowing fully well that 34 and 35 2 appeals are pending, direction is issued by the court to consider only 35.
There is no harm to you because your injunction order is still there. No order has been passed. I will permit it to withdraw with liberty. If that order goes against you, you can challenge both.
Could I only ask this much, my lord?
No, my lords could say that this order will not be influencing the decision to be taken in MA 35.
No, suppose MA 35.
My lords.
That your appeal is allowed.
Could I only suggest this?
Then order for vacating is not challenged. Then he will be. Therefore, I will give the liberty.
My lord,
Please.
could I ask only this? This petition could be disposed of by my lord remanding this matter and asking the court to consider both the IA simultaneously. It's coming up on the 30th of January, my lord, the IA.
It's a fair.
They have argued. So let both be heard and disposed of together is my only
the
request.
direction
I don't know why. They could have been passed single order by clubbing together. They could have allowed both the appeal and injunction granted is not proper, something they could have done it.
30th January it is coming up before the MA court.
On that day
ಎರಡನ್ನೂ
itself,
ಒಟ್ಟಿಗೆ ಯಾವತ್ತೇ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೋದು ಅಂತ.
Both.
No, again, it makes no sense.
No, that is the correct proper procedure.
Direction by this honorable court, knowing fully well that there are two appeals pending, is to consider only 35. Actually, this appeal becomes only academic, my lords.
No, academical law. See,
It's ambiguous.
tomorrow, after 2
Because
years,
this honorable court has already modified the interim order, passed under IA number 1.
IA number 1, what is that modification?
Just kindly see page number 153, my lords.
In the second round of
153.
writ petition, my lord, to
Wait,
some extent there was a modification.
150?
153.
Now, what is that modification?
Till any decision is taken by the first appellate court in MA number 35 of 24 or on any IA filed before it for vacating, varying its order, the respondent is hereby restrained from putting up any additional external construction on its premises. However, the respondent will be at liberty to make any internal modifications in respect of the construction already put up.
No,
However, if
this
the same is found to be not in accordance with law
is
subsequent,
filed against what?
Against an,
filed against
earlier.
temporary injunction being granted.
on
No,
the same IA, my lord, earlier
Not
the
to
matter
put up
got remanded.
construction.
no, but why that this writ petition has been filed when that application is pending?
Plus, they filed a writ petition even before exhausting the remedy of appeal.
Directly they are.
Directly, they have come before this honorable court challenging the entertainment of the appeal.
No, my lord, that was,
Appeal is directed, the first appellate court is directed to dispose of the MA as expeditiously as possible. Petitioner is give liberty to necessary to application
my lord, I'll,
to modify, vacate that interim order. Now, why that you have not brought to the notice of this court that another appeal is also pending?
Both are there within their knowledge, my lords.
No, only direction is to dispose of one appeal.
my lord, why I filed that writ petition, my lord, is because the common order was passed on 24th of April. Even without, my lord, the certified copy on 25th of April, the order was stayed. Challenging that, I came before the High Court in that order which my learned friend just read out. By saying that not even looking at the order, I am on caveat, I have not even been served. In these circumstances, why, how could it have been filed?
First appellate court to modify or vacate that interim order by it. First appellate court to decide MA or pass an interim order as deem it fit. Materials placed before it without influencing any observation made by this court. Till the decision is taken by the first appellate court before it for any order, the respondent hereby restrained from putting up an additional external. No, this is only disposal of MA 35.
Yes, my lord.
Now this has gone now by disposing of this.
MA 35 is pending today.
MA 35 is pending.
Yes, my
What is before this court is 34.
Disposed of then.
Now 34 is
disposed
disposed.
of.
34 this disposed.
Yes.
Where there is an order of the court, they have not disposed of.
No, the reasoning given in this is the construction is, High Court is permitted the internal work to be carried on. Therefore, no necessity to go on with this matter. Or 35 will be considered on merits. Must kindly see the operative portion of the order, my lords.
The ambiguity could, my lord, be avoided if
Eh,
both are heard.
Now, what is the purpose in considering only a vacating application?
They're like twins, they have to go together.
If that court, this court is there already directed, then how we will get any benefit by getting that order?
Perhaps I feel, my lords, for the purpose of statistics, this appeal is disposed of.
We'll say that club together and pass an order on this thing. Till that anyhow, that order passed by this court will be continued.
Yes, my lord.
Oh, kindly see the page 43, my lords.
Yes.
Appeal is allowed, my lords. The order dated so and so is set aside. Kindly see the third paragraph. Anyhow, this order will not affect orders passed by the trial court on IA number 2, which filed under order 39 rule 1 and 2 of CPC, because ex parte injunction was already confirmed by trial court by allowing IA number 1.
No, this order will not affect the order passed by the trial court on IA number 2, which filed under 39 because the ex parte injunction was already confirmed by the, and that only you have challenged that.
Is also pending.
So what the honorable trial, the first appellate court is saying, first appeal is pending in respect of the order granting temporary injunction. Even if this appeal is disposed of, that order stays, he will not be affected.
No, see, order is passed under the temporary IA filed for an 39-1.
Placement.
Temporary injunction has been
Granted.
filed in a vacating.
Placement.
Vacating is dismissed.
Yes, ma'am.
Should it not be said that it is confirmed?
No, my lords, what happened was, this application was filed against the ex parte interim order. Court said ex parte interim order is confirmed.
That
by
means-
dismissing my application.
Ah,
I challenged both the orders before the first appellate court. This honorable court said, let the appeal be disposed of on merits and made an interim arrangement. Now, ideally speaking, both the appeals should have been considered together.
That's
Now,
what-
my lords, what that first appellate court has done is that now that the benefit of the temporary injunction order is already there, no useful purpose is served in
No,
keeping
in
this
fact,
application
this order
pending.
is affect you also, because nothing but dismissing your other appeal, MA 35 of 2024.
No,
No,
They said, since it is already confirmed, therefore there is no necessity of considering IA1. See, trial court on IA number 2, which filed under order 39-1 and 2. IA number 2 is for 39-1 and 2. Your vacating is IA number 3, na?
no, my lord. I number 1 is 39-1 and 2.
But till 2 anta hakidare.
I number 2 is 39 rule 4.
Everything is messed, mister. If they said IA number 2, we see that order portion.
no, let's kindly see page 43, my lords. Top portion.
Party injunction was already confirmed by that trial court by allowing that IA number 1.
Yes,
ಅದನ್ನೇ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದಿರ ನೀವು.
ಮಾಡಿದೀವಿ.
But should they not hear that?
That is being heard. 30th is the date given.
Hmm.
ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ. ಇದನ್ನ ಅಲೋ ಮಾಡೋದು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ ಇವ್ರಿಗೇನು ತೊಂದರೆ ಆಗಲ್ಲ ಅಂತ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಿದ್ದಾರೆ. Kindly see the reasoning, my lords, page 43.
Then we will keep that, let us see what is that order passed in that.
Yes, ma'am.
In which
But this matter could be adjourned after 30th, ma'am.
30th, what that order will be passed.
30th, my lord, it is kept for further hearing, my lord. I think they have concluded their arguments on the last date of hearing. 30th, it's kept for my arguments. It may take more time, my lord, for my problem also is this.
No.
Because what
even-
the court
no,
has
Mr.
done.
Counsel, even let him take that 1 year. The order passed by the trial court still is in your favor.
Yes.
My lord, what has also happened?
Happened to you.
Now, what has also happened in this order is that a lot of reasons are given. A lot of reasons are
That
given.
can avoid, you have to file another appeal. After that order passed, you challenge, suppose if it is against you, you challenge it, that appeal will be clubbed with this appeal and
My lord, two things, my lord. One, what has happened is while passing this order, if this, by this discussion, if it appears that this was only a matter of statistics or that, this, it doesn't have any bearing on anyone. My lord, there are a lot of reasons given here. The court, I did not want to enter into merits, but maybe it becomes necessary. Court goes on to say that they have spent 4 crores of rupees. Therefore, even if there's illegal construction going on, let it go on. Let them then seek equities.
all
and so
that
on.
matter
Now,
will.
I don't want that to come in the way of hearing at IA number 1 again. Because in the
That
IA
will
number
make
1,
clear
there's a,
without influencing the observation made in this order, let them.
or my lord, if both could be heard together.
No,
my
what is
lord,
that? See, now.
Well, the
what is-
ambiguity that gets created, because like my lord rightly observed, here they do not also say that IA number is confirmed, because if my lord sees the one paragraph before that on paragraph page 43, they say by allowing this miscellaneous appeal, court cannot set aside the order passed on IA number 1. Appellant can redress his grievances in miscellaneous appeal which filed
See,
against order passed on IA number 1.
What he said, only for the statistics purpose, they have disposed of. It is an
Which
easy
is
to
creating
dispose.
ambiguity.
No,
Therefore,
it will not create any ambiguity. They said that whatever order I am going to pass on IA number 1, nothing to do with this case. Therefore, I am going to pass instead of keep pending. That is the what I think rightly guessed by him that nobody is. Therefore, we don't want that any statistics purpose. Instead of you want to file another appeal after disposal, we'll keep this pending. Let them decide on that.
or my lord, this could also be disposed of. One, with my primary request that it be clubbed. If it is not being clubbed, my lord, then at least to say that the observations made in this order should not come in the way of disposing of that IA number 1 is the least that I would.
That I will
request.
dispose with that
If it is clubbed, my lord, nothing like that, because all ambiguity gets avoided.
unnecessary then. Again,
My
unnecessary.
lord, because 39-1 and 2 and 39-4, my lord, have to go hand in hand. It can't be that I will decide one separately and the other one
No,
separately.
see, suppose now this has been disposed of. IFR vacating is allowed. So IFR vacating which has been, what is that?
Essentially,
number?
vacating should be allowed, my lord.
Appeal is filed against the order granting temporary injunction.
My lord, what happens is IA number 2 is dismissed.
This is IA number
2.
IA number 2 filed by that order passed on that IA number 2 passed in this
Is
set
set
aside.
aside.
That vacating is set aside.
Consequently means IA 2 is allowed, which means vacating of the interim order. They
Now
don't say that in so
that,
many words, but that is what it would mean. Interim order IA 2.
IA order passed under IA number 1 is there. Suppose court said that order passed under that IA number 1 is correct. Then again, your application for vacating has to be considered by the trial court.
No.
Why? That that has been allowed now. IA has been kept pending. See,
No,
there is
IA
an
is
application
disposed
for
of, ma'am.
vacating. there is an application for vacating, it is before the trial court. Now, as on today, it is pending.
No.
You have filed an appeal only against that injunction passed by the trial court. Now, your appeal is allowed. Now that, again, that IFR
Right,
vacating has to be considered.
No.
To avoid all this
that
ambiguity,
cannot
my
happen,
lord, just
because
club
for
the
this
vote.
reason, IA for vacating was filed when an ex parte order was granted. Now that ex parte order is confirmed by a considered order. Against the considered order, an appeal is filed.
No, is there any
There is
provision?
no provision for filing an appeal against a considered, filing an application for vacating stay on a considered order. If there's a considered order already passed, 39 Rule 4 arises only if I can show change of circumstance. If there's no change of circumstances,
They
then.
could have said
39
that
4
no purpose will serve, it can be disposed of.
ಅಷ್ಟೇ infructuous ಅಂತ ಹೇಳಿ dispose ಮಾಡಿದ್ರು, I would not even have come in appeal.
But that finding is effective.
Rules,
My lords may observe, my lords may
I will
observe.
say, then, see, since order has been confirmed, there is no question of filing an application for vacating. Therefore, now only that appeal he has rightly filed. When deciding that appeal, he should not influence any observation made in this.
Please.
Fair enough.
Yes, that
Until then, whatever order is there will continue to operate.
is passed by this court will continue. That.
Yeah, that goes without saying, my lords.
The
That order is
injunction
there.
order is still there, that has not been stayed by
That has
that.
not been stayed by any.
Then why do you make all this thing? Yes. This petition is filed by plaintiff challenging order dated 7/11/2024 passed by second additional senior civil judge JMFC Anekal in MA number 34 of 2024, whereby order passed by the trial court on IA number 2 is set aside. Plaintiff has filed suit for
Injunction, well.
suit for injunction. Along with that plaintiff, he has filed IA number 1 under order 39 rule 1 and 2. Our so and so is undertake to our guest. Order 39 rule 1 and 2. The trial court has granted an ex parte injunction order. After appearance of the respondent defendant, they filed an IA number 2 for vacating that ex parte injunction order. After hearing the parties, the trial court has rejected that IA number 2 and confirmed that ex parte injunction order granted on IA number 1. Being agreed by the same, which defendant?
There's only one defendant.
Only one defendant. Huh? The defendant has filed MA 34 of 2024 before second additional senior civil judge JMFC Anekal against that order passed on IA number 2 and MA ಇನ್ನೊಂದು 35.
35.
MA 35 of 2024 has filed against that order passed on IA number 1. The first appellate court has passed this impugn order in MA number 2024 on the ground that since injunction granted by the trial court on IA number 1 has been confirmed, the question of consideration of IA number 2 for vacating would not arise, and the defendant has rightly filed an appeal for challenging granting of injunction under 39(1) and 2 on IA number 1 is pending. However, while passing that order on MA number 34 of 2024, the trial court made as some observation. Being agreed by the same, the plaintiff is before this court. In view of the above, it is made clear that since temporary injunction granted by trial court on IA number 1 filed under order 39 rule 1 has been confirmed, against that appeal is filed in MA number 35 of 2024, same is pending. The trial court has rightly held that there is no necessity for consideration on IA number 2 filed by the defendant for vacating. However, trial court has made some observation in the impugn order in MA number 34 of 2024, it is made clear that trial court while deciding IA number 1, deciding MA number 35 of 2024 on merit without influencing any observation made in this order. With that observation, the writ petition is disposed of.
Without being influenced by any objection made in that order, my lord. Filed in MA
Without
34.
influencing any observation made in MA number
34.
34 of 2024. Yes.
Grateful.
All pending applications are disposed of.
Serial number 13, Varun S. per petitioner, connected matter.
Appear for the petitioner in these matters, my lords. These are the matters where my lords were pleased to see in the previous state. Very clearly, my lords, these suits are not commercial disputes. Probably in a hurry, my lords, there is a perverse interpretation by the learned commercial court. My lords were pleased to hear me on the last state. 3 conditions have to be satisfied, my lords. One is that parties have to be merchant, banker, financier. Second, it has to be an ordinary transaction. And thirdly, the dispute has to arise out of that. Illi enagide, 3 family members suit hakidare. 60 lakh, 1 crore, 1.5 crore, all 3 suits. And I'd also submitted probably a fallout of the original partnership dispute. They're harassing me with about 5 to 6 suits, my lords.
Yes.
My lords, I'm not shying away from defending, my lords. Let them institute it in the court which has jurisdiction. 25th matters coming up, my lords.
Permit me to file the Bakalan and file my statement for objections.
25ನೇ ತಾರೀಕು ಅಲ್ಲಿ ಬರ್ತಿದೆ before the learned commercial court.
What is your contention? This is
Lords,
not
my
an account.
contention, my lords, my lords are pleased to take the plaint. Very evidently, plaintiff himself says who are the parties anta. The more condition alli merchant banker financier agbeku annodru. Kindly take, my lords, page 21 of the plaint. My lords of the first writ petition 33639. Because my lords are well aware, setting up of the commercial courts is for a specific objective.
Yes.
Page 21, my lords have. Para 6, my lords. D1, plaintiff submits that the first defendant is carrying on business in the field of manufacturing and selling agarbatti since many decades. That is the business of defendant number 1. Plaintiff adordo, what is his profession or calling? Nothing is mentioned, my lords. And thereafter, the very next paragraph, 7, plaintiff submits whenever financial requirements arose to the first defendant. It is a suit for recovery of money, my lords, where plaintiff.
No, that is what that hand loan has been taken from me.
ಅದಕ್ಕೆ 2 citation ಕೂಡ ಕೊಟ್ಟಿದ್ದೆ 25ನೇ ತಾರೀಕು ಬರ್ತಿದೆ. My lords, court without jurisdiction. I don't want to take up the time of this honorable and ultimately.
What do you want, madam? Yes. 23rd. Yes, 23rd.
Please.
Yes, leave this matter on 23rd.
Number 14, yes, we.
Yes, on that day, if they are convinced, otherwise we'll pass an order on.
I'm grateful, my lords. I've served copies on all the defendants. Response 2 to 4 are formal parties, my lords.
Yes, what is the trial court has passed an order?
Trial court has rejected saying, my lords, it is not the transaction which matters. Illi recovery suit ಅವ್ರು ಹಾಕಿರೋ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಏನ್ ಹೇಳ್ತಾರೆ, ದುಡ್ಡು ಕೊಡೋದು ಬಿಡೋದು ಆರ್ಡಿನರಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅಲ್ಲ. ಆ ದುಡ್ಡು ಇಸ್ಕೊಂಡು ಉಪಯೋಗ ಏನಕ್ಕೆ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದು ಮ್ಯಾನುಫ್ಯಾಕ್ಚರ್ ಆಫ್ ಅಗರ್ಬತ್ತಿ. ಸೊ ವೆರಿ, ಇಫ್ ಐ ಮೇ ಹಂಬ್ಲಿ ಸೇ ಸೊ, perverse interpretation. What will happen, my lords? Every single civil suit will end up coming before the commercial court, except for maybe partition suits.
Where is that judgment you have placed?
My lords, previous, okay. Honorable Bombay High Court, my lords, where very clearly it says hand loan is not a commercial dispute ಅಂತ. ಅಲ್ಲೂ ಕೂಡ partners ಮಧ್ಯಾಹ್ನ ಆಗಿತ್ತು. My lords have the.
Which is that judgment?
My lords, the first of these judgments is Bharat Hudanna Shetty versus Ahuja Properties anta.
File ಅಲ್ಲಿ ಇದೆಯಾ ನೋಡಿ. Take note down that this thing, Mr.
I have.
No, give it to that my law clerk. Yes. Next case, sir. Yes.
Because as my lords have rightly observed, there's no judgment on the point, my lords. I will trouble the court with, my lords, to lay down some guidelines for assistance, my lords.
Yes, we'll see that. Yes.
Grateful.
Number 14.
Now we'll also get that assistance of other side, then we'll.
Grateful.
My lord, defendant's petition, my lord. My lord, suit for declaration, possession and consequential injunction filed by the respondents herein, my lord. My lord, before commencement of the evidence, my lord, the respondent herein have filed, made an application seeking for appointment of court commissioner to inspect the suit schedule property and to submit a report.
No, suit for?
suit for declaration, possession and consequential injunction
Yes.
filed by the respondents herein
Hmm.
against the petitioners.
Yes.
My lord, in the
Now-
before commencement of the trial, my
Hmm.
lord, they made an application.
Where is
Sought
that?
for appointment of court commissioner to inspect the suit scheduled property, who is in possession of the scheduled property.
Now, what is that order passed by the trial court?
Your lordship kindly come to that the application came to be allowed. Your lordship kindly come to operative portion at page number 38.
To report whether there is any.
It amounts to collection of evidence and premature, misconceived.
Issue notice. Stay of order dated 23/9/2024 passed by Permanent Civil Judge JMFC Arkul Court on IA number 2 in OS number 4 of 2023 till next date of hearing.
Much obliged.
Serial number 15, AG Nagaraja.
Please, my lord.
Yes.
Plaintiff's writ petition, please, my lord.
Hmm.
Initially, the suit was filed for permanent injunction against the defendants.
Hmm.
And during pendency of the suit, please, my lord, the defendants have executed the sale deed in favor of the impleading applicants.
Hmm.
And the impleading applicants have started putting up construction by encroaching the social property, please, my lord.
Hmm.
And hence the plaintiff has filed 2 applications under Order 1 Rule 10 Class 2 application and also another application for the amendment application under 6 Rule 17 produced at annexure.
What is that amendment you want to say?
An amendment which is sought for, please, my lord, the encroached portion and also the construction started putting up construction. We are sought for the possession by way of declaration as well as the pleadings, please, my lord. This is the amendment we are sought in the application. It is
What is the
produced.
stage in that, this thing?
Now the stage is for the hearing and application, please, madam. One application is filed under our 1 Rule 10 Class 2 application. This is the stay for hearing.
No, issues are not framed.
Issues are not claimed, please.
Then
Now
why
this
the
appli-
trial court is dismissed?
Dismissed without the reason, please, madam. Your lordship may kindly come to the reasoning arising.
Hmm.
Without expressing the reasons, please, madam, the injunction suit, if the defendants are denied my right title and over the property and also encroached my portion, it is definitely cause to the plaintiff to amend the plaintiff.
Issue notice. Stay of further proceedings in OS number 942 of 2017 pending on the file of second additional city civil judge Bangalore
City-
Rural District.
Senior is only civil judge, please, madam.
Second additional civil judge
Yes.
Bangalore Rural District till next date of it.
And also I may permitted to take out the notice to the counsel who is on record before the trial.
Permitted to take out notice to that counsel who is appearing for the respondent before the trial court.
Please.
Serial number 16, adjourned. Serial number 17, Sharan BT.
Serial number 60, I am appearing for petitioner, my lord.
Somebody has taken time, Mr.
Because I am the petitioner, I am waiting here since from, no, I don't know who has taken.
Our respondent.
Proxy I'm the proxy counsel for the defendant.
Without,
Wait.
The advocate on record is traveling today, my lords. He's not present today. Sought an adjournment today.
ಎಲ್ಲಿ ಯಾವತ್ತಿಗೆ ಹೋಗಿದೆ? ಅಲ್ಲಿ ಯಾವತ್ತಿಗೆ ಹೋಗಿದೆ?
Next week ಅಂತ ಹೇಳಿ.
Tuesday.
I am seeking stay of the further proceedings, my lord.
What is that urgency? in
I
that?
have served caveat petition also. Earlier, this court, trial court has passed an order.
Tuesday we'll have it on Tuesday because it is
ಅಲ್ಲಿ-
already urgent.
Tuesday ಹಾಕೊಂಡಿದ್ದಾರೆ ಅವರಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಟೈಮ್ ಕೊಡ್ತಾ ಇಲ್ಲ ನನಗೆ.
Tuesday we'll hear and grant an order by the time. Yes, Tuesday.
ಅಲ್ಲಲ್ಲಿ 20ನೇ ತಾರೀಕಿಗೆ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ
Let
ಅದಕ್ಕೆ.
us see on that. On that day itself it is posting. Yes,
Without intimating me, they have taken time.
madam. Before that, yes.
I am all
No,
waiting.
at least she is there when the matter is called. In some of them.
I
counsel
was
after-
sitting here, that is only
No,
for
some
preliminary
of the cases-
hearing.
Respondent counsel, after taking the time, we will left the court premises itself. At least he is there responding. Yes, that too.
Date means
Junior member.
Tuesday.
Yes,
Serial number 17, Sharan BT.
Wait for petitioner in this case, ma'am.
yes,
Petitioner is a decree holder before the trial court, my lord.
yes.
Petitioner has filed in recovery proceedings before the arbitration case in 1335 AC 3516
Hmm.
for amount of 4,44,720.
Hmm.
That has been allowed. That is
Hmm.
an ex parte order, my lord.
Hmm.
Thereafter, we filed an execution petition before the trial court, Bangalore.
Hmm.
In that application, in that petition,
Hmm.
they have appeared after the NBAA has been issued.
Hmm.
They have not filed an objections to that said petition. Thereafter, objection has been taken as nil. After the objection has taken as filed, they filed an application under Order 11 Rule 14, my lord,
Hmm.
seeking the documents
That is annexure B, my lord. That is the application. Annexure B, page number 19, my lord.
During that, if the documents are relevant to the matter in controversy and the same. No, yes, let them produce how it will affect that.
We will already produce all the documents relevant to the trial court, my lord.
Adi, whatever the documents you required, you have produced, but see, is there any judgment to shows that in execution petition, no document can be produced under Order 11, Rule 14? Is it your case?
Yes.
No, where is that judgment on that point? It cannot be produced in that execution
No,
petition.
my lord. My only submission is we already produce all said documents before the arbitration and also the
No,
execution
that is,
petition.
you can produce the documents for your case supporting. Can you produce the documents which will helpful to that defendant? See, first of all, you have taken an ex parte order.
Yes, my lord.
At least now they are appearing and wants to produce that some documents to defend their case, which is permitted under law. It has been permitted.
No, my lord, they have not.
What will happen?
They have
if you
not
are-
challenged the arbitration proceedings also, my lord. They have not although.
No, they need not be challenged. Even execution petition also, it is permitted that they can take any contention. There is no bar. If there is any bar, you show me that. See that if I stay that execution petition, it is your execution,
Yes,
again
my
it will be stayed.
It's seeking only order of operation of the order.
Order of operation cannot be. Tomorrow, if you fails, then execution petition is closed, where they will produce the documents. You want stay, I will stay that execution petition or leave it that will take notice. What do you want?
If notice, my lord.
Yes, issue emergent notice.
Serial number 18, Manjunath Rao Bonsle.
For the petitioner, my lord.
Yes.
Petitioner is the defendant number 1 before the trial court. And the first responding here is the plaintiff, my lord. Earlier, my lord, he has filed a suit for bare injunction. That is annexure A, my lord, is plaintiff. The kindly see the prayer, my lord. Prayer page number 20, my lord, in plain. To pass judgment and decree permanent restraining the defendants, their legal heirs, agent, influence, and so far in respect of the suit property, my lord. No, I have heard the detailed written statement, my lord, as per annexure B, containing that the suit person is not existed. And the suit earlier, my lord, he has filed a suit against one Narasimha Murthy, who is the one of the
What is that?
No, my lord, he has sought the amendment, madam, seeking 3 prayers. The entire change nature of the suit, my lord, change, my lord.
Earlier suit for?
Bare injunction, only bare injunction, my lord.
Now what is that application? Where is that?
Application number annexure E, annexure D, my lord. Kindly see the, my lord, is a prayer. He sought several amendment. Page number 22, annexure D, my lord. Application for amendment. He sought some amendment in the pleadings, my lord, and also in the prayer.
Amendment.
Amendment, kindly see, my lord, page number 33, to pass a judgment and decree for declaration declaring that the plaintiff herein is the object owner of the suit settled property.
Declaration.
Yes, sir, declaration, my lord. If he want to, my lord, he has to withdraw this and file the first suit.
No.
Where is the declaration is
That need not be, mister. When you have taken a contention in the written statement denying their title, they can seek.
No, I have not denied, my lord. I have not denied his title, my lord.
Yes.
The suit settled property is different. Kindly see my written statement, my lord. And I also constructed in the year 18 itself.
No, if declaration is sought in respect of the suit scheduled property.
Suit settled property.
Then
suit settled property is not existed, my lord. There is no such suit settled property. In spite of, there is an injunction order also there. If the violated the injunction, my lord, he has every right to file the.
If suit settled properties is not existed.
Yes, my lord.
What will happen if they claim for any declaration? He will fail.
No, my lord. No, my lord. They wanted to demolish my building. My building. I have already constructed in the 2018 itself. I have stated my written statement. Kindly see my written statement, my lord. My written statement, annexure B, particularly page number 29, my lord. It is filed on 6/4/2018.
What is the reason given for filing an amendment now?
Amendment, my lord, there is a COVID is there. That's why he has not filed this application. My lord, 2018 itself, I have constructed. They have taken the concern before the trial court that I have constructed a building during the period of COVID. Total nature of the suit is a change, my lord.
When suit is filed?
Suit is filed on 2018, my lord. That is dated 5/9/2017.
Issue notice. Stay of further proceedings in OS number 3271 of 2017. Pending on the file of 31st Additional City Civil Judge, Bangalore, till next date of. Please.
Serial number 19, Nanjunda Swami.
For petitioner,
Yes.
the petitioner, my lord, is a second defendant before the trial court. My lord, he filed an application under section 11 of Karnataka Court Fee and Suit Valuation Act, wherein, my lord, seeking a direction the plaintiff to pay fresh valuation slip and pay the deficit court fee.
Good for?
Suit for, my lord, declaration that the alleged, my lord, execution of release deed dated 17/7/2013 executed by the defendant plaintiff in favor of the defendants is null and void anta kelidare.
Now what is the order of the trial court?
The trial kindly, my lord, before that, my lord, they have produced the page number 48 is the valuation slip. Valuation slip ಅಲ್ಲಿ ಅವರು ರಿಗಾರ್ಡಿಂಗ್ ಪಾರ್ಟಿಷನ್ ಮಾತ್ರ 200 ರೂಪಾಯಿ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದ್ದಾರೆ. Release deed null and void ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. They have to pay the court fee on the market value of the property in view of section 38 of the Act.
Seeking for a relief, 1/3 share of the court has paid, so 35 court fees. Where is that plaint, Mr.?
A plaint, my lord, at annexure A, my lord, page number 16. Page number 16, prayer, my lord, page number 19, my lord. Running page number 19, prayer ಗೆ 1 ಮತ್ತು 2ನೇ ಪ್ರತಿವಾದಿಯವರು ದಿನಾಂಕ 17/7/13 ವಾದಿಯಿಂದ ಆಗಿದೆ ಎಂದು ಹೇಳುವ ಹಕ್ಕು ಖುಲಾಸೆ ಪತ್ರ ಮೋಸದಿಂದ ಕೂಡಿದೆ ಎಂದು ಘೋಷಿಸಬೇಕಾಗಿಯೂ ಮತ್ತು ಪಾರ್ಟಿಷನ್ ಕೇಳ್ತಾರೆ. ಮತ್ತೆ ಪ್ರೇಯರ್ ಸಿ ಅಲ್ಲಿ
Issue notice. Hints. Matter involving that court fee is concerned. Government advocate is directed to take notice. Learned counsel for the petitioner is directed to serve one set of copies on government advocate. Office is directed to show the name of government advocate in cost list. Stay of further proceedings in OS number 388 of 2014. Pending in the file of 6th Additional Civil Judge JMFC Hassan till next date of hearing.
Great.
For 20, Chokka Reddy for petitioner.
Respondent 2 to 11, my lord, they are claiming the expert. I sought defense on notice.
ಏನಾಯ್ತು 18?
18 notice ಆಗಿದೆ sir.
Respondent 2 to 10, my lord. They are placed expert in the trial court. That's why I am seeking a disposition of notice.
Memo ಕೊಡಿ.
Please.
Filed in a memo, dispense ಮಾಡ್ಬಿಡಿ. Yes. At the risk of the petitioner. Yes.
My lord, in this petition,
Serial number?
20, my lord.
Yes.
My lord, the will was executed 21/6/22, my lord, by the husband of the petitioner, and second petitioner is the son. Based on the 2023 died, my lord. Thereafter, they have approached the district court and PNDC 112/2023. It was PNDC granted, my lord. But they subsequently, my lord, January 24, the second respondent claims as a second wife and son. And she has filed the very same in the court for the PNDC in another the created bill. But the petitioners appeared and filed the objections. So already PNDC was granted to the in favor of the petitioner based on the will. The second will, the proceedings are conducted by the court is a abuse process. But the already in this the point is the deceased executed the will, already PNDC was granted.
Now what is that order you are challenging?
The entire the proceedings initiated by the second petitioner was challenged. Already PNDC granted by the very same court. Again, the second PNDC, the respondent number 1 and 2 claims.
Oh, there is a provision for restoration of that order.
They have a right to file the declaration suit against the petitioners. Or challenged by the PNDC certificate issued by the very same
court. Can seek for a restoration of that order. It is provided.
My PNDC order, she can challenge my PNDC order or they file the suit for declaration.
Now, where is that this thing?
Malad, PNDC certificate, page number 37. Annexure F, Malad. That is the petitioner's, the PNDC certificate. Based on the will dated 21/6/22. That is allowed. Thereafter, Malad, the 2024 January, she has initiated this PNDC proceedings, now the challenge before this court. Based on the will executed by the very same deceased. The petitioners they appeared before the court and filing this statement of objections. That proceedings, one PNDC granted, my point is PNDC.
Is it order 7 rule 11 application is maintainable here.
My lord, maintainable, we have not filed 7 rule 11, my lord.
You file for a rejection of
Yes.
is it applicable to that P and S?
And already, my lord, my point is to already one PNDC certificate was granted by the very same court.
No,
Second
therefore-
PNDC certificate.
See, 227, any interlocutory order by the trial court can be challenged. You can't use it at a 226. See, you have a provision which is made in that CPC which is available. You make use of that.
This is an
Is it-
abuse process, my point, my lord.
Therefore, that is the ground which is available. First, you verify whether Order 7 Rule 11 application can be filed under P and SC. If it is there, you file it there and get it order.
Yes,
Otherwise, everybody will file a writ petition saying that it is abusing process of law. Therefore, that Order 7 Rule 11 is there.
Yes. Next date, I will verify the
You first
provision.
verify it is
Yes.
maintained, then you will permit it to file it there. Yes. When do you want?
In the next 1 week time, maybe.
Yes, use this matter on 23rd.
Yes, please.
In the meantime, you verify.
I will.
Serial number 21, Nagaraja
If
RC.
application can be filed under Order 7, you file it for rejection of the plan.
Serial number 21. And for the
Petition. Kindly see the annexure beam load, page number 19.
Yes.
Lord, Chikka Madaya and Siddhamma, they had 3 children. Siddhamma and Chikkanamma and Linganna. Siddhamma and Chikkanamma filed a suit against Linganna and my petitioner. Suit for partition. Suit was decreed in respect of 1 to 3 items.
Yes.
Against the 4th item, Lord, a suit was dismissed. At the same time, Lord, Linganna has also filed a suit for cancellation of the sale deed. That has been dismissed. RA is filed. RA is dismissed. RSA is filed. Dismissed. After lapse of 9 years, Lord, these Siddhamma and Chikkanamma filed an RA. Filed an RA application under section 5 of the limitation. It is condoned without.
Where is that order?
Order, Lord, kindly
What
see
is the reason given by for delay?
ಏನು ಇಲ್ಲ ನಮಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ ಅಂತ ಐ ಆಮ್ ನಾಟ್ ಅವೇರ್ ಆಫ್ ದಿ ಆಫ್ಟರ್ ಡೆತ್ ಆಫ್ ದೇರ್ ಫಾದರ್ ಆಫ್ಟರ್ ಡೆತ್ ಆಫ್ ಸಿದ್ದಮ್ಮ ಅಂಡ್ ಚಿಕ್ಕಣಮ್ಮ ಇದು ಯಾವಾಗ ದಿಸ್ ಸೂಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಆರ್ಯ ಡಿಸ್ಮಿಸ್ ಆಯ್ತಲ್ಲ RSA 2022 ನಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು ಅದು ಆಫ್ಟರ್ ಕೇಮ್ ಟು ನೋ ದಟ್
Stay of further proceedings in RA number 45 of 2023 pending in the file of Senior Civil Judge JMFC Chamarajanagar till next date of hearing. Emergent notice.
Serial number 22, Govindaraya Kamatke.
For the petitioner, your lordship.
Yes.
Lordship, 3 applicants, it's a commercial suit, your lordship, filed for recovery of monies in lordship. Your lordship, if I may draw your lordship's attention to 3 IAs that were filed by the petitioner, your lordship. 3 IAs, one was for recall of the order, reopening of the stage and production of documents.
No,
The
suit for?
Suit for recovery, your lordship. Recovery and direction, your lordship. Wherein we had filed, the stage was for final arguments. We had filed an application, 3 applications for recall of the order, reopening of the stage and production of documents. The documents sought to be produced was the resolution copy of the partnership firm, your lordship. Your lordship, the resolution of the partnership firm is at page number 91A, your lordship.
Where is that order?
Your lordship, the
No,
order.
this is your suit.
Please, your lordship.
It
it's
is
my-
in a commercial suit.
Please, your lordship, it's a commercial suit arising out
All
of,
for all that, there is a limitation is there for that.
well within
Can't take
limitation.
it as in a general suit.
Please, your lordship.
You can't take it as in a general suit in delaying that process, madam.
We're not juggling the suit, your lordship. One more thing, if I may just draw your lordship's attention to the plaint that's annexed, your lordship. At page number 24, your lordship. If I may just kindly read the cause title. It reads, Shri G. Satish, partner of Mahesh Home Appliances. Further, at paragraph number 3 of the said plaint, it reads, if I may just read this paragraph, your lordship.
Yes.
Plaintiff Shri G. Satish is one of the partner of Mahesh Home Appliances. That Mahesh Home Appliance in Bangalore is one of the leading businesses and inter-alia engaged in the business as dealers in LPG gas. That's one, your lordship. Subsequently, if you just look into the invoices raised by the plaintiff, your lordship, at page number 35. it reads Mahesh Home Appliances. It bears the GST number of the partnership firm as well. And your lordship, it's aware that the GST number is also inclusive of the PAN number. And here it reads FM, your lordship. The letter F, which is in the
Now you
PAN
come to
number.
that reason for the
Please,
trial.
please, your lordship. Your lordship, if I may also draw your lordship's attention to the legal notice that was issued by us to the defendants.
Now, what is the reason given by the trial court for rejection?
Your lordship, the reason given by the trial court for rejection is that they say that there has been subsequent admission, your lordship, is what it reads. If I may.
Where is that?
Your lordship, that is at page number 16, your lordship. 16 is the order sheet. It reads.
Where is the finding or reasoning?
Please.
You read that para 8.
Yes, your lordship. Under the applications, the plaintiff is seeking to produce the resolution of the partnership firm dated 19/11/24 to ratifying the acts done by PW1 with respect to filing the suit, adducing evidence, etc. It is the contention of the defendant that this application is filed only to overcome the admissions elicited in cross-examination. PW1 in cross-examination is admitted to the remaining partners have not issued any authorization in his favor to represent them in the suit. This is what it reads, your lordship. If I may just draw your lordship's attention to the admission and denial statement filed by the
Order
defendant.
9 Rule 1 CPC stipulate that time of filing an suit itself is a document sought to be filed. The exception is with regarding to the document confirmed in the course of the cross-examination, which are summoned by the court. The plaintiff is fully aware regarding the transaction at the time of filing the suit, and he was also aware that he was filing a suit on behalf of the home appliances. There was no impediment for the plaintiff to obtain the necessary resolution and pass production same along with. Why you have not produced along with that plaint, madam?
Your lordship, there was, the reason stated was we were the subsequent counsels in the case. There was some miscommunication between the earlier counsels.
No, that is not the ground which is available under that act. madam.
Please, but your
By
lordship,
changing the counsel is not a ground that not produce that.
please.
It is for the parties to show.
Please, your lordship, if I may humbly submit, it's a procedural defect, your lordship. It is also admitted by the defendant in his
No,
admission and denial
this is
statement.
also law which says that
Please,
all the documents which is available has to be filed along with that.
we stated
What
the,
do I
ad-
do?
we state,
PPCL. Consumer. Consumer. right.
your lordship, it's merely procedural nature, your lordship. And the resolution that was placed, your lordship, is based on the admission made by the defendant as well. And it's not a disputed fact that it's a partnership firm, your lordship. Even,
No, you see that order 11,
please, your
rule
lordship.
1,
Sub-rule 5, your lordship.
rule 1(3). Plaint shall be containing the declaration of oath from the plaintiff that all documents in the power, position, control, or custody of the plaintiff pertaining to the fact and circumstances of the proceedings initiated by him have been disclosed and copies thereof annexed with the plaint. That the plaintiff does not have any other document in its power or position, control, and custody. As on the date of filing that whatever the documents it is there, you have to be produced, madam.
Please, your lordship.
Then
Your
there
lordship,
is no such exemption then that if you are not produced, you can be allowed. Filing the petition may seek a
Your
leave
lordship.
of early and additional documents as a part of the above declaration and the oath subject to the grant of such leave. The court plaintiff shall file such additional document in court within 30 days of filing. See, you have to take any leave, you have to file. There is no such provision permitted you to file it later stage.
please,
Just because that lawyer has, you produce any document, judgment to show that it can be filed even after that, then I can, otherwise nothing wrong in that order, madam.
please, your lordship, I would just want to take 2 minutes of your lordship's time to show to peruse through the admission and denial statements, your lordship. Nowhere it's denied by the defendant that we are not a partnership firm. It's forthcoming even in the statement of admission and denial at page number 53, your lordship.
See, whatever the document you have to be produced along with that.
Please,
Where is that provision which permitted you to file it afterwards? Show me that. This is the, see, for this act, there is a special provision.
Please.
Even CPC, they have made an amendment.
please.
It is only applicable to that. In this, which is very clear, along with that plain documents, in that urgency, if can't file it, you have to take a permission of the court.
Please.
Then you have to file it within 30 days. Now, after 1 year, you are doing all these things.
Your Lordship, it's merely procedural in nature, Your Lordship. We have also, Your Lordship, this subsequent ratification has also been given, Your Lordship. And
Show me that
please,
this is only a, now it is not a mandatory, it is directory, court can accept. Any judgment on that point, you show me that
please, Your Lordship, if Your Lordship, I may be passed over in that matter, Your Lordship.
next week.
Your Lordship, the matter is listed tomorrow for final hearing, Your Lordship. I seek for a stay in this matter, Your Lordship, as it may be passed over, Your Lordship, if in that
Yes,
matter.
pass off, yes.
Number 23, Chidambara GS.
Yes.
And it's the plaintiff's petition.
Hmm.
And suit is for declaration, mandatory injunction and possession. And in which plaintiffs made an application under Order 26 Rule 9 for a commissioner appointment, which was dismissed by the trial court, and this honorable court earlier writ petition allowed and appointed the DDLR as commissioner. Thereafter, we have issued a memo of instructions and commission warrant was issued. Instead of DDLR, surveyor has visited the spot and submitted the report. Objections were filed and court has rejected the commissioner's report. And the DDLR has been specifically directed to execute the warrant. Accordingly, DDLR 1 Bhavana has visited the spot and submitted the report showing encroachment. It was also objected to. Court has rejected that report also. And with a specific direction to that commissioner, CW2 Bhavana to re-execute the warrant in view of certain
Irregularities.
But second time, after that order, instead of the CW2 Bhavana, some other DDLR has visited the spot. He has some different reports submitted stating that there is no encroachment. Therefore, we have filed objection to that. Plaintiffs have filed the objections. Commissioner has not properly executed the warrant,
then
and
what
that
has-
instead of Bhavana, some other person has gone.
Yes.
And that he has not taken the assistance of engineer of corporation, though there was a.
No,
there-
what is that order passed by the trial?
Now, trial court has accepted the commissioner's report,
Where
which
is
is according to me.
Where is that direction that only Bhavana
Please.
has to do it?
You will ask me kindly see page number 25. Sorry, page number 25. And last para. For the reason stated above, the report of the commissioner is rejected. The court commissioner Bhavana is hereby directed to execute the warrant afresh. Now, Bhavana has not visited this spot.
Where is that? Have you taken that objection in that?
Yes, I have
where-
taken the.
What is the consideration of that? Trial court?
Yes, in the objection to the commissioner report,
No, that,
As-
where is the impugned order?
impugned order, page number 37. It commences from 37. And some history is given. Thereafter, after considering several judgments, page number 42, CW3 during his cross-examination has admitted that Mardan Saab and all one more submission. One of the memo of instructions was that commissioner shall issue notice to the Bajudars. After receiving the memo of instructions from the advocates, court itself has formulated the memo of instructions.
No, what is that reasoning given? Why that? Bhavana
Mainly on the ground that this is a old suit pending.
I am asking,
Please.
is there any reasoning given by that trial court? Why Bhavana has not?
That has not been specifically considered by the trial court. Main ground was that it is a old suit. And Bajudars notice ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋದು objection ಹಾಕಿದ್ವಿ. Court shall issue notice to the Bajudars ಅಂತ memo of instruction court itself has formulated. ಅದನ್ನ ಮಾಡಿಲ್ಲ. ಅದಕ್ಕೆ ಕೋರ್ಟ್ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ Page number 12.3 may kindly be seen at page number 42, point number 12.3. May I read? Madam?
Yes, yes.
42 page. Admittedly, there are no documents to show that they are Bajudars. However, it is to be noticed that the counsel for the plaintiffs has not denied that they are not the Bajudars of the suit A and B scheduled properties. This is because we have objected that Bajudars have not been noticed.
Now that they are not in a Bajidar.
Bajudars. Okay, Your Lordship may kindly see CW3's cross-examination.
Issue notice. Stay of further proceedings in OS number 363 of 2010. Pending in the file of first additional civil judge JMFC Davangere till next date of hearing. In addition, petitioner is also permitted to serve copy and counsel appearing for respondent before the trial.
Serial number 24, Sanjay Nair for petitioner, Abhinav R.
Yes, I am for the petitioner, Your Lordship.
Yes.
This is challenging and allowing of an amendment application, Your Lordship.
Right.
The basic facts of this case is that the respondent number 1 herein had filed a suit for specific performance against the remaining respondent. I am
Yes.
appearing for the defendant number 9 in the lower court, Your Lordships.
Yes.
The suit was filed by the respondents seeking for a relief of specific performance against the defendant number 1 to 8 with respect to certain amount of sites, that is site number 2 to site
Why
number
then 9 has made as a party? You are a purchaser.
I am a purchaser subsequent to the suit, Your Lordship.
Yes.
Kindly see, what happened in this case was, they filed the suit in the year 2007, Your Lordships. My agreement with the defendant number 2, who is the owner of Schedule A property. The suit schedule consists of 5 properties, Schedule A to Schedule E. I am concerned only with Schedule A, Your Lordships.
Yes.
I entered into a memorandum of understanding on 24/2/2003 to 2003, which is prior to the suit. Their agreement is 28/7/1994, Your Lordships.
28/7.
1994 is the agreement of the respondent number 1 with the remaining respondents.
Yes.
It is
That agreement includes A scheduled property also.
yes, Your Lordship. It includes A schedule property. It was a purchase of the A schedule property.
Yes.
During the course of the proceedings, the defendants have taken a contention that the agreement came to be cancelled by way of a notice dated 17/7/2001. That is their agreement. I am not getting into those merits of the case, Your Lordship. Then my agreement is 24/2/2003, Your Lordships. On 3/3/2005, I issue a notice under Section 21 of the Arbitration Act to commence the arbitration proceedings. Hence, as per Section 21.
What is the order you are challenging?
My order is an order of amendment that they have filed now.
What is that amendment they are
Yes,
sought
sir.
for?
Their amendment application, Your Lordship, will find it at page 213. They not only want me to join in the execution of the sale deed.
What is that amendment they are sought?
They have sought to include certain paragraphs, which is a matter of trial, Your Lordship. But the the grievance is with respect to the respective prayers that they have made. At 216, they have sought for amending of the prayers of the suit.
Yeah, no.
To replace the word defendant number 1 or 2 to 7 with the word defendants. That is all right.
Yes.
Because to insert the words in the 4th line of the prayer after the word sale deed, the suit schedule property is either a landed property with developments thereon or assets. What they wanted to seek from the court against the defendant number 1 to 7 was with respect to certain sites that they alleged that they had formed. Subsequent to the purchase by me, which is through a court order, through in execution proceedings, I have, in the year 2021, I have gone and proceeded to construct a multi-story building.
So now it is constructed, therefore they are included what?
Not only that, Your Lordship, the third prayer is the one which is even more aggrieved.
Yes.
To insert the following and declare that the court sale deed dated 23/2/2001 executed in favor of so-and-so, registered as so-and-so at the office of sub-registrar so-and-so, as not binding on the plaintiff and direct the defendant number 9 to restore possession. Now, the simple question before the Honorable Court is that if in a suit for specific performance, if I am the purchaser subsequent to the the suit or whatever they claim, at best, all that they can ask me is to join in the execution of sale deed in case they succeed finally. That's all the Supreme Court has said. The role of the subsequent purchaser.
In suit for specific performance, can he sought for any declaration?
No, he cannot seek for a declaration that my sale deed is not binding upon him. All that he can seek for relief is, if I succeed in my relief of specific performance, ask the defendant number to join in the execution of the sale deed. Adibitpitu cannot ask for a declaration because as on today, he is only an agreement holder. He does not have a title over the property in case for a partition suit for lordship. For
It's the
example,
only issue. You have to be answer both of them. Can it be allowed to seek for an
Why the prayer sought?
Hmm.
In the year 2003, Lord, the person who is now impleaded as defendant number 9 gives paper publication on 12/11/2003.
Hmm.
Lord, I give a response to the paper publication saying I am an agreement holder. I am in possession. Please don't go ahead and enter into any transactions. This is in the year 2003. 2007, my lord,
Hmm.
I filed a suit. There is an order of status quo which binds, my lord, defendant number 1 and 2. My lord, the 9th defendant is fully aware that I am a prior agreement holder. I am in possession.
Yes.
Nevertheless, my lord, he initiates proceedings unilaterally against defendants 1 and 2. There is a collusive decree that is passed. Plaintiff is not made as a party. Then, my lord, he claims that there is an arbitration award passed in his favor. Then, my lord, he takes a court sale deal. And then, my lord, without there being an order for
No, during the pendency of this suit.
this suit, he does
This has,
not-
no.
wait. This has not been brought to the notice of the court in.
That's what?
It has not been brought. I'll finish, sir.
Okay,
It
sir.
has not been brought to the notice of the court in the year.
No. See, if that would be the case.
Yes, my lord.
Yes, now the question is, suit for specific performance,
Yes, my lord.
whether you have to file in a separate suit, in that it can be amended. That is the only
No,
issue.
my lord, that is not the ground that he is.
No, now that it's a question of law.
No, my lord. 2021, my lord, sale deed is executed during the pendency of the present suit.
Hmm.
My lord, it is not that he does not have notice. He has notice of the proceedings in the year 2003 itself.
We'll accept everything.
Yes, my lord.
During the pendency, they have done it illegally,
Yes.
whether you have a remedy of filing the contempt or not. Now, can you seek an amendment to declaration that suit is in the specific performance is the question you have to be answered.
For this reason, because it is the pendant is
No.
there.
You show me that in
Yes, my lord.
judgment.
I'll produce, my lord.
That is what that I want, that is the only a question. Otherwise, see, during the pendency, if he's sold the property and all, it should be brought on.
Disposes me without taking an order of the court.
That is true.
Therefore, my lord, question of separate suit will not arise. I will press. my
And that
lord.
is only the point. If it is, can be filed, then I think that amendment can be considered as.
Very well. very
Yes. You saying that it is cannot be. Both of them produce the judgment. I will see that. When do you want?
Lordship, okay. Lordship, they all along say that I filed a collusive suit with the defendant.
This is, see, if that such a amendment is permitted under the law in the specific performance, then I will see whether this can, because this sale deed is entered in 23 to 2021.
Yes, sir.
Immediately he has filed that application. I
No. I'll tell you, Lordship.
For, my lord, impediment.
No, Lordship, I will submit certain facts. The sale deed is not a fraudulent sale deed like how my learned friend is saying a collusive suit. This matter has gone up to the Supreme Court twice. On 2 occasions it has gone.
If any sale deed or degree passed with the person who is not in a party, it is permissible for file to suit.
Correct. I have no doubt on that.
Right is there. Now, only thing is whether in the specific performance, such a relief can be claimed.
That's
One.
all I'm saying.
Second is, if it is whether question of limitation is coming. This is the two question of law has to be
Yes,
answered
yes.
by both of them.
Very well.
That's all. We'll not go any further.
Yes.
If there is no question of law arises
It is a
to
question.
challenge, then he can be permitted. Otherwise, he is getting over that limitation and filing
My lord,
that.
sale deed is executed in the year 2000.
No, that if
Yes,
it is
I
permitted,
follow that.
then we will see that.
Lordship,
That you
stay
got-
of the proceedings, the amendment has been allowed and the trial court has fixed the next date of 21/1/2015.
Wait.
21/1/2015, they said that I have to file the additional written statement as the last chance on 21/1/2015.
21-1,
21/1/2025.
file it.
ಅಲ್ಲ ನಾನು ಅಮೆಂಡ್ಮೆಂಟೇ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ನಾನು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಕ್ ಬರಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತೇನೆ.
If I allowed that and amendment is set aside, your written statement will also go.
Why I'm asking a question is to the matter is an important one. It can be
Then,
stayed
no,
for a
then-
limited purpose of hearing the.
That would be the case. You don't file it. I will permit it to file if you succeed.
That may be done, but the last chance ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. So that if the honorable court says that after the matter can be heard by me, then I can file written statement, I'm okay.
Yes.
Otherwise, I'll have to
Then
file
that
an
counsel- You will take notice to whom, Mr.?
He is already filed for the respondent number 1. And for the, as far as the respondent number,
1 to 3 are the plaintiffs, my lord. Rest of
no,
them are
it's not
all the
respondent 1
defendants.
to 3 ಅಲ್ಲ 1-3 ಅಂತ ಮಾಡಿದ್ದೀನಿ.
And then
One to three.
you will file in a memo for dispensation, Mr.
Because they have also filed their objections. Lordship, you kindly see this prayer is with respect to
Yes.
even schedule B to E. I
Yes.
will take out notice on the advocate who is appearing for the defendant number 2 to 8.
Undertake to appear for respondent number 1 to 3 Office is directed to
Hello,
store.
respondent 123 I am appearing.
He is appearing for respondent 1 to 3.
You are appearing as an caveator.
Yes, my lord.
For one-
I have to be, make it as in an, yes.
Yes.
Yes. 1 to 3, as undertake to appear for respondent 1 to 3, issue emergent notice to 4 to.
4 to 17. I may be permitted to serve the counsel who is appearing for them in the lower
4
court.
to 17. In addition, petitioner is permitted to serve counsel for the respondent appearing for respondent number 4 to 17 before the trial court. Learned counsel for the petitioner has submitted that the trial court has granted time till 21st
Yes, your lordship.
January.
January
the
2020.
last date for filing in a written statement.
Additional written statement. Lordship, in this case, I filed the written statement and I have led my evidence also. ನಾನು ಎವಿಡೆನ್ಸ್ ಲೀಡ್ ಮಾಡಾಯ್ತು ಅದಾದ್ಮೇಲೆ they filed the application.
We'll see, yes, additional written statement. If petitioner is succeeded, the time may be extended at the time of passing a final order.
Yes.
By this court.
No, Lordship, the order is clear. No, I'm not able to understand whether next state I have to file or.
Now, filing of the written statement, filing of that additional written statement by the petitioner for extension of the time will be granted at the time of final hearing.
Yes.
Will be granted a time at the final hearing. Even if you fails also, the time will be extended because you have to be filing an additional this thing.
So there is no stay of proceedings, Lordship.
Will not stay. Why do you want to stay? Yes.
No, because the case is only for filing additional written statement and for him to cross-examine me. At Matangiri, that's the only thing. If there is no stay,
Service, my lord, protecting him. One date may be fixed, my lord.
No, you will have, when do you want both of them? Then.
after the service on all the respondents, because they are also concerned with respect to schedule
My lord.
B to E.
No, only you have to answer these questions. If you satisfied, then I will grant a stay for further proceedings.
Yes, my lord.
Others has to be served. Otherwise, it is not necessary.
Lordship, the only question over here, only question was, in a suit for specific performance, even if I am a subsequent purchaser, the only relief that can be claimed is for me to join.
Asking with that authority, you come.
Put in.
He wants time to examine that.
One judgment of the Supreme Court,
Hmm.
Lordship, the Thompson press case.
Yes.
Para number 41, your Lordships.
My lord, I lost state judgment. My
You
lord,
give
may
that
I-
copy and
my
I
lord,
don't
may
want
have
to
it
waste
on
that.
the first itself, my lord.
Yes, we'll have it on 22nd.
Yes, my lord.
Yes, 22nd.
Yes.
On that point, we'll hear that consideration of interim prayer will be there. On that day,
Very.
if you are convinced, then I will grant an interim order for further proceeding.
Then the other part will not be, my lord, mentioned, saying that it is extended. My lords may call it on 22nd. On that day, my lords may take a.
No, his last date is for
Last date is 21st, then they will.
21st. But any other reason, if it is not concluded, then let it be there that will.
I can submit to the honorable trial court.
Even that order also, this court can permit.
Yes, my
For
lord.
his satisfaction, I have passed. it.
Yes, very,
Yes,
very.
Cell number 25, Satish K.
yes,
For the petitioner,
yes.
Lord, my only prayer in the writ petition is to, Lord, pass appropriate orders on the commissioner's report. Lord, facts of the case is, my lord, the respondents instituted, my lord, suit for partition, which was decreed, Lord, granting 1/8 share. Thereafter, my lord, they initiated FDP. Lord, I was not a party in FDP, my lord.
Yes.
Lord, in the year 2013, my lord, 2013, commissioner has submitted a report. Lord, I was not a party at that time.
Yes.
Lord, thereafter, my lord, the respondents filed a suit for injunction. There, my lord, the temporary injunction was rejected. Against that, my lord, an MFA was filed. May I request my lords to kindly turn to, my lord, page 47, annexure C.
Yes.
Lord, this honorable court, my lord, disposed the MFA. Lord, I filed an affidavit that I will not claim equity if the portion of the property which I have purchased, if falls within the share of, my lord, the respondents, I will not claim equity. Lord, affidavit is at page 50.
Yes.
With that observation, my lord, MFA is disposed. Now, my lord, the commissioner's report, Lord, I have cross-examined the commissioner. Lord, an order is to be passed on the report submitted by the commissioner. Therefore, my lord, I am seeking for a direction to pass appropriate orders on the commissioner's report, whether to accept.
No, that you are the party in that FDP now.
No, my lord, I got impleaded. Lord, I have,
Where is the order sheet of the FDP now?
Lord, my lords will find that annexatory page 61.
Yes.
I got impleaded, my lord, as respondent 29 and filed, my lord's statement.
Now, what is that order on that commissioner for?
Lord, no order is passed.
Cross-examination of CW1 at last chance.
ಆಯ್ತು ಅದನ್ನೆಲ್ಲ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ.
ಮುಗೀತಾ ಈಗ?
Page 67.
Is present and fully further cross-examination by the counsel.
ಮುಗೀತು. ನಾನು ಮಾಡಿದೆ, ಅದರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಮಾಡಿದ್ರು. Now, my lord, matter is
For arguments.
for arguments on the main, not on the commissioner's report. Therefore, my lord, an innocuous prayer is sought in the writ petition.
Advocate has filed a wakalat for respondent number 3 with no objection for argument. Both the counsel present, counsel for the petitioner submit a matter is.
Page 71, my lord.
Bangalore in RFA. What is that RFA it is pending?
RFA ನಲ್ಲಿ don't draw final decree ಅಂತ ಹೇಳಿದ್ದಾರೆ. There is an interim order of stay, my lord. Only with regard to final decree. Therefore, my lord, I am requesting to pass orders on the commissioner's report, not on the main.
No, now that court is, there is a direction.
Please.
See, not to draw final degree.
Yes,
proceedings.
my lord.
What is the purpose in hearing that commissioner now?
Lord, the report is submitted by the commissioner.
Suppose commissioner report is accepted.
Yes, my lord.
They can't draw that final degree because there is a stay.
Lord, I will have a remedy. Lord, I will have the remedy to challenge the order passed by the trial court.
Yes.
Therefore, my lord, my only prayer in the writ petition, kindly take, my lord, page 18.
I have seen that, but now that order of this court in RFA is coming in the way.
No. Lord,
Court Karnataka, Bangalore has, therefore they are just simply urging for arguments, that's all. It may be.
no order is to be passed on the commissioner's report, my lord. I will have the, Lord, if commissioner's report is rejected, then, my lord, appointment of, my lord, fresh commissioner is to be
Where is that order of this High Court in RFA?
Lord, the page 77, my lord.
70?
Final decree proceedings, don't draw order illa ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
Akkodi?
First date ಅಲ್ಲಿ ಆಗಿದೆ. Lord, that is not uploaded in the internet, my lord. That is the only order passed.
No, you produce that order.
Please.
In the meantime, you take notice also. Yes.
Lord,
Counsel appearing for trial court. Yes.
ಆಗ್ಬೋದು.
Issue emergent notice.
Lord, this is the only prayer. Writ itself can be disposed, my lord.
You will serve a counsel and produce that order. If there is no order which restraining for consideration on that commission.
Commissioners, yes.
In addition, the respondent, the petitioner is permitted to serve a counsel appearing for the respondent before the trial court. Yes. In the meantime, you get that order passed by that.
Please. And may I request, my lord,
You serve it and move that matter.
Serial number
Yes.
26.
ಒಂದು
Day
day,
after service, then move that matter. Yes.
23rd or 24th.
You serve it and move that. Yes.
Please.
26 for petitioner, my lord. Suit for partition and separate position, my lord. The dependent is a brother. The plaintiff has filed two applications, not to create third party right and not to construct the building in the item number 1 property. But trial court has considered IA number 1 to not to create third party rights. IA number 2 is, my lord, issued the notice. Prima facie case, my lord, the property is standing in the name of the mother of the plaintiff. Mother died, my lord, both are
Number 2.
IA number 2, my lord, only issue the notice.
No,
But
what is
not
that
to
prior-
put up any construction in item number 2, 1 property. Photos we have produced, my lord, the annexure
There
K,
are 2 IAs.
2 IAs.
IA number 1 is for
One is not to alienate the property,
not to alienate.
Yeah.
Second is not put up.
not to put up construction in the property. IA number 1 is passed, my lord. Order was granted. IA number 2, my lord, issued the notice. Kindly see the photos page number 38.
If they construct anything, they can't claim any equity.
My lord, in this, my lord, the
Suit for
partition and separate portion, my lord.
I thought if you.
But page number 60, my lord, the panchayat has issued the endorsement. No, the plan and no license for this.
I thought illegal ag madadre, they are responsible.
Yes, Allah issued an endorsement, my lord. The panchayat has issued an endorsement, page number 30.
ಈಗ ಪಂಚಾಯತ್ಗೆ ಅವರು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟು ಅವ್ರು ಕನ್ಸ್ಟ್ರಕ್ಟ್
All the documents we have produced before the trial court.
See, if they are constructed without the plan, you have in a remedy, you approach the panchayat and seek in a direction to stop that construction.
My lord,
If they are constructing in accordance with law, if you succeed, they can't claim any equity. Therefore, trial court has rightly not granted an ex parte order. The trial court has granted an ex parte order not to alienate. That is
not
correct.
alienate.
That is correct because third party interest may be created. Now construction, let him construct multi-store building. What will happen? If you
Let-
succeed, you will lose it.
My lord, prima facie, my lord,
Even then also, if it is before this court also, I will also pass same order saying that without claiming any equity, they can consider. Suppose still you are objecting, if you are ready to deposit that, if you are going to loss after that suit is dismissed, you compensate, then you deposit that amount, will say that you are not to construct.
all the
That is
prima.
what Supreme Court said.
Yes.
Construction is subject to the result. He can't claim any equity. That can be permitted.
That can be, my lord.
That is what now permitted now.
And issue the notice to the respondents, my lord, on that point, my lord.
Issue
If they-
notice. Yes, you take notice, that's all. If he is illegally constructed, approach the panchayat.
Illegally, my lord, approach the panchayat has a.
ಈಗ ನಿಮ್ ಸೂಟ್ ಇಲ್ಲ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ನಿಮ್ ಮನೆ ಪಕ್ಕದವ್ರು ಇಲ್ಲಿಗಲ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತೀರಿ. What is the remedy?
At
that
the
is-
authorities, we have to approach and to.
That is there. That is not taken over. Yes.
Yes, we have to file the another writ petition in the LB, my lord. For that
ಅದಕ್ಕೆ
purpose.
ಈ ಸೂಟ್ ಅಲ್ಲೇ ನೀವು ಎಲ್ಲದೂ ನಿಮ್ ಮನೆಯದು ಎಲ್ಲವನ್ನು ಕೆಲಸವನ್ನು ಇದ್ರಲ್ಲೇ ಕೇಳ್ಬೋದು.
Yes, yes, my lord.
Office objection
And
matter.
date may be fixed, my lord.
ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟು ಮೂವ್ ಮಾಡಿ.
Already trial court ಅಲ್ಲಿ are permitted to serve the notice to the.
ಅವ್ರ ಅಷ್ಟೊತ್ತಿಗೆ ಅಪಿಯರ್ ಆದ್ರೆ ex parte order ನೇ you can claim for a final disposal.
Yes,
That's all.
please.
Yes.
Office objection matter serial number 27 to 36 adjourn for orders serial number 37 MB Chandrachuda for petitioner.
Number 28.
Office objection, time is granted.
ಅಲ್ಲ ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ ಮಾಡಿ ಡೇಟ್ ಮಾಡಿ ವಿತಿನ್ 3.
ನೀವು comply tomorrow, you move day after tomorrow, I will take that. I am granted. I will, you whoever complied will see, person who wants to comply, you comply today itself. After that, move it, then you will take it that. Yes.
My lord, serial number 34 and 35, my lords.
Hmm.
I had taken the file for compliance, my lords. I have complied it, my lords, but there appears to be additional objections, my
We
lords.
will see, we'll see. If you
Kindly
want,
pass over, my lords. Kindly pass over, my lords.
we'll see now that, which is your matter, Mr. 36, no, 29 is pass over. Yes, 29, what is that?
Please.
Mr.?
29.
34 and 35.
Wait, madam, 29 were there.
One nimsha, sir, one nimsha.
27.
Jayakara Shetty H.
27, 1 week time is granted to comply office objection.
Proceeding officer as partner in the.
ಅವ್ರು ಕೊಡ್ರಿ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ 27 ಕೊಡಿ.
Serial number 27.
What is that?
14
objection?
person.
ಏನ್ objection ಇದೆ? The prayer to be stated properly, respondent not made a party, further verification the office raised. The proper jurisdiction and provision of law. There are so many other office objections, Mr. You comply, will grant week's time. Yes. You first comply, then only. Some of the office objection without complying, I can't hear that, Mr. You see, there are 4 office objections. You comply it, then I will take it that. Provision of law stated, not stated. Jurisdiction is not stated. That is office objection still, Mr. Yes. Week's time is granted to comply office objection.
Serial number 29, Jayakara Shetty H.
39, my lord, only prayer is, my lord, to direct the trial.
Office objection.
Office objection, my lord, there are 2. Attesting, my lord, notary has already attested it, my lord.
It is attested.
Attested in all the annexures, my lord.
Notary, then why that? Attestation.
And another is, my lord, the typed copy I have.
That's okay, but attestation, without that attestation of.
No, it has already been done. Notary has.
Even after that office has raised.
No.
objection.
Before that, I think they have not properly. Notary seal is there. It has done.
ಮಾಡಿದಾರಲ್ಲ. ಮತ್ತೆ office objection.
Here only prayer is, my lord, to direct the trial court to deal.
What is this matter, Mr.? Yes.
I am defendant number 2, my lord. The suit is for recovery of the OLT amount, my lord, by the first respondent plaintiff. And I have purchased the property, my lord, in the year 2012.
Now suit for,
Suit is for recovery of OLT amount, my lord.
then what is
Saying
the
that
stage?
there was some condition in the settlement of the
No, what is the stage now?
stage, my lord. I have filed IA, my lord, annexure G, ink page 85, my lord. In the year that is 23, 22, I have filed, my lord. Till today, no order has been filed, my lord.
What is that IA?
IA for vacating the injunction order, my lord, ex parte injunction order. So
80?
in all the dates, my lord, 2 here, 2 here, 2 here, 85, my lord. Ink page, annexure G,
85.
please.
Filed passed by the honorable court, please so and so. Yes.
IA number 4, my lord.
52. Where is that order sheet?
Order sheet is at ink page 52 relevant, my lord. Last typed copy, my lord. Hearing on IA number 224, my lord.
52.
52.
Yes.
Last date, my lord.
Hearing on IA number 2 to 4.
2
What
to
are the
4.
2 to 4?
2, 3 are all IA for injunction, my lord. 4 is my IA, my lord, for vacating. As early as possible, let the
This writ petition is filed by defendant number 2 under Article 227 of Constitution of India, seeking directions from this court
page 20 allide.
dispose of IA number 4
Annexure G.
filed under Order 39 Rule 4 of CPC. The plaintiff has filed a suit for recovery of money. The trial court has granted an ex parte injunction under Order 39 Rule 1 and 2. Immediately after service of summons, the defendant number 2, the petitioner has filed IA number 4 under Order 39 Rule 4 for vacating that ex parte injunction order dated 22/1/2020. The application is filed on 23/3/2022. As on today, no order has been passed. In view of the above, it is suffice for this court to direct that. Which court, mister? Trial court ಅಂತ ಬರೆದಿದ್ದೀರಲ್ಲ, we have not mentioned which court. ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಶೀಟ್?
Order sheet ink page 22, man.
Principal Civil
Principal Civil
Judge
Judge JMFC, Dakshina Kannada.
as expeditiously as directed to dispose of that IA number 4 filed under Order 39 Rule 1 and 2. 39 1 and 4 filed by the defendant number 2, petitioner defendant number 2 under Order 39 Rule 4 for vacating the ex parte injunction order 22/1/2022 as expeditiously as possible, not later than ಯಾವತ್ತಿದೆ next date?
ತಿಳ್ಕೊಂಡಿಲ್ಲ.
ಮತ್ತೆ not later than end of March 2025 in accordance with law. Submission is accepted, office objection is over.
Serial number 32 M Shivaprakash.
Yes, ಅದಿಲ್ಲ ಬಿಡ್ರಿ.
Serial number 34 Mithun GA.
Yes.
Krishna, my lords.
Hmm.
My lords, I have come.
Jurisdiction to be stated, deposit court fee has to be paid. How can you seek for an urgency
My lords,
without paying the court fee, madam?
My lords have paid, my lords.
When?
My lords, yes, deficit I paid it yesterday, my lords. In the other case, I've paid it today, my lords, the court fees.
Rank up the parties to be stated.
I have stated it, my lords.
Where is that? You complied, pass off, yes.
Please, my
Whatever it is not complied, you complied, yes.
grateful, my lords.
For order serial number 37, MB Chandrachuda for petitioner, Sujayendra Sridhar.
Steps for R. Yes, Mr. Chandrasud, what is that? Steps for deceased R2 to R8.
Delete ಮಾಡ್ಬಿಡ್ತೀನಿ ಅವ್ರು.
You want to delete them? ಕೊಡಿ. They are not necessary parties.
2, 8, 6, 11.
Learned counsel for the petitioner has filed in a memo for deletion of respondent number
2, 6,
2, 6
8, 11.
and 8. ಅಲ್ಲ 6 ಏನೋ ಸರ್ವಿಸ್ ಆದಂಗಿದೆ.
ಇಲ್ಲ.
ಆಗಿಲ್ವಾ? 2, 6, 8 and 11. Memo is taken on record. The respondent number 2, 6, 8 and 11 has deleted as a party in this writ petition. Learned counsel for the petitioner is directed to amend the past title.
Serial number 38,
Next
Didamalappa
week ಅಲ್ಲಿ
PM.
B group ಕಾದ್ರೆ ಉಂಟು.
Huh?
B group ಗೆ next week.
Next week, leave this matter next week. Yes.
Amend ಮಾಡ್ತಾರೆ.
Didamalappa PM.
Yes.
Waiting for the petition. A week time I will done.
ಏನ್ರಿ 2022 ಸರ್ವಿಸೇ ಆಗಿಲ್ಲಲ್ರಿ? 4th time steps to be taken for that 4th time service of notice to respondent, 3 times issued. Then you have to file in paper publication, Mr.
Please, ma'am.
4th time. Learned counsel for petitioner prays weeks times to do the needful.
Serial number 39, Rukoji Rao HS.
I appear for the petitioner, my lords. In respect of R4, my lords, it's unclaimed. So R4, it may be held to be served, my lords. Other respondents, my lords, I'm not pressing, my lords. I've
Notice issued to that respondent number 4 is written with post akshara unclaimed. Hence service R4 is held sufficient. File in a memo.
in my writ petition itself, in the note I've stated, my lords.
No,
that-
we file in a memo that.
I'll
notice-
file, my lords. Now I'll
this
give.
court once issued notice,
Yes, I'll file a memo.
what you want to delete,
My lords, I'm not pressing my relief against them, my lords. They're not, they're only,
you want to dispense.
yes, my lords, it may be
File in
dispensed.
a memo
notice.
seeking dispensation of notice to respondent number
3 and 5.
3 and 5, my lords.
3 and 5. Yes.
Serial number 40.
My lords, one submission, my lords, it may be taken up next week because the order transferring the matter to civil court is challenged, my lords, from commercial court
Yes,
to civil
next
court.
week.
Much of it.
Serial number
ಅದ್ರಲ್ಲ ಅವ್ರದಲ್ಲಿ entry ಮಾಡ್ರು granted earlier is extended till next date. Yes.
Serial number 40, 41 adjourned. Serial number 42, Vijay Kumar K for petitioner.
Submission. Serial number 40.
Hmm.
8 hours in the month, they didn't inform us. After 11:30, they are informing that.
You are appearing for whom?
Responded and we have filed IA for vacating stay in the previous date of hearing. Sorry, last year filed for it.
Rectification of office objection raised on IA number 1 of 20. No, there is an office objection on your application, mister. No, you, I have not seen the cost list. Then you have to comply that first. Next week.
ಬೆಳಿಗ್ಗೆ 2 weeks ಕೊಟ್ಟಿದ್ದೀರಾ senior appeal.
They, see, now that you have to comply office objection and then move that matter, we'll take it. Now, when you have 2 weeks are already adjourned, if it is complied, you move that matter, we'll take it. Yes.
Serial number 42, Vijay Kumar K for petitioner.
For the petitioner matter, so far as the respondent number 4 is concerned, it and the notice is returned unclaimed.
Yes, notice issued to that R4 is written with postal serra unclaimed. Service of notice to R4 is held sufficient.
R3, I will take necessary steps in 2 days, 2 working days, I will text.
Week's time is granted to do the needful in respect of R3.
Serial number 43 adjourned. Serial number 44, Aman Nalina Lingesh for petitioner.
I pay for petitioners, my lords. I may be permitted to take, give this notice to the trial court advocate, my lords.
Yes, week's time
Respondent.
is granted to do the needful. In
My
addition,
Interim
petitioner
order.
is permitted to serve a copy on the counsel appearing for the respondent before the trial court. Interim order granted earlier is.
My lords, may I request for a date? I've stayed my own suit in the,
No, that is true, but service is not completed. ma'am.
I'll serve it immediately. Next week, any date may be given.
No, you serve a counsel, it is not in a service. You have to take hand summons or process has to be completed.
May I
otherwise-
request for hand summons and trial, service by trial court?
In addition, the petitioner is also permitted to take out hand summons to respondent number 2. Yes.
Serial number 45, Vijay Shetty B.
For the petitioner, my lord.
Hmm.
I have paid the process, my lord.
Yes, learned counsel for the petitioner submits that needful has been done. Office to verify and proceed further. Yes. Service is not completed, madam. What to do with it? Yes, that. Now that R8 and R6, R8, you are taking notice. You are taking notice, then we can. Yes. Then what is that order they are challenging?
Compromise, the matter has been settled before the Lok Adalat.
Then they are also parties. Yeah, they're necessary.
Cell
Yes.
number 46 adjourned, cell number 47, Venkatareddy CM. Serial number 47.
Venkat Reddy.
The office objection will response 5 and 6, though they are not necessary parties. They have been made as parties by the plaintiff. Therefore, my lord,
Parties
have
of the
not made
lower
them as a
court
parties.
You're not made a party to this writ petitions to be clarified. The above objections counsel for. Now, who are that respondent number
My
6?
lord, the plaintiff has made me as well as those persons as parties to the proceedings.
No,
They
you
in
are
no-
the plaintiff or a defendant.
My lord, defendant's writ petition.
Defendant's writ petition. Suit for.
My lord, suit for permanent injunction. My lord, here is a suit, my lord,
Now, whom you have not made party?
5 and 6.
D5 or
Defendants
6.
5 and 6.
Even against them, injunction order.
Now the order is against all of them.
Then they are the necessary parties.
They are parties, my lord, they are not necessary.
No, that what is that order you are challenging?
My lord, the order passed by the trial court and confirmation of the same by the appellate court,
Injunction.
granting
Injunction.
temporary injunction in favor of the plaintiff.
They are not necessary parties because if he succeed, they will get benefit. But injunction order is benefited by only the plaintiff. You are the plaintiff now.
Yes.
Then you are the only necessary party.
No, one submission, madam. Order dated 23/2024 confirming the order of injunction has been challenged.
Yes.
Concurrent findings. And pursuant to that, to implement the order, police protection has been given, passed by, as per the order passed by the learned trial judge. And we have taken police protection and they have given statement stating that we will not interfere. I will place all those materials. My lord, it may be taken up. I will file my objection.
That is the case, will direct the suit itself.
My lord, what has happened,
Maybe
my lord?
disposed of,
Here,
my lord.
here, my lord, here is a, under the sale deed, my lord, no sale consideration has such has passed on. My lord, there is an averment in the sale deed that the amount has already been paid by way of check through Punjab National Bank. And my lord, to say, my lord, the sale consideration has passed on. My lord, no materials hitherto has been made by the plaintiff. Rashma, kindly just pass on the sale deed, my lord. Just, my lord, if the sale consideration has passed on, then my lord,
Possession ಕೊಟ್ಟಿದ್ದೇವೆ ಅಂತ ಹೇಳ್ತಾರೆ, separate suit and challenge ಹಾಕಿದ್ದಾರೆ.
judgment of the recent Supreme Court, my lord, if the sale consideration has not passed on, it is a null and void. Rashma, kindly see, my lord, page ನೋಡಿ 11,05,5 ಎಕರೆನ ಕಾಫಿ ತೋಟನ the sale consideration has been shown as 11 lakh, page 61, my lord. Rashmi, class 4, ಮಾರಾಟದ ಪ್ರತಿಫಲ ಪೂರ 11 ಲಕ್ಷ ರೂಪಾಯಿಗಳು ಒಂದನೇ ಪಾರ್ಟಿಯವರಿಗೆ ಎರಡನೇ ಪಾರ್ಟಿಯವರಿಂದ ಈ ಕ್ರಯಪತ್ರ ಬರೆದು ಸಹಿ ಮಾಡುವ ಮುನ್ನವೇ ಪಂಜಾಬ್ ನ್ಯಾಷನಲ್ ಬ್ಯಾಂಕ್ ಚಿಕ್ಕಮಗಳೂರು ಶಾಖೆಯ ಬ್ಯಾಂಕುಗಳ ಮೂಲಕ ಸಂದೇಹವಾಗಿರುತ್ತೆ. Let them produce, my lord. If there is a sale consideration through a national bank, Punjab, I have no case at all. Then another sale deed.
See, that is on the merit.
Therefore, my
Now that only thing is for injunction.
according to me,
Now
my
if
lord,
you have undertaken that, I will not do it. Then what else?
Police protection
as
has
per
been
section
ordered,
54.
that has not been
as per
challenged.
section 54 of
And
the,
they themselves have given under.
as per section 54 of the Transfer of Property Act, the recent judgment, if the sale consideration has not passed, it is null and void.
No,
that-
that is in respect of merit of your case. We are not on that degree passed by the trial court. Now that injunction is granted, now that you are undertaken before that first appellate court saying that we will
No,
not.
Not
Before
supported.
the
I have not
police-
taken, I have not taken.
For implementation, one second. For implementation of this
You
injunction,
produce that.
ಅದಕ್ಕೆ ಅದು ಎಲ್ಲವುದನ್ನು ಹಾಜರು ಮಾಡ್ಬಿಡ್ತೇನೆ.
Let there be an order of status quo.
No,
If
no.
he is in possession.
No, no,
Yes,
no.
my lord.
We are-
According
they are
to my
not in
learned friend.
possession.
Now, see, we will see what is that undertaken given before that. If you
Police.
are given an undertaking, then that has to be obeyed by that. When you have given.
Police protection has been given.
Therefore,
Kindly
my-
see.
if
What is his undertaking?
If, if there is, if
That
there,
we will implement the order of the court. We will abide by the order of the honorable.
Yes.
but there, I don't,
Petition-
but there is such a,
They themselves have given undertaking.
let them, let them produce.
You
my lord,
give
I
it
will,
that,
answer
produce
that
that.
point.
First one, my lord, the order passed by the learned trial judge ordering police protection.
No, I'm not, I'm asking that where is
That has not been challenged.
I three undertaken given by that, where is that, Mr.?
That has been given, my lord, on 33/2024.
ಆಯ್ತು ಎಲ್ಲಿದೆ
ಅದನ್ನ ಎಲ್ಲವುದನ್ನು ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೇನೆ.
ಅದ್ ಕೊಡಿ, ಅದನ್ನ ಹೇಳ್ತದೆ, ನೀವ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಕಾಪಿ
ಅಲ್ಲಲ್ಲ, ಅದನ್ನ ಎಲ್ಲವುದನ್ನು objection ಹಾಕಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಡ್ತೇನೆ.
21. You
1
produce
week
that.
time ಕೊಡಿ.
Yes. Is this matter 28th? Yes, you first produce.
Let
that
there be an order of status. My,
No,
if my
no.
learned friend has taken possession,
We have taken the.
See that what are that undertaken given, then we'll decide what order has to be passed. Yes. 28.
lordship may kindly overrule the office objection, let it be posted for preliminary.
Yes, submission of learned counsel for the petitioner is accepted, office objection is overruled. Yes.
Serial number 48, Ravi Shankar as per petitioner, government advocate.
Memo for dispensation of notice.
ಅದೇ last occasion, it is with regard to payment of court fee. The coordinate bench has already ordered. Order 7, it is an agricultural land under section 7 subclass 2
Yes.
of court fee. I have passed on the judgment of a coordinate.
Yes, Mr. There is there are similar circumstances, there is this thing. You'll put judgment, put. There also here suit
For cancellation of sale deed. There also suit for cancellation of sale deed.
Yes, Mr. You are appearing for?
Serial number 47, my lord.
48.
Now 48.
48,
Who is appearing for respondent?
government advocate.
ಇನ್ಯಾರಿದ್ದಾರೆ?
ಇಲ್ಲ, ಅದಕ್ಕೆ dispensation ಲಾಸ್ಟ್ occasion ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಗೆ ತಾವು ಡೈರೆಕ್ಷನ್ ಮಾಡಿದ್ರು.
Already you are the plaintiff.
I am the plaintiff.
Where is defendant?
ಡಿಫೆಂಡೆಂಟ್ ಗಿನ್ನ ನೋಟಿಸ್ ಹೋಗಲ್ಲ, FR ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಹೋಗಿದ್ದು.
Already defendant ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಗಕ್ಕೆ.
ಅಲ್ಲ, I am filed a memo for dispensation since since suit itself is not registered at the time of passing of the order. FR stage ಅಲ್ಲಿ ಆಗಿದ್ದು.
See, their rights to raise an objection will go, Mr.
ಅಲ್ಲ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹಾಕೊಂಡು section 11 ಅಲ್ಲಿ ಅವ್ರ ರೈಟ್ ಬರ್ತದೆ. Section 11 ಅಲ್ಲಿ
once I given a finding that court fee is correct, then they can't raise that.
Your lordship may kindly see the coordinate bench order. It is also at the stage of FR stage.
ಆಯ್ತು, FR stage ಆದ್ರೆ is then
ಅದಕ್ಕೆ
to be heard.
ಅಲ್ಲ ಬರೋದಿಲ್ಲ, ಯಾಕಂದ್ರೆ ನಿಮ್ ಸೂಟ್ ಅಲ್ಲೇ ಸರ್ವಿಸ್ ಆಗಿರಲಿಲ್ಲ ಅವ್ರಿಗೆ. ಸೂಟ್ ಸಮನ್ಸ್ ಇಶ್ಯೂ ಆಗಿರಲ್ಲ. Therefore, they are not necessary part at the time of ಇದು.
Even they have a right to object.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಅವರು your lordship may kindly see ಅವ್ರ ರೈಟ್ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಿದ್ರೆ they are at liberty to raise any objection under section 11 of the court fee suit violation act. 11 ಅಲ್ಲಿ ಅವ್ರ ರೈಟ್ ಬಂದೇ ಬರ್ತದೆ. ಆವಾಗ ಒಂದು ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ ಅವರು ಅಂಡರ್ 11 ಸಬ್ ಕ್ಲಾಸ್ section 11 ಅಲ್ಲಿ.
Can the trial court decide after this high court has given a finding that court?
ಮಾಡ್ಬೋದು. It is only at the stage of ಇದು. It is only in the FR stage. The court right there at the time of filing the suit, I valued the suit. If my valuation is not correct ಅಂದಾಗ the defendant will appear and file a written statement and took up a contention.
There is that finding of the trial court, this court saying that they can raise an objection at the time of. ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಅಲ್ಲ, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರಿಗಾರ್ಡಿಂಗ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಕೋರ್ಟ್ ಫೀಸ್ ಓವರ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಓವರ್ ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ. Your lordship may kindly see para 3 petition allowed, the impugned order so set aside. The office objection was raised by the registry of the trial court regarding valuation of court fee over. Registry of the trial court is directed to register the suit and post the said suit for appropriate court before so and so. Section 11 ಅಲ್ಲಿ ಅವರು ಅಷ್ಟು ಹಾಕಿದ ತಕ್ಷಣ ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಅವರು ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡಬೇಕಾದ್ರೆ. Section 11 is the statutory provision where the defendant can take up a contention.
Yes, thoroughly. That I will clarify that.
Hours.
Yes. This writ petition.
There are other 3 judgments for there, man. Coordinate bench.
Yes.
Where in agricultural land only it is only for.
Petition is directed against that. Impugn order dated 1/6/2024. What is that order? Next B.
Order on office objection with regard to the valuation.
Page number?
Page number 30, 32, my lord. Seven subclass 2, your lordship may kindly see. Seven subclass 2 of course is supervision.
No, this is after that, this thing. Where is that order, mister?
730,
Page number, Eldri.
page number 31, my lord.
31.
32 is the order.
Is it in the first stage?
FR stage. FR ಆಗಿದೆ ಆದ್ಮೇಲೆ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ they are registered this.
Pass an order dated 15. Order dated 1/6/2024. Vide annexure B, directing the petitioner to pay the court fee under section 38 of Court Fee and Suit Valuation Act. Passed by Senior Civil Judge JMFC Nelmangala in FR number 258 of 2024. Bernard Counsel for the petitioner has relied on judgment of this court in WP number 10681 of 2023, disposed of on 26 May 2023. On similar circumstances, the writ petition is allowed, the impugn order is set aside. Relied on judgment so and so and contended that similar circumstances, writ petition is allowed, the impugn order is set aside. In view of the above, this court in order dated so and so, paragraph 3 and this court order is extracted, para 3, 4 and 5. In view of the above, the writ petition is allowed, impugn order dated so and so is hereby set aside. The office objection raised by the registry of the trial court regarding the valuation of court fee is overruled. Post the said suit before that appropriate court for hearing overruled, and it is made clear that this order will not come in the way of the defendant to raise an objection under section 11.
11.
Court fee and suit violation. Come in the way of defendant to raise an objection
11 subclass 2.
under Court Fee and Suit Valuation Act.
5.
Yes.
Highly obliged.
Yes, mister. The connected matter court said, at this stage, it cannot be. Let them rise in that proper stage. That is- Yes.
Serial number
Please,
49.
49.
Government advocate also.
Please, and for the petitioner, madam.
Serial number?
49,
49.
Yatnal Parsappa.
Yes.
Please, madam, this petition for seeking a direction to the honorable lower court to
No,
dispose. by
you
suit.
furnish the PF process is not completed, mister.
I have filed application for a dispensation. It is merely asking for a direction. The suit is pending for last 13
Dispensation
years.
of whom?
Notice to seventh
What is that
respondent.
order you are challenging?
No, I'm not challenging any order, my lord. I'm seeking only direction of this honorable court. I have filed a partition suit, which is pending for last 13 years, my lord.
No, you
I
have,
filed a suit.
You have filed in a suit for what? Partition.
Suit for partition.
And then what is the stage now?
Now stage is for the defendant evidence, my lord. It is pending for last 4 years for the said purpose.
No, it is pending for?
Dependent's evidence for last 4 years. My lord.
Yes.
I have completed my part of evidence already.
Yes. This writ petition is filed by plaintiff under 227 of Constitution of India, seeking direction from this court to dispose of the suit OS number 3 of 2013, pending in the file of Second Additional Civil Judge JMFC Arkalgod Hassan as expeditiously as possible. The plaintiff has filed in a suit for partition and separate possession. After the appearance of the defendant, they have filed in a written statement. On the basis of the pleadings of the parties, trial court has framed the issue and plaintiff has completed his part of his evidence. Now matter is posted for evidence of defendant. Since suit is of year 2013,
Suit is of the year 2013, my lord.
hence the petitioner pray for early disposal of the suit. In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to dispose of the suit OS number 3 of 2013, pending in the file of Second Additional Civil Judge, Junior Division, JMFC Arakulgod, as expeditiously as possible, not later than 1 year from date of receipt of copy of this order.
Serial number 50, Venkatesh S. Arabatti for petitioner.
Rectification of the office objection, Mr. Yes.
We filed a application for rejoinder after the written statement was filed.
Who has filed the wakalat for R1 to R3? What is that office?
But I'm I appear for R7 and R8, Milord. I have to file my wakalat.
You have to file a wakalat.
Please, Milord, for R7 and R8.
Who is for R1 to R3?
I am for 5 and 6.
R1 to R3 yaridare? Deepak. Something, some office objection on this,
Oh,
on that
sorry.
wakalat. Yes. Where is that Deepak? Yes, what is that? We'll have it some other day.
Please,
after his
Milord.
presence.
Even
Yes,
if it's not complete, my lord, the
yes, yes.
process itself is not complete.
Yes.
Milord.
Now all that other respondent is there.
Wakalat.
None appear for respondent number 1 to 3. Office objection on wakalat filed by that respondent number 1 to 3. Week's time is granted to rectify that office objection.
Serial number 51, Patil GS for petitioner.
Non-ratification of office objection on IA vacating.
For the
Yes.
petitioner, my lord. I have received the copy
Application
today.
for vacating the interim order is filed.
Hmm.
In fact, we have served.
I have received today, I have received the copy.
Today. Yes, when do you want? What is that injunction stay?
Regarding easement rights, revising of right of way.
Right, we'll hear that. Are you ready?
And kindly pass it over.
And when do you want?
And then,
Which date you want, mister?
is it 21st, Milord?
Huh?
21st.
20?
21st,
Yes, Milord.
not 21st, 22nd, mister.
Aye.
Yes, at the request of counsel for learned counsel for the
Office
petitioner pays
objection
time to.
overruled.
ಅದ್ ನೋಡಿ ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ vacating.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತಲ್ಲ ಇನ್ನ
ಅಲ್ಲ ಅದೇ ಇದ್ರೆ ವಿಲ್ ಸೇ ದಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್ ಕಂಪ್ಲೇಂಟ್.
Copy. Served, has been not filed.
Yes, learned counsel for the petitioner submits that he has received IA copy, IA number, copy of IA number 1 of 2024.
Yes.
Hence, office objection is overruled. Counsel for the petitioner press weeks time to file objection to IA 1 of 2024. Hence, post this matter on 22nd.
Interim kindly extend. Interim order is
Order
there.
granted earlier is extended till next date of it.
See, by making use of the interim order,
Hmm.
they have removed the jink sheets which have been erected.
Let us see on that.
No,
next.
my lord.
Yes,
Yes.
we have blocked the road actually.
What is that interim order?
Lord, they have not to block the passage road. It is common passage
Let
road.
us
road.
see, let us see on
Yes,
that 23rd.
road.
Serial number 52, Rupesha B.
Pay for the petitioner.
Hmm.
My lord. We had taken the process for the R4, my lord. And also the meanwhile, this honorable court has directed to serve a copy on the learned counsel who is appearing before the trial court.
You are appearing for whom?
In this matter, my lord, I am appearing for 3 and 4, man.
You will take
Today I
notice.
file a wakalat, man.
for
Can you
taking-
put up this?
My lord,
Yes. So,
There- There is urgency in this matter, my lord, because my lord, this is a writ petition which has been filed by an impleading application, proposed impleading application. The application which has been filed by the defendant number 3 and 4 has came to be allowed by the trial court
We have it on next week, my lord. Any date, may be.
because because
he's now he has
ಅಲ್ಲ,
appeared.
ನನಗೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಕ್ಯಾರಿ ಔಟ್ ಹಾಕಿದ್ರೆ ಮತ್ತೆ ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಇನ್ಫೆಕ್ಚಸ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ ಇನ್ನೇನು.
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರ ಇಲ್ಲಿ?
ನನ್ನನ್ನು ಪಾರ್ಟಿ ಮಾಡೋದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ. ದ ಅಪ್ಲಿಕೇಶನ್ ವಿಚ್ ದೇ ಫೈಲ್ಡ್, ದ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದ ಅಪ್ಲಿಕೇಶನ್ ಟು ಇಂಪ್ಲೀಡ್ ಮೀ ಆಸ್ ಎ ಡಿಫೆಂಡೆಂಟ್. That has came to be allowed, that has been challenged.
Challenge. You are saying that you are not a necessary party.
Yes, ma'am.
ಆಯ್ತು.
As per the own pleading, my lord, the partition has been took place
Now
between.
what is the stage there?
Now it is for the amendment of the.
ಮಾಡ್ಲಿ ಬಿಡಿ. If
ಅಲ್ಲ.
this application is allowed, then you are been striked out as in a party. Why do you want? Yes.
One date fix ಮಾಡಿ.
Yes, learned counsel. So and so learned counsel undertake to appear for respondent number 3 and 4. Office is directed to show his name. He requests week's time. Leaves this matter on 28th. Yes.
ಮತ್ತು
Serial number 53, adjourn. Serial number 54, Lakshmana SP for petitioner.
Please, I have to party. Yes, my lord.
For respondent.
Awaiting reply report from that Manoj Gowda, Devanalli. What is this, mister?
ಏನಾಗಿತ್ತು ಅಂತಂದ್ರೆ ನಾನು ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಕೇಳಿದ್ದೆ ಸ್ವಾಮಿ, ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಆರ್ಡರ್ ಮಾಡ್ತು. ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅನ್ನು ತಗೊಂಡು ದೇವನಹಳ್ಳಿ ಕೋರ್ಟಿಗೆ ನಾನು ಸರ್ವ್ ಮಾಡಕ್ ಹೋದ್ರೆ ನಾನು ತಗೊಳ್ತೀನಿ, ನಾನು ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಕೊಡಲ್ಲ ಅಂತ ನಾನು ಅಫಿಡವಿಟ್ ಹಾಕ್ತೆ. ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದಾದ್ಮೇಲೆ ಅಗೈನ್ ದ ಮ್ಯಾಟರ್ ಹ್ಯಾಡ್ ಕಮ್ ಅಪ್ ಬಿಫೋರ್ ದಿಸ್ ಆನರಬಲ್
No,
ಕೋರ್ಟ್
hand summons to whom?
ಟು ದಿ ಕೌನ್ಸಿಲ್ ಹೂ ಇಸ್ ಅಪೀರಿಂಗ್ ಫಾರ್ ದಿ
ಎಲ್ಲಿದೆ?
ರೆಸ್ಪಾಂಡೆಂಟ್.
ಕೌನ್ಸಿಲಿಗೆ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಕೊಡಕ್ ಎಲ್ಲಿದೆ ಮೇಡಮ್?
ಅಲ್ಲಲ್ಲ, ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಕೌನ್ಸಿಲ್ ಅಪೀರಿಂಗ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಬಿಲು.
ಅವರಿಗೆ you can seek a permission to file the survey copy.
ಹೌದು,
How can you take any hand summons to that council?
ನಾನು ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಕೊಟ್ಟು ಆರ್ಡರ್ ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ.
Where is that? How can you issue a hand summons to that council? How he is responsible, madam?
ಅಲ್ಲ ಅವರು
When that order has been passed,
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್
issue court notice to the Manoj Gowda Devanalli as to why action should not be initiated against him for not accepting the notice. Learned counsel for the petitioner submitted the advocate who present one before the trial court has refused to acknowledge the receipt of the notice. Where is that notice?
ನಾನು ಹಾಕಿದ್ದೀನಿ ಸರ್.
Memorandum
We have
notice
filed
in
wakalat for R1 to R5.
I filed it on 11/11/20.
ಸರ್ವ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸರ್ವ್ ಅಂತಂದ್ರೆ ದಿಸ್ ಥಿಂಗ್. ನಾವು ಯು ಆರ್ ಅಪೇರಿಂಗ್ ಫಾರ್ ಹೋಮ್.
R1 to R5 minutes. ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದೀವಿ.
ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದಾರಾ?
Yes, ma'am.
Yes. Now service is completed.
Please, please.
Yes. What is this matter?
The matter is, my lord,
Ready?
Let's start accommodation.
When do you want?
Next week.
ಅಲ್ಲ ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ 23 ಸ್ವಾಮಿ.
Yes.
Matter is of 12 years old, my lord.
Now that service is completed, all this is not necessary
Please.
because yes. Learned counsel appearing for respondent number
1 to 5.
1 to 5. 6 weeks time, leaves this matter on 22nd.
Please, ma'am.
Serial number 55, yes, Ganesh Shanai for petitioner.
Appearing for petitioner in this case.
Right.
We have served the copies to R1 and R3 and also to their respective councils.
For R3, my undertake file. R3.
R3. What about R1?
R1 is placed ex parte in the pending suit, man.
What you want now? You want to that dispense or you want to take notice or you await for service? Huh?
R1 get dispensed.
Who is R1?
R1 is one, Milan M. Parekh. He is the respondent number 1 in the pending suit.
Suit for?
Suit for declaration of JDA as cancellation of JDA and declaration of GPA as terminated.
What is that order you are challenging?
We are challenging the order of IA number 1 of 23 and IA number 1 of 24 filed by
one BHEL and Lakshman for impleading them as the parties in the suit.
That has been allowed.
That has been allowed.
Then that R1 is not a necessary party. You file in a memo.
My lord, seeks time to file objection.
Wait, I will grant. First, let that service complete. Learned counsel for that petitioner has filed in a memo seeking dispensation of service of notice to R1. Memo is taken on record. Notice to R1 is dispensed at the risk of the petitioner.
Interim order may kindly be extended.
What's your name? Srinivas?
No, GK Bhavana undertakes.
DK?
GK Bhavana undertakes to file.
So and so learned counsel undertake to appear for respondent number 2 and 3.
No, only 3, my lord. Respondent.
3 na?
Yes, ma'am.
2 ge? 2 ge ಏನಾಗಿದೆ?
Caveat ಹಾಕಿದ್ದು.
2 ge
So it is a caveat, my lord.
Who is Srinivas DC?
Cell number 55, Srinivasa DC.
Yes, anyhow, caveator is there. Yes. Undertake to appear for R3. Lease this matter next week. Interim order granted earlier is extended till next year.
Cell number 56, BM.
Lease this matter after 2 weeks.
Appearing for the petitioner.
Yes.
In this case, I have served the notice on the advocate who is appearing for the respondents hearing before the trial court. And also I have taken steps to service them.
That, service is awaiting, Mr. Await service of notice.
Here, what is peculiar case is that, my lord.
Notice
Yeah,
complete agle.
Please.
Yes. Await service of notice.
Cell number 57, Nayanatara BG for petitioner.
Petitioner on this matter, my lords.
Where is that respondent? There is an office objection on IA.
Please, my lords, it's that they have not solved it on me. I've got a copy.
But where is he? He is not there. Yes, none appear for the respondent. Please this matter after 2 weeks.
Please, my lords, the interim order may kindly be.
Interim order granted earlier is extended till next date of hearing.
I'm deeply.
Cell number 58, G Balakrishna Shastri for petitioner.
Yes, Shastri.
For the petitioner, my lords.
Non-compliance of the office objection along with counsel submission. What is that?
Please, my lords. One is statement of objections to IA to be filed, my lord.
MA 7 of petition copy to be filed along with the statement of objection. Yes. MA copy have you filed?
It's not required, my lords, for the adjudication of this
No.
matter.
Board should, office should request to see that who are the parties, what is that charge. It is not for your requirement. Office to see that office.
Judgment is there. MA order has been produced here with.
Appeal ಯಾರು ಹಾಕಿದ್ದಾರೆ?
Appeal now.
ಅದು ನಿಮಗೆ ಗೊತ್ತಿರ್ತದೆ ಅವ್ರ ಆಫೀಸರ್ಗೆ ಏನ್ ಗೊತ್ತಿರ್ತದೆ. That is why they need that MA copy.
But since we have filed the appeal, my lords, since we have filed the MA, and the MA grounds are also available in the order,
You
petition copy would not be required. That is our.
No, you can seek for a time to produce, but you can't say that office not required when there is a rule prescribed, they have to ask for that. Now, what is this matter?
Temporary injunction, my lords. But,
Suit for?
Suit for permanent injunction. It may be heard in another date, my lord.
Request.
Please.
Yes, when do you want, Mr.
A statement of another submission may be accepted, my lords. Statement of objection to IA, if any, to be filed. It is point number 2.
ಯಾವ್ದು ಇಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ?
ಅದು written statement has been accepted as statement of objection to IA. Page number 37.
ಅದು ಆ ತರ ಬರ್ದಿದ್ದೀರಾ?
ಹಾಗೆ ಹೌದು.
ಅದನ್ನ ಫಸ್ಟ್ ಇದ್ರ ಜೊತೆಗೆ MA ಕಾಪಿ ಕೊಡಿ. In the meantime, you will accept it. When do you want?
Next week, my lord.
Next week.
Date.
Yes.
Date may be fixed.
Yes, at the request of the parties, leave this matter on 27th.
Please.
27, yes.
Cell number 59, Nandish Patil.
Lord, I appeal for petition, my lord.
Yes.
Lord, your lordship may grant me week's time, my lord.
Yes, week's time is granted to do the needful.
Interim order may be continued.
Siddaramaya.
Interim order granted.
Please, obliged.
Memo for dispensation.
R1.
Why you don't want?
Not a necessary party. No relief is sought against R1.
Notice to R1 is dispensed. Awaiting service of notice to R4. Yes.
Cell number 61.
My lord, interim order may kindly be extended.
Interim order granted earlier is extended till next date of hearing.
Cell number 61, Shakil Ahmad.
Complaints of office objection, Mr.
My lord, there is urgency in the matter, my lord, because delivery warrant has been issued, my lord. I completed the office objection yesterday, my lord. The rest of the office objection I undertake to comply, my lord.
Legible copy of the annexure, judgment, debtor, execution, so on, so.
Yes,
Are
yes.
not parties to that writ petition to be clarified. Why you have not made a party?
My lord, because I request the lordship to
Huh?
consider Annexure A, my lord. That
It has
page,
not been made as a party, judgment debtor.
yes, my lord,
Who do
they are
you-
my sellers, my lord.
Huh?
They are my sellers, my lord. I request the lordship to consider Annexure A, my lord, page
You
number
are a degree
26.
holder.
Yes, my lord.
What is
I am
that
not,
order you are
my
challenging
lord, my
here?
lord, I am challenging the order passed by the first additional court, my lord, rejecting my IA, your honor, my lord.
Yeah.
IA under order 29, rule 97, it was filed, my lord, by way of objector. Because
You
I am
are-
a bona fide purchaser of property, my
You are
lord.
an objector.
Yes, my lord, my application has been rejected, my lord. I am in possession of property, my lord, as I have purchased the property during pendency of the execution proceedings. I request the lordship to consider Annexure A, my lord, page number 26.
No, on what ground you are filed an application as an objector?
My lord, I have purchased the property from the sellers, my lord. That is the judgment debtors in execution proceedings, my lord.
You have
During-
purchased that property when?
That is in the year 2021, my lord.
After that execution petition.
During the pendency of the execution proceedings, my lord.
How can you purchase that, mister?
My lord, that fact has been suppressed, my
There is
lord.
no end.
No, my lord.
When that judgment debtor is aware that I is going to lose, then he will alienate the property and create third party.
My
Then you
lord,
are coming that.
one submission, my
cannot
lord.
be-
One
that
submission,
You
my
can't
lord.
stalling that decree by selling that after you impleaded,
My
then
lord,
you will sold the
my-
property to
I'll-
that other.
one submission, my lord. My lord, the suit is filed by the respondent, my lord, for this relief of specific performance against my vendors, my lord. The suit was decreed, my lord. As per the decree, my lord, sale deed was executed through the commissioner. And with regard to delivery of possession, my lord, they have filed execution proceedings. During the proceedings of execution, my lord, the judgment debtors, they have sold the property to me, my lord.
That cannot be.
I am not,
Otherwise, the
my
decree
lord-
cannot be executed.
my lord, I am unaware, my lord.
Tomorrow, that is for you to
My lord, I am a bona fide purchaser, my
go
lord.
and claim against that vendor.
My lord, I have
After
filed,
filing an
my
execution
lord, I have filed a
petition.
suit also, your honor.
No,
My
this
lord.
is encouraging that person who are playing a fraud.
My lord, Annexure D, my lord.
Cannot be stated, mister.
My lord, Annexure D, my lord.
If you are an earlier purchaser, then it is true. You are purchasing after the execution petition is filed. Show me that even person who has purchased during the pendency of the execution petitioner, he can file an application for objector and is a necessary party. You show any judgment, I will entertain. You show me that, otherwise you will be impleaded. Tomorrow, again that warrant will be issued. In the meantime, you will sell that property to somebody else. He will come before the court.
One submission, my
Then-
lord. One submission, my lord.
Yes.
That I have already filed a suit, my lord. That decree is not binding upon me. That is pending before the
You
same
go
court.
and get a stay in that suit.
My lord, still it is pending for issuance of notice, my lord, to implement the parties, my lord. In
No,
the mean-
you can get an ex parte, you
No.
seek for that and you
My lord,
challenge.
my lord,
Here,
in the meantime, my lord, delivery warrant has been issued, my lord. I am in possession of property purchase the sale deed, my lord.
No,
I am going to lose my position, my lord.
see, you have failed to get ex parte degree there.
Yes, my lord.
Then you challenge it before that court
My
where
lord,
we are
I'll
available.
I'll make necessary steps, my lord, by filing an IA, my lord, on more application. In the meantime, my
No,
my
you convince
position
me,
needs to
you
be protected, my lord.
see, objector, person who is in the position is necessary party, but person who has purchased after the execution can be filed an application, objector is necessary party. Show me the judgment, I will take that matter. Not only take that, I will grant an interim.
My lord,
You convince me on that.
during pendency of the execution proceedings, my lord, suppressing the fact of earlier decree, my lord, my vendors have sold the property to me.
It is suppressed by you vendor, your vendor. Why the degree holder has to be suffered, mister?
My lord, I am unaware, my lord, is a bona fide purchaser of purchase the
You
property.
don't know that when you are purchasing, you should be aware. Otherwise, you go and file against
My
that.
lord, based on the agreement of sale which is unregistered, my lord, a decree was obtained,
No,
my
you
lord.
claim all damages and all against your vendor.
In the
Anyhow,
meantime,
you have filed in a suit.
my lord, in the
But
meantime,
Now, first thing, yes, you convince me with the judgment saying that you can be a objector if you purchase during the pendency of the execution. Definitely, I will entertain.
the reason assigned.
No, you convince me on that question of law, then I will consider that.
One week's time may be granted.
Yes.
By Tuesday or Wednesday.
Yes, even tomorrow I will grant, but you have to convince, yes, leave this matter on Tuesday,
Tuesday, better, so Wednesday.
Wednesday, yes. If you convince that, then I will consider for interim prayer, yes.
Submission. My lord, in serial number 45, there will be an interim order, my lord. In serial number 45, there will be an interim order, madam. It may be kindly extended, my lord.
Why you have not asked when that matter is called?
Due to oversight.
ಏನಾಗಿದೆ ಅದು?
Sir, needful status have been done, office to.
ನೋಡಿ entry order, if there is any entry order extent.
ದಿವಸ ಒಬ್ಬೊಬ್ಬರು ಬರ್ತಾರೆ. ಕರೆಕ್ಷನ್ ಇರುತ್ತೆ, ಯಾರಿಗೆ ಗೊತ್ತಾಗುತ್ತೆ, ಯಾರು ಬರ್ಲೇ ಇಲ್ಲ. ಮೇಡಮ್ ರೆಗ್ಯುಲರ್ ಆಗಿ ಬರೋದು. ಸರಿ. ಆಮೇಲೆ ಬಾ ಡಿಸೆಂಬರ್ಗೆ ಹೋಗಿ.
ಬೇರೆ ಒಂದು ಲಿಸ್ಟ್ ಇದೆ ಅಡ್ಮಿಷನ್ ಅಂತ 10 ಬರ್ತೀರಾ?
ಸರ್ ಇದು ಲಂಚ್ ಆದ್ಮೇಲೆ
ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ.
ಇದೆ 62 only. Total 11. ಅದಕ್ಕೆ ಬಿಟ್ಟು ಅದು ನೋಡಿ ನೆಕ್ಸ್ಟ್ ನಮ್ದೇ ಅಷ್ಟೇ ಬಂದಿದೆ. ಒಳ್ಳೆ ಕೊಲಿಜಿಮ್. ಕೊಲಿಜಿಮ್ ಅಲ್ವಾ?
ವಾಚ್ ಮಾಡ್ಬೇಕು. 57 2 weeks ಹೋಗಿದೆ.
ಸರ್ ಲಾಯರ್ ಹೇಳಿದ್ರು ಅವ್ರು ನಿಮ್ಮ ಹತ್ರ ಕೇಳಿ ತಂದ್ರು 649/2010 ಫೈಲ್ ಕಳ್ಸಿದಾರೆ ಕೆಳಗಡೆಯಿಂದ ನಾಳೆ ಏನೋ ಬರುತ್ತಾ ಅಂತ RF.
ಬೋರ್ಡ್ ಹೋಗ್ಬೇಕು ಸರ್, ನಮಗ್ ಗೊತ್ತಾಗುತ್ತೆ. ಬೋರ್ಡ್ ಹೋಗ್ಬೇಕು, ನಮಗೇನ್ ಗೊತ್ತಾಗುತ್ತೆ?
ಅಲ್ಲ ಅವ್ನು
ಲಾಯರ್ ಹೇಳಿದ್ರು ಹಂಗಂತ ನನಗ್ ಕೇಳು ಅಂತ. ನಾನು
ಲಾಯರ್ ನಿಮ್ಗೆಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ದು ಅವ್ರು ಕೇಳಿದಕ್ಕೆ ಅವ್ರು ನಿಮ್ಮನ್ನ ಕೇಳಿ ತಂದ್ರು.
ಬೋರ್ಡ್ ಹೋಗ್ಬೇಕು, ಬೋರ್ಡ್.
ಬೋರ್ಡ್ ಎಲ್ಲಿದೆ ಸರ್?
ಬೋರ್ಡ್ ಕೆಳಗಿದೆ, ಯಾರನ್ನಾರು ಕೇಳಿ.
ಕೆಳಗಡೆ ರೆಕಾರ್ಡ್ ರೂಮ್ ತಾನೆ.
ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಅಂತ ಕೇಳಿ ಯಜಮಾನ್ರೆ, ಇಲ್ಲ ನಿಮ್ ಲಾಯರ್ ಕೇಳ್ಬೇಕು. 34 35 ಕೊಟ್ಟಿದ್ದೀನಿ, ಕಂಪ್ಲೇಂಟ್ಸ್ಗೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಕೆಲವರು ಲೋಕೇಶ್ ಅವರು ಹೇಳ್ತಾರೆ.
நடராஜன் போடலாம். அவங்க சேர்.
Sir, memo. Serial 55. One medical.
Very custom. Date any. ಹೇಳ್ತಾರೆ. ಇಲ್ಲ ಅಲ್ಲ ರೆಕಾರ್ಡ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಅದೊಂದು ಮೆಮೊ ಕೊಟ್ಟು ನೋಡು ಅವ್ರು ಯಾರು ಫೋನ್ ಮಾಡಿದಂತ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಬಂದಿಲ್ವಾ ಕಂಪ್ಲೇಂಟ್ಸ್? ಇಷ್ಟು ಪಾಸ್ ಕಂಟಿನ್ಯೂ
Court officer. Court officer.
ಹೇಳಿ ಯಾರು?
Sir, serial number 50 ಏನಾಯ್ತು sir?
1 week ಸರ್.
ಅಜ್ಜನ ಆಯ್ತಾ ಸರ್? ಏನು ಆರ್ಡರ್ ಏನು ಪಾಸ್ ಆಗಿಲ್ಲ ಅಲ್ಲ?
1 week ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಓಕೆ. ಟೂ 230 ಅಂತ ಸಪರೇಟ್ ಇದೆ ನೋಡ್ಬೇಕು ಸರ್ ಏನ್ ಹೇಳ್ತಾರೆ.
ಎಷ್ಟಿದೆ 230?
39 ಸೈನ್ ಆಗೋಗಿ ಒಟ್ಟೋಗಿರುತ್ತೆ ಸರ್. ಮಧ್ಯಾಹ್ನ ಎಲ್ಲ ಸೈನ್ ಆಗಿದೆ. 39 ಬೆಳಿಗ್ಗೆನೆ ಆಗಿರೋದು. ಮೆಮೊ ಮೂವ್ ಮಾಡಿ ಅಂತಾರೆ ಅಷ್ಟೇ. ಸೈನ್ ಆದ್ಮೇಲೆ ತಿರ್ಗಾ ಆಲ್ಟರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಮೆಮೊ ಮೂವ್ ಮಾಡಿ, ನಿಮ್ಗೆ ಯಾವ ಡೇಟ್ ಬೇಕೋ ಆ ಬೆಳಗ್ಗೆ ಮೆಮೊ ಮೂವ್ ಆ ಡೇಟಿಗೆ ಹಾಕೊಂಡು ಅಂತ ಎಲ್ಲ ಅವ್ರಿಗೆ ಹೇಳಿ ಆಮೇಲೆ ಅವ್ರು ಏನ್ ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ ನೋಡಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಕೆಲಸ ಆಗಲ್ಲ ಅದನ್ನ ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಹೇಳಿ. ಸರಿ ಸರಿ. ಯಾಕಾಗ್ತಾನಪ್ಪ ಹಾಕಲ್ಲ ಓದಕ್ಕೆ. ಯಾಕೆ ನಾನು ಅಸೋಸಿಯೇಷನ್ ಪ್ರೆಸಿಡೆಂಟ್ ನಾನು ಸಾಹೇಬ್ರಿಲ್ಲ ನಾನು ನನ್ನ ಹಾಕ್ಲಿ ಒಂದೇ ದಿನನೇ ಸಿಗಾಕೋಣ ನಾನು ಓದಕ್ಕೆ. ಎಲ್ಲ ಆರಾಮಾಗಿದ್ದ ಎಲ್ಲೂ ಹಾಕಿಲ್ಲ ಅವನೇ ರಜಾ ಹೋಗ್ಬಿಡ. ಮೆಂಟಲ್ ಕೆಲಸ ಇದೆ ನನಗೆ, ಡ್ಯೂಟಿ ಮೇಲೆ ಇಲ್ಲ ರಜೆ ಕೊಡು. ಇನ್ನ ಬಿಟ್ಟು ನನ್ನ CPC ಮಾಡ್ಕೊಂಡು ಕೆಲಸನ ಮುಗಿಸ್ಕೊಂಡು ರಜೆ ಕೊಡು ಹೇಳ್ತೀನಿ. ರಜೆ ಹೋಗ್ತಾ ಇಲ್ಲ ನಾನು ಏನೇ ತಿಂಗಳ ಅಂದ್ರೆ ಆ ಮೊದಲನೇ ದಿನ ಯಾವಾಗ ನಾನು ಓಡಾಡ್ಕೊಂಡಿದ್ದ ಹಾಕ್ಲಿ ಅಂದ ಸ್ಟೇಷನ್ ಕೋರ್ಟ್ ಹಾಕೊಂಡು ಅವನ್ನ ಇರಲಿಲ್ಲ ಮಾಡಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ಅವತ್ತು ಬಿಡು 10 ಗಂಟೆ
ಅವನು ಇಲ್ಲ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾನೆ ಅವನು ಇಲ್ಲ ಆದ್ರೂ ಬಂದು ನಿಲ್ಲಿಸ್ಕೊಂಡು ಸ್ಟಾರ್ಟ್ ಮಾಡಿರೋ ಜಡ್ಜಿನ ತಳ್ಳ ನಾನೇನು ಸುಮ್ಮನೆ ಕೋರ್ಟ್ ಗೀಟ್ ಎಲ್ಲ ಹೋಗಾಡ್ಕೊಂಡು ಲಾಸ್ಟಲ್ಲಿ ಗಂಟೆ ರಾತ್ರಿಯಲ್ಲಿ
ಸಾರಿ ಏನು ಜಾಸ್ತಿ ಇಲ್ವಾ?
My lords, humble submission, my lords. My lords, in serial number 39, my lords, it was told that to list after a week, my lords. In that, I need a specific date, my lords, so that we are seeking for a transfer from Bangalore Rural Court to Commercial Court, my lords.
ಇದು process complete ಆಗಿಲ್ಲಲ್ಲ. You have to pay that process. For that only we are granted time to take steps.
Okay, one particular date, my lords.
After service, you move that matter. Yes. At 2:30 correct. Yes.
Like a bad coin, my lord, this has come back.
Yes, yes.
It often happens, my lord, we say, bad coins keep coming back to us. My point is very narrow, my lord.
Yes.
The lordship should take this review petition 226.
226, yes.
Page 56 is your lordship's order, my lord.
Yes.
Kindly go to page 62, my lord. The compromise, my lord, having been accepted by your lordship's, my lord,
Yes.
and the appeal having been disposed of,
Yes.
an application was filed, my lord, by certain persons claiming to be relatives of the founder of the trust. And they, my lord, said that this compromise is not fair, not legal, so it should not have been accepted. And this is the argument, my lord, that they addressed at page 62,
Yes.
para 4, my lord.
Yes.
Firstly, the first petitioner is the daughter. Second, third petitioners are great-grandsons of so-and-so.
Yes.
They are persons interested in the trust. Trustees of the second respondent trust acted contrary to the objects of the trust, were transferring properties of the trust. They were misappropriating funds of the trust. My lord, please note this.
Yes.
So these people are not trustees. They are claiming to be lineal descendants
Yes.
of the founder of the trust.
Yes.
And the trust, my lord, was formed some substantial period ago, some about 25 years ago.
Yes.
And now, my lord, till the time they file this application, they file before this one miscellaneous application under section 92. And that is, my lord, before the lower court.
Yes.
Now, in this proceeding, my lord, parallelly, they're trying to raise this, to say that the trust is misusing the properties. Now, I'll show your lordship what the resolution was, my lord, which was before the court. Therefore, the second and third petitioners have filed a suit before the principal city civil judge, Bengaluru, seeking the removal of trustees and appointment of new trustees. They have also filed miscellaneous petition under 92, seeking leave of the court on 4/7/22. When the same was pending, respondents herein filed a compromise petition in RFA 1294,
Yes.
contrary to the object of the trust. Hence, petitioners have filed this review petition.
Yes.
Secondly, petitioners are persons interested in the trust. They are aggrieved by the order passed by this court in RFA number 127494 of 22, dated 15/2/23. Hence, they filed the review petition, since they cannot file a suit challenging the compromise petition, as the same is barred under Order 23, Rule 3A. In support of the contentions, he relied on so-and-so, so-and-so. This is the second argument. First argument was that we are misusing, the
Yes.
trustees are misusing. Second is that there was a suit filed, not my client, not I am the person, my lord, who has an agreement to sell with the trust. And I have, my lord, paid substantial part of the consideration, and I am in possession of the property. All these are not in dispute. When I filed for specific performance, the court, my lord, rejected that suit on the ground of delay, on the ground, my lord, of the plaintiff there was a firm, and the firm was not registered. The technical objection. That was upheld by this honorable court, my lord, in the RFA. Therefore, I had to perforce file another suit referring to the earlier proceeding, and the trust, the partnership firm having been registered,
Yes.
I have a right now to file the suit, and that was the case in which I came.
Yes.
Now, in that, my lord, an application was filed in Order 7, which came to be allowed. So RFA is admitted, appeal is pending before the court. So the argument is that since that delay was there and since the suit was dismissed, there's nothing before the court, though the RFA was pending. Not that's how they put it. And third point. Thirdly, in the suit filed by the first respondent, the application is rejected as not disclosed the cause of action and barred by limitation. Hence, the court, without deciding as to whether the suit is barred or not, cannot entertain a compromise petition. The order and review was passed by this court is without jurisdiction. It is also reiterated Section 3 of the Limitation Act contains the suit claim is barred by limitation. It touches on the jurisdiction of the court unless the court holds suit is filed within time. Even though parties have agreed to settlement, compromise decree cannot be passed. In support of the contention, he relies on judgments of so-and-so. Fourthly, my lord, suppression of material fact. This is the point on which your lordships, my lord, allowed the review filed by them. Fourthly, while filing the compromise petition, respondents have suppressed material facts from this court. Even though it is stated in the compromise that after executing the sale agreement dated 13/6/84 in respect of 6,000 square feet in favor of first respondent, that's my client, The remaining extent of land will be retained by the trust. They have not disclosed to this court that they are going to alienate the remaining extent of the land to a third party. Now, please mark this. This is the finding of your lordships at the end of the order.
Yes.
My submission is this contention is completely wrong because I'll show from the compromise petition in the papers file.
Yes.
There is a resolution that the trustees need this money.
Yes.
They want to use the sale proceeds for charitable objects.
Yes.
And they have disclosed clearly that they have entered into agreement. All the disclosures are there, but the contention is not disclosed.
Yes.
On the same day, on 15/2/23, respondents 2 and 3 alienated remaining portion of the property in respect of third parties. Hence, he contended that the compromise petition was filed with mala fide intention to misappropriate funds of the trust. It's against the interest of the trust.
Yes.
Not one aspect, my lord, needs to be borne in mind. The total area, my lord, of this property is 16,441 square feet.
Yes.
As per and my case is, I'm in possession of the entire thing. I paid money and I'm suing for specific performance.
Yes.
And that suit, my lord, for specific performance is pending.
Yes.
Now, my lord, the compromise is that the trust will get a major portion of the property. 10,318 will be retained by the trust. 6,123 is what I am going to get. And in this case, my lord, the first suit was filed in 1987. So, my lord, and the agreement is 1984. My lord, we cannot lose track of these dates, my lord. 84 agreement, 87 first suit, 16 second suit. So, my lord, it is
By entering with a compromise with you.
Yes.
Before any result of the suit. You
Yes.
say that they are saving more portions of the property.
Absolutely, my lord. In any
They have entered in another agreement with that other person who is nowhere concerned.
no, my lord, my submission is I am appearing for the one, my lord, who is retained 6,000 square feet. My case, my lord, is the trust will certainly, my lord, answer, my lord, your lordship's kind query. But my case, my lord, is this. Please look at this compromise from my point of view. I'm the plaintiff. I have given up 10,000 square feet. Now, my lord, what the trust should do with this 10,000 square feet is a matter which is within the province of the trustees.
Yes.
My lord, if supposing the trustees act illegally, what is the remedy, my lord, to a person who is interested? Firstly, he must be interested. Secondly, what is his remedy? And thirdly, what has this person done from 1987, 84 onwards? 84 is the first agreement.
Yes.
Trust receives money from me. Trust puts me in possession. Title deeds are with me. And they're not executing sale deed in my favor. So I have gone to court from 84. That means for 30 years I'm agitating. 40 years really. 40 years I'm agitating. Saying this property is mine. I have done everything. Give me specific performance. And on technical grounds, the list has not been yet adjudicated. No, my lord, at the end.
Your right and this thing is still it is there. If you succeed now, instead of 6,000 square feet, you will get it entire this thing.
That's true. But now my endeavor, my lord, is to place before your lordships, my lord, the argument that what are the grounds on which, my lord, this has been interfered with by your lordships? My lord, because your lordships did interfere and allowed the review. So in challenge, my lord, the Honorable Supreme Court said you may be filing one more review against this order. So that's how we are before your lordships. I'm only pointing out, my lord, that the observations of the court relating to suppression of facts are contrary to the record.
Yes.
Please, for that person, my lord, go to page 73. My lord. The discussion on merit begins at paragraph 8. And one most important aspect, my lord, is this, that these very persons, they have agitated this right in a section 92 proceeding. Lord, section 92 is the power of the civil court to administer, oversee, and correct any aberrations in the affairs of a trust.
If that compromise is accepted by this court, then that in that 92, they can't do it because High Court has already accepted.
Their contention is I'm not party, so I can agitate. So I don't mind leaving that open, my lord. I have no objection. If your lordships will not accept the compromise, and they have said themselves that the section 92 is pending. So, my lord, if section 92 is a proceeding in rem against the whole world, this is a proceeding in between the parties who are before your lordships. And if their case, they are riding two horses at the same time. One is 92, they should have pressed the court there. They don't do that. Instead of filing an application there for
In
relief.
the meantime, you have settled this matter.
Yeah.
Therefore, it is effect to their rights. Therefore, they are before this court.
My lord, my submission is this, my lord. Any order made in these proceedings, my lord, is not going to affect the powers of the civil court under 92. The 92 proceedings are still wide open.
Yes.
But they don't want to go there. They come straight away here. And please see the reasoning, my lord, of your lordships on this aspect. At page 78, on the locus standi, your lordships have held in their favor. And then, my lord, the other contention regarding pendency of the appeal. And at page 94, para 16, this is the reasoning, my lord, which I respectfully submit, my lord, requires reconsideration.
Yes, which is that?
Page 94, para 16.
Yes.
In the case on hand, the compromise petition has been filed on 15/2/23. It is mentioned that they have agreed to execute the sale deed in favor of first respondent in respect of 6,000 square feet. Remaining extent will be retained by the trust. Now it is brought to the notice of this court that on the very same day, the remaining extent of the property has been sold in favor of third parties by the trustees. This was not brought to the notice of the court. Before passing the compromise decree, trustees have already identified buyers, but it was not forthcoming in the compromise petition. Any transfer of trust property should be only in the interest, benefit, and protection of the trust. Since the sale of the trust property by private negotiation not verified or disclosed in the market value, it is not in the interest of the trust. Therefore, my lord, what your lordships have done by these observations, without inquiry, without trial, without evidence, the Honorable Court has come to the conclusion that the decision of the trustees to sell this property is illegal.
No, no, no. What is that? On the day when you have filed a compromise petition, the date of the agreement is also on that date, same date.
Yes.
Before that, you have to identify that purchaser.
That's done.
That has not been, see.
It's
the
there, my
matter
lord.
is
Now kindly turn to page 180.
Pending before this court.
Yes.
It is not brought to the notice of the court that remaining portions you are going to.
It's there, my lord. It is brought. Please turn to
No,
page.
it is, see, you have filed it along with that compromise petition on
Lord,
that
in
day.
the compromise petition, there are.
It is on that day. No, on the same day, you can't find out the purchaser and you have to make a.
It need not be same day, my lord. What I am saying is this, my lord. Along with the compromise petition, we filed certain documents.
You filed a document showing that you are going to alienate this property.
And resolution of the trustees.
Yes, but before that, there was already an identification of that seller.
That's all right, my
purchaser.
lord.
That has not been brought to the notice that.
It is brought, my lord. Kindly, my lord, turn to page 172, my lord. This is the compromise petition, which was filed before your lordships. Everything is disclosed.
170.
172, annexure H. This is the compromise petition. Kindly go to page 178, my lord.
178. Yes.
In para 11,
Yes.
the appellant represents and warrants that it is only the appellant firm that has transacted with respondents. There are no other entities. This is their inter se, my lord, assurance was given. They're not para 12. Appellant and its partners represent and warrant that no other persons have any right, title, interest in Schedule C. Then para 13, no alienation, etc. Para 14, there are no proceedings.
Yes.
Then my lord, next page, 180. Para 15, the sketch annexed as annexure A to this compromise petition has been prepared mutually by both parties and forms an integral part of this compromise petition. Both parties are bound by the same, shall not challenge the same. So before this was drafted, exact locations were taken, physical measurements, sketch was prepared, who is going to get what. So the identity of the property is known, the exact contour is known, the division is known. Then parties
Is
submit.
that understanding of the court that before filing the compromise petition, it has to be brought to the notice of the court in remaining portions of the property we want to alienate, permission to identify, Then you have to file in a
Not necessary,
compromise.
my lord. Please see para 17.
Yes.
My lord, in law, my lord, the trustees of a public charitable trust have right to deal with the property in any manner they want. The law, my lord, is only if the trust deed contains a restriction that the trustees cannot sell without leave of the court,
Yes.
then such permission is needed from the court. Otherwise, in the absence of any order from any court
Yes.
relating to dealing with the property, the trustees have every right to do whatever they want to do with the property. I respectfully submit, there is no need for us to approach this court or the court under section 92 to say, I want to sell this property, please permit me. I've given one case, my lord, I'll cite that also.
Yes.
I'll show them. Kindly now see, my lord, para 17. Your lordships were at the impression that this was not disclosed. This is para 17 of the claim, the compromise petition. We are specifically stating it is to be sold.
Yes. Para?
Para 17 at page 180.
Yes.
The sale is in the best interest of the respondent trust,
Yes.
and the sale proceeds will inure to the benefit of the trust in doing charitable activities in consonance to the deed of trust.
Yes.
This is disclosed.
Yes.
Then, my lord, the terms of the compromise is to be treated in consonance with the relevant provisions relating to the law applicable to the trusts of the kind of the first respondent.
Yes.
Therefore, the prayer is to permit the compromise. Now, my lord, please see the sketches at page 184. All this discussion takes place before compromise is filed before the court. The trust, my lord, has this property dispute from 1984.
Yes.
It doesn't have the property. It doesn't have any income. It doesn't have possession. It has objects of charity, which it cannot do anything. So if the trustees may not say, well, how long this litigation will go on? Let us enter a settlement. Let us encash the value of this property and we'll use it for charitable purpose. I would respectfully submit there's nothing wrong with that. Now please see, my lord, at page 207 is the resolution. This is also part of the compromise. Please see the date, my lord, 6th, page 207, 6th February 23. Execution of compromise petition in RFA 1294.
207.
Yes, ma'am, 207.
Yes. Yes.
The compromise petition, my lord, is dated 15/2.
Yes.
This resolution is on 6/2.
Yes.
And your lordships were not pleased to order on 15/2 itself. So this resolution is prior to that. The Board of Trustees have met and discussed in detail the litigation in respect of the property bearing number 28, situated at Dickinson Road, so-and-so, and have also been briefed by their counsel.
Yes.
Mr. K. Raghav Reddy and Associates are claiming rights under an agreement executed in the year 84. They have been in possession of the property for the last 38 to 39 years. There have been multiple rounds of litigation with the matter traveling all the way to the Supreme Court. The trust has also filed a suit for recovery of possession very recently in the year 2021. After extending discussions, the Board of Trustees noted that Raghav Reddy and Associates have had the benefit of being in possession after getting tenants evicted from the property. They have also incurred certain expenditure towards the same. The trustees noted that the trust has not benefited from the property, and due to pendency of litigation since 1987 onwards, no improvement could be done to Schedule A property, and as such, the trust could not get any revenue from the property except rupees 2 lakhs being the advance sale consideration received from K. Raghav Reddy and Associates. At the same time, the trust has incurred substantial expenditure in fighting the litigation. The trust has been advised that the present litigation, appeal and suits, is likely to consume more time having regard to the fact that the possession of the suit and the appeal before the High Court have been filed recently. The trust is not deriving any income from property for the last 40 years, and should the litigation continue, there is not even the remote possibility of the trust generating any income from the trust property, as K. Raghav Reddy are in possession of the entire property. At the end of the long-drawn litigation, which is going to involve expenditure and time, it has been advised that the possibility of the trust getting substantial amount from Raghav Reddy other than what is stipulated in the agreement, is also very remote. Now, this important factor, the agreement contains a price, and that price has become irrelevant because of 1984 agreement today.
Yes.
A proposal has been negotiated wherein Raghav Associates will retain about 6,123 square feet out of 16,144 square feet, and the larger and substantial portion of the property would be surrendered and returned back to the trust. This will enable the trust to raise substantial funds to fulfill objectives and achieve activities, and in further aggressively taking up charitable activities by the trust. The trust has been able to convince Raghav Reddy and Associates to return back substantial portion of the property immediately for the benefit of the trust. The proposal was discussed and debated in the background of legal and financial advice taken by the trustees from advisors of the trust. All the pros and cons were identified, weighed, and debated. The trustees have also taken advice of legal luminaries who have held high and respectable positions. In view of the above, the trust has decided to settle all of their disputes with K. Raghav Reddy Associates, to withdraw all the litigation in terms of compromise in RFA number 1294 before the Honorable High Court, finalize the draft of the compromise petition which has been placed before meeting today. The board unanimously accepts the terms of compromise, in terms of which an area to the extent of 6,123 square feet earmarked in the sketch annexed to the compromise petition shall be allotted to K. Raghav Reddy Associates in lieu of the said entity giving up its claim to the entire property. This next sentence. And the balance area, being an area of 10,318 square feet earmarked in the sketch annexed to the compromise petition, shall be sold by the trust to raise funds. Page 208.
209.
208, my lord.
Yes.
This third para says, in view of the above, that's
Yes.
how it begins.
Yes.
In the middle of that, my lord.
Yes. The board.
After approving the
Yes, yes.
sketch, in lieu of the balance area, being an area of 10,318 square feet,
Yes.
earmarked in the sketch annexed to the compromise petition, shall be sold by the trust to raise funds for setting off expenditure and for generating funds and finances to undertake further charitable activities in a larger scale with wider reach.
Yes.
The trustees acknowledge and confirm that the sale is in the best interest of the trust, and the sale proceeds will inure to the benefit of the trust in doing charitable activities in consonance to the trust deed.
Yes.
The trustees also confirm that the terms of the compromise are to be treated in consonance with the relevant provisions of law pertaining to sale of trust property. Then my lord, resolutions are passed. First resolution is to settle the dispute. Second resolution is to withdraw all litigation.
Yes.
Third resolution is authorizing two of the trustees to execute all the documents. And the fourth resolution is for sale.
Yes.
And the last resolution is authorizing two trustees to execute. All this, my lord, was part and parcel of the compromise petition.
Yes.
Whereas the argument was, oh, this is suppressed.
Yes.
My respectful submission, my lord, is that this portion of the order, my lord, requires re-examination, my lord,
Yes.
because this material is available. And my submission is, to what extent, my lord, in this review petition, in a suit for specific performance of a contract inter se between trustees and a third party, will the court, my lord, go into the propriety or otherwise of the trustees acting in their capacity? But they're covered by authority, my lord. I'm told, my lord, that it is the document, the judgments I filed is put up, my lord, today in number 90.4 in review petition 235, my lord. The earlier review petition is placed before your lordship.
Yes, yes.
In that, my lord, there's a list of authorities that I had filed.
Earlier review petition of the list of authorities.
It's dated 4/1/23. Huh? 4/1/24.
Responding to the ನೋಡಿ, ಒಂದು ಗಂಟಲು ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದಿದೆಯಾ?
Should be 24, I think.
ಯಾವ್ದು? ಅಲ್ಲಿ
Proceeding.
only list of authorities ನೋಡಿ.
ಇದೆಯಾ?
ಒಂದು ನಿಮಿಷ.
Well, it's not immediately available, I can give one more.
List of authorities by respondent ಅಲ್ಲ ನೀವು
Yes, madam. First respondent,
Respondent number 2 and 3 is different.
different. madam.
First respondent. Where is it? 1, 2 and 3. Ah, yes, I got it.
Kindly may not turn to page number 135. my lord. There's one judgment which
35.
deals with the powers of the trustees. My lord, my first submission is that is not a matter which merits consideration in this appeal.
Yes.
But just to satisfy my lord's conscience, my lord, that there is nothing wrong in the manner in which it is done, please see, my lord, how the courts have approached about powers of the trustees. my lord. Page 135, it's an old judgment. AIR 1966 SC 878. Constitution bench.
Yes.
We had made this submission also, my lord, that is outside the purview of the review, my lord. Please see the first page, my lord, itself, page 135. Some facts are there.
Yes.
This is an appeal by special leave against judgment of the Mysore High Court. Brief facts necessary for present purposes are these. There is a mutt in a village Devanur. A suit was brought in 1942 under section 92 of the CPC for framing a scheme for management of the mutt. A decree was passed on 17th March 48 with the High Court, by which a scheme was settled. 2 persons were appointed as joint managers thereunder. In 59, 2 managers were the appellant Madappa, who was chairman, and the respondent Mahanta Devaru. On 12th May 59, respondent made an application to the additional district judge in Mysore, in which he said there were more than 100 heads of cattle belonging to the mutt. The estimated income of the properties was barely sufficient to meet the cost of worship of the deity. No funds were available to maintain cattle. He also said it was unnecessary and expensive to incur feeding charges and pay for staff needing to take care of the cattle. He therefore prayed for an order for sale of cattle as a measure of economy and practical utility. Further, it appears there were some lands belonging to the mutt which were being cultivated through servants. It was suggested in this application that the lands might be leased out for cultivation for 1 year by public auction for cash consideration in order to increase the income of the trust. So these were the 2 prayers, my lord, that gave the genesis of this dispute. Then, my lord, please go to now page 138, para 9.
Yes.
Let us now see if there is anything in section 92 clause F which prohibits the giving of such directions, even if there is a provision to that effect in the scheme. 92(1) provides for 2 classes of cases, namely where there is a breach of trust in a trust created by public purpose of charitable religious nature, where the direction of the court is deemed necessary for administration of any such trust. The main purpose of section 82(1) is to give protection to public trusts of charitable religious nature from being subjected to harassment by suits being filed against them. That is why it provides that suits under this section can only be filed by either Advocate General or 2 or more persons having an interest in the trust with the consent and writing of the Advocate General. The object clearly is that before the Advocate General files a suit or gives consent for filing suit, he would satisfy himself that there is a prima facie case of each of the trust or the necessity of obtaining directions of the court. The relief sought in the suit under 92 are indicated in the section, including removal of trustees, appointment of trustees, and vesting of any property, vesting it should be more, vesting of any property in a trustee, directing a removed trustee or a person who has ceased to be a trustee to deliver trust property in possession to that person entitled to possession, directing accounts enquiries, declaring what proportion of trust property or of interest thereon shall be allocated to particular object, authorization of the whole or any part of the trust property to be let, sold, mortgaged, exchanged, or settlement of a scheme. Nature of the relief will show that a suit under 92 may be filed when there is a breach of trust or when administration of the trust generally requires improvement. One of the reliefs which can be sought in such a suit is to obtain authority of the court for letting, selling, mortgaging, exchanging the whole part of the property as provided in clause F. Next, my lord, they clarify. We, however, are the opinion that prayer for such a relief, though permissible in a suit under 92, does not in any way circumscribe or take away from the trustees or managers of public trusts the right of ordinary administration of trust property, which would include letting, selling, mortgaging, exchanging such property for the benefit of the trust. we cannot infer from the presence of such a relief being provided in a suit under 92 that the right of trustees or managers of the trust to carry on ordinary administration of trust property is in any way affected thereby. If this were so, it would make administration of the trust property by trustees or managers next to impossible. This will be clear from a few examples we may give. Suppose there's a lot of odds and ends accumulated, and the trustees or managers of a public trust want to dispose of those odds and ends if they are of no use to the trust. If the interpretation suggested on behalf of appellant is accepted, the trustees or managers could not sell even such odds and ends without filing a suit or authorizing them to sell such movable property. Obviously, this could not have been the intention behind clause F of 92(1). Take another case where the public trust has a good deal of land and arranges to cultivate itself, gets crop every half year. If the produce is not at all required for the trust has to be sold, the presence of clause F in 92 does not require that every half year a suit shall be filed by the trustees or managers with permission of the Advocate General to sell such crop. Absurdity, the argument on behalf of appellant based on clause F of 92(1) is therefore obvious, and that clause does not, in our opinion, have the effect of circumscribing the powers of the trustees or managers to carry on ordinary administration of the trust property and to deal with it in such manner as they think best for the benefit of the trust, and if necessary, even to let, sell, mortgage, or exchange it. It seems that clause F was put in inter-alia to give power to the court to permit lease, sale, mortgage, or exchange, where, for example, there may be a prohibition in this regard in the trust deed relating to public trust. That's the submission Lord is making. If the trust deed says you cannot do it without permission of the court. For example, my lord, in the BBMP Act, there's a provision which says the BBMP can deal with the property, but if the lease is for more than certain period or sale, permission of the government is necessary. Same way, my lord, many trust deeds contain a provision like that. Either it will say it has to be a particular procedure to be followed, or some public notice, or they may procedure may be prescribed, or it may say the trustees shall not sell any property without leave of the court. If no such provision is there, my lord, the law, my lord, has been very clearly laid down. Then, my lord, they continue. There may be situations where it may be necessary to alienate the trust property, which might require court sanction. That is why there is such a provision in clause F of 92(1). But that clause, in our opinion, was not meant to limit any power of the trustees or managers to manage the trust property to the best advantage of the trust and its interest, and if necessary, even to let, sell, mortgage, exchange, or property. Further, if clause F cannot be read to limit the powers of trustees or managers to manage trust property in the interests of the trust and to deal with it in such manner as would be in the best advantage of the trust, there can be no bar to a provision being made in the scheme for directions by the court in that behalf. If anything, such a provision would be in the interest of the trust, for the court would not give directions to let, etc., unless it is clearly in the interest. So, my lord, what they're saying is, when you're making a scheme, if we can put it in the scheme, if the court is making the scheme, that the trustees will deal with the normal day-to-day things, and that is when a case the court is framing a scheme. But if there's already a trust deed is there, of course, under 92, my lord, the trust deed can be interfered with. Supposing there's a very absurd provision in a public charitable trust, that only the trustees will enjoy the benefits of this. To that extent, if it comes to 92, my lord, court can override that to say, no, this is not public. So this clause should not be given effect to. We direct this is how the property should be dealt with. The scheme can be framed. But in the normal course, my lord, the position is very clear. Therefore, my lord, my submission is that that portion of the order, my lord, requires reconsideration, my very humble submission, that appears to have not been examined, my lord, by your lordships, my lord, in the earlier round. That is why, my lord, the Honorable Supreme Court found that this is a matter which requires, my lord, another look at your lordship's hand, my lord. Therefore, I am submitting, my lord, that matter requires, my lord, reconsideration. My lord, one other aspect, my lord, is having appeared in this case for considerable period, every time, my lord, the court was inquiring, why are you not settling this dispute? How long will this case continue? I'm not saying, I'm not blaming the Honorable Court. I'm only saying it was with a sense of completing the justice that required in a case. How long will this public trust continue? Therefore, my lord, what happened was, my lord, let's be very clear, my lord. If this litigation continued, probably it would continue for another 20, 30 years. After the High Court, my lord, matter will surely, in any way, my lord, if the High Court, my lord, had held that the dismissal of the suit was not proper, the matter would have to go back to lower court. And then.
No, that dispute is between you and the trust.
Yeah.
They can settle the matter between your part.
Yeah.
Why they have included other in this? If their trust has any right, let them do it separately and do it separate, they can challenge it, but not in that compromise petition, they have to do it that.
No, in the compromise
That
petition.
They taking the seal of this court and
No, my lord, I'm saying that that's.
you are before the court. It is between you and the trust. It is for the interest of the trust, you are giving up that some property and settling that. If it is settled and file it, it's okay. They are saying that their other part of that, if trust has any right, there is no condition, they can do it, let them do it, not by part of this court.
No, my
order.
lord, what I'm saying, my lord, is this.
See, why they have passed in a resolution for selling that other portions in this matter?
They, my lord, the compromise, my lord, it's, my lord, kindly appreciate this, my lord.
See, they should have making a compromise with you and deciding that matter and give it off. Taking that other parties to compromise and he is also going to sell. That is not that issue before me.
My lord, true, my lord. After all, my lord, when our lordships are recording a compromise, the test is whether the compromise is lawful.
No, compromise should be in respect of the parties between the same this thing.
My lord, the authority on the proposition is that the compromise may encompass everybody who is before the court. And the compromise should not be unlawful.
Now, who is that other person who has purchased?
The trustees are there and the purchaser.
Who is that other portions of the property who is selling that?
The purchaser is before your lordships.
No. He is not the parties in the suit.
No, my lord, they are not, my lord, that the purchaser was never in the scene in the litigation. My lord, what happened was the list was between the trust and me. So, my lord, when they settled the dispute, the understanding was that I'm going to get something and the remaining will be left with them. They took a decision that the remaining property we don't want to keep. We want to dispose. The question is, my lord, while accepting the compromise, the question of whether that decision was legal, lawful, is outside the purview of the court is what I'm respectfully submitting. Because the only issue that will arise for consideration, is it a free compromise? Is it between the parties who are before court? Is it lawful? Supposing the object is unlawful, then your lordships will say, no, this will not be accepted. But none of those are coming. But my lord, the reason why the resolution was passed to that effect and was placed before the court was to be very clean. They wanted to submit to the court that this is our decision. We are settling this, my lord, so that I will sell this property. That is the trustee saying, I'll sell this property, I'll get money, I'll continue my charitable activity, which I have not been able to do for 40 years. They wanted to place that before your lordships, my lord. My submission is, my lord, that should not, my lord, come in the way of the honorable court saying that court is not, I respectfully submit, my lord. If the court feels that that portion of the compromise, the Honorable High Court is not giving its view on that, my lord, I have no objection. If that is to be left open, there is already a proceeding under 92, it is for them to agitate it there. That I have no difficulty with that. Therefore, my lord, my submission is that the rejection of the compromise is not, my lord, justified because of the disclosures that have been made very clearly and candidly. Only thing, my lord, that the paperwork was a bit lengthy. Therefore, my lord, your lordships probably would not have.
Yes.
And one more aspect, my lord, is very important. My lord, please kindly, my lord, consider it from the point of view of the trust, my lord. The trust does not have possession of this property from 84.
Yes.
It has not received only some paltry sum of few lakhs.
Yes.
Documents are not with them. Now, if they feel that this compromise is in our interest because we are getting substantial part of the valuable property today, which I can sell and use the money, that is not, my lord, unlawful is my respectful submission. And I had given up possession because of the compromise.
Yes.
So now, my lord, if this is undone now.
No, that is if you succeed that, you will get the entire extent of the property.
No, they must put me back in. Now, my lord, if review is allowed, what will happen now is status quo ante must be restored. I must be put back in possession. The sale deed executed by the trust, that should be annulled. The consideration paid should be refunded. All that would be the consequence of this order. My submission is not that was not intended at all. It was nobody's case that the trust need not have sold. And since there is already a proceeding under 92, it is for them to establish it in those proceedings. Lord, till now, there is no separate proceeding against the purchaser. That purchase, the sale deed is not challenged, payment of consideration not challenged, then cancellation of the documents not sought, delivery of possession to him not challenged. So somebody who is not before the court is now in possession of the property, so far as trust property is concerned, and trust has the benefit of the money also. When they have earned, my lord, substantial money in the last 2 years. And mutations, I'm told, are affected. And up-to-date tax has also been paid by the purchaser. Therefore, my lord, my submission is that not that your lordship's order merits not reconsideration, humble submission.
Yes. You are arguing on behalf of trustee in place of Holla. Yes. Same, both are having in the same defense.
Just to give a brief background on it.
Yes.
Not the agreement of sale is of the year 13/6/1984.
Yes.
Admittedly, not the intending purchasers were put in possession of the whole property, the entire property. But OS 2495 of 1987 was a suit filed for specific performance by them, contending that they had spent certain amounts in getting the tenants also vacated.
Yes.
That suit initially came to be decreed on 21/2/1997. The trust challenged it by way of an appeal in RFA 306 of 1997. That came to be allowed on 13/6/2008 on the basis that the firm which had filed, that is the purchaser, was a firm that had not been registered under Section 69 of the Partition Act.
Yes.
And therefore, Section 69 says if any suit on a contract by an unregistered firm would not be. This the firm challenged it in the Supreme Court, did not succeed. But what they did was they got themselves registered. The position is that insofar as a rejection of a suit on the basis that it is not registered, that is not one on merits. Therefore, my lord, if they get themselves registered, that's only a bar under Section 16 of the Partnership Act, which gets removed. But therefore, they filed OS 7566 of 2016 again for specific performance. Of course, the only question which would arise then is whether it should be barred by limitation or not. They had also pointed out, claiming the benefit of Section 14 of the Limitation Act, because initially the decree was in their favor.
Yes.
And only on the basis of a defect of, because Section 14 of the Limitation Act says that if any cause of any defect of a like nature, then the period which is spent in the earlier proceedings could be excluded. They filed this suit. In the meanwhile, they had also filed OS 8357 of 2008 for injunction, permanent injunction, restraining us from interfering in their possession on the basis that they were in possession of the whole property in part performance of the agreement of sale. I'm not invoking Section 53 of the Transfer Property Act. The difficulty which we faced was the Supreme Court had clearly said, even if a suit for specific performance is barred by time or it is otherwise dismissed also, if 53A is an independent right on which they can protect their possession. So it is like even if their suit had got dismissed, I would have operation successful, patient dead, because still I had this difficulty because they had raised they were in possession of the whole property and they had raised a defense under 53A of the Transfer Property Act. And the Supreme Court, there were initially conflicting decisions as to whether if the suit for specific performance is barred by time, whether 53A will lie or not. Matter, in fact, in our court, went to a full bench. Full bench said, no, that's an independent right. Then, of course, Supreme Court itself took the view that, yes, it's a different aspect of suit being barred by limitation or suit otherwise being dismissed. As long as you show readiness and willingness and you are in possession in part performance, 53 is a bar for you to recover possession. So I had this difficulty also. Of course, I filed a suit, OS 26572 of 2021 for possession. But my suit for possession would depend on their plea of 53 of the Transfer Property Act. CRPs came out from interlocutory orders, not where an application was filed for rejection of plaint, etc., which I had also filed. CRP came. In the course of those proceedings, this honorable court sent the matter for mediation.
Yes.
Your Lordship has there was a background in which this the compromise came to be entered into. And not insofar as the trust was concerned, Your Lordship would see ultimately, since they had raised Section 14 of Limitation Act as a ground, insofar as their own second suit for specific performance.
Yes.
Now that became a matter for adjudication as to whether Section 14, if that period is condoned because it's it was dismissed only on the basis of non-registration and that got it then registered, then I faced the threat of specific performance and I would lose the whole property. At the same time, even assuming that suit were to go, because of their defense under 53A, and if they were to show that they had spent monies also for eviction of tenants, which was a fact, and they were in possession of the property, which was a fact, agreement of sale was a fact, then I faced a situation where even if their suit was specific performance, assuming it takes its own time, second suit for specific performance, even if I were to succeed again, I would still face the same difficulty in so far as 53A suit, and I would be out of possession till that injunction suit is to be decided, and then that would be perhaps not taken in appeal, etc. It is in these circumstances that I felt that there is and since the court also had suggested that this is a matter where there are several of these three suits and various interlocutory proceedings, CRPs, etc., court felt this is a matter where settlement should be explored. Now, insofar as Your Lordship rightly pointed out that insofar as the present dispute is concerned, or in the RFA, which came up in the RFA, where the compromise was recorded, was between the trust and the old purchaser, with whom I had an agreement of sale of the year 1984. But when I am taking a decision to compromise, I took into account the fact that ultimately something had to be done. It is not I am in a position to deal with, because he has been in possession from several years. I have been out of possession.
Yes.
Fortunately for me, they were able to persuade, and it was accepted that out of about 16,441 square feet is the entire extent of land of which they were in possession of. They agreed to take 6,123 square feet. So less than almost a quarter of 1/3 of the and they agreed to give up possession of the whole of the balance. Now, for this, I cannot, I have to find some funds, because I don't have funds to do anything with this property. Property is only a means to raise funds. Therefore, I had passed the resolution which Your Lordship has seen. When senior take Your Lordship to the resolution, I'm not troubling again, but Your Lordship it sets out the background. Kindly have a look at that resolution again, which has been passed in the. I'm sorry, I don't have a copy of their set. I couldn't see the page number in there. But in our petition, RP 232, Your Lordship would find it page 38. But perhaps since Your Lordship has already perhaps marked, I would not trouble Your Lordship by taking away this thing. If I may just request
208.
Please,
Resolution is page, I think it's somewhere.
Please, Your Lordship may just take that resolution. If I may just read the whole of it, it should give the background.
Yes.
The Board of Trustees have met and discussed
which paragraph?
The beginning, very beginning itself of the resolution. If I may just read the whole of it,
Page
just
207.
page 207, I'm told, it starts.
07.
Please.
Yes.
The Board of Trustees have met and discussed in detail the litigation in respect to the property bearing new number so and so, situated so and so, and have also been briefed by their counsel.
Yes.
K. Raghavan Associates are claiming rights under an agreement executed in the year 1984. They have been in possession of the property for the last 38-39 years. There have been multiple rounds of litigation with the matter traveling all the way to Supreme Court. The trust has also filed a suit for recovery of possession very recently in the year 2021. After extended discussions, the Board of Trustees noted that K. Raghavan and Associates have had the benefit of being in possession after getting the tenants evicted from the property, and they have also incurred certain expenditure towards the same. The trustees noted that the trust has not benefited from the property, and due to pendency of litigation since 1987 onwards, no improvement could be done to the Schedule A property, and as such, the trust could not get any revenue from the property, except 2 lakhs being advance sale consideration received from K. Raghav Reddy and Associates. At the same time, trust has incurred substantial expenditure in fighting the litigation. The trust has been advised that the present litigation, pending 1 appeal and 2 suits, is likely to consume more time having regard to the fact that possession suit and the appeal before the High Court have been filed recently. The trust is not deriving any income from the property for the last 40 years. And should the litigation continue, there is not even remote possibility of the trust generating any income from the property, as K. Raghav Reddy and Associates are in possession of the entire property. At the end of the long-drawn litigation, which is going to involve expenditure and time, it has been advised that the possibility of the trust getting any substantial amount from Raghav Reddy and Associates, other than what is stipulated in the agreement, is also very remote. A proposal has been negotiated wherein K. Raghav Reddy and Associates will be retaining about 6,123 square feet out of 16,144 square feet, and the larger and substantial portion of the property would be surrendered and returned back to the trust. This will enable the trust to raise substantial funds to fulfill the objectives and activities and to further aggressively taking up charitable activities by the trust. The trustman has been able to convince Raghav Reddy and Associates to return back substantial portion of the property immediately for the benefit of the trust. The proposal is discussed and debated in the background of legal and financial advice taken by trustees from the advisors of the trust. All the pros and cons were identified, weighed and debated. The trustees have also taken the advice of legal luminaries who have held high and respectable positions. In view of the above, the trust has decided to settle all of their disputes with K. Raghav Reddy and Associates and to withdraw all of their litigation in terms of the compromise petition in RFA number so and so before the Honorable High Court of Karnataka, the finalized draft of which compromise petition has been placed before the meeting today. The board unanimously accepts the terms of the compromise, in terms of which an area to the extent of 6123 square feet earmarked in the sketch annexed to the compromise petition shall be allotted to K. Raghav Reddy and Associates in lieu of the said entity giving up its claim to the entire property, and the balance area being an area to the extent of 10,318 square feet earmarked in the sketch annexed to the compromise petition shall be sold by the trust to raise funds for setting off expenditure and for generating funds finances to undertake further charitable activities in a larger scale with wider reach. The trustees acknowledge and confirm that the sale is in the best interest of the trust, and the sale proceeds shall be inure to the benefit of the trust in doing charitable activities in consonance with the duty of the trust. The trustees also confirm that the terms of the compromise are to be treated in consonance with the relevant provisions of law pertaining to sale of trust property. In view of the same, Board of Trustees resolved as follows. Trust resolved the trust settle its disputes with Raghav Reddy and Associates in respect to the property bearing at so and so by way of executing the compromise petition before the High Court of Karnataka. The finalized draft of the compromise petition has been placed before the meeting today. Further resolved that the trust in pursuant in consideration of the compromise at RFO withdraw all litigation filed against K. Raghav Reddy and Associates so and so. Further resolved that so and so present and only trustees of the trust be and are hereby authorized to jointly represent before the Honorable High Court of Karnataka and to sign, execute all necessary papers, including compromise petition, applications, affidavit, memo, so and so, on behalf of the trust to be filed in so and so, as well as other litigation, so and so. Further resolves the trust be and is hereby authorized to execute, admit, execution of, and present for registration a sale deed in favor of Raghav Reddy, so and so, in respect of 6123 square feet of land situated so and so. Further resolved that so and so, trustees be and jointly execute sale deed in respect of above mentioned and to represent trust before the office of jurisdiction, so and so. Therefore, my lord, insofar as what was compromised with Raghav Reddy, not the appellant in that appeal, was only insofar as conveying this. This decision was an independent decision by the trust, my lord. That, my lord, in my humble submission, if anybody is aggrieved, it could be, my lord, the respondents 1 and 2 hearing or the review petitioners. Their remedy, my lord, if at all, is to question it by way of proceedings in section 92. Not which, in a way, they have initiated proceedings in section 92, but they have not yet chosen to seek for any relief insofar as this particular sale is concerned. Therefore, my lord, insofar as the court is not really called upon, even in accepting the compromise, my lord, I may just try to, my lord, places ourselves back in a situation where the court was to accept the compromise. Insofar as the decision to sell the balance of the property, the court is really not called upon there and cannot be called upon there also to decide whether that is either correct or not correct, or whether it is as per provisions of law, whatever it is. That is not the question at all called for by the court. The court has to see whether insofar as parties to the suit are concerned, what has been compromised, is it valid or not? And that, my humble submission is, insofar as taking back possession of about out of 16,000, about 6,000, 12,000 is 10,000 is taken back, and giving up 6,000 But that is very much in the interest of the trust, considering that they were in possession of the whole property for about 40 years. There were 3 litigations. This court had also suggested that the parties go to mediation about it. And therefore, not insofar as that is concerned, that cannot be called as unlawful in any manner. And your lordship would now see, my lord, what was the ground on which review was sought? Kindly have a look at, my lord, the review petition, which was filed, my lord, by the review petitioners.
Yes.
Page number?
In your case,
Yes, my lord.
which one that is?
My lord, I don't know whether they have annexed it, my lord, as part of their or the release of it. My lord, perhaps, my lord, it's the order, my lord. The petition.
No, you are referring the ground in your review petition or?
No, my lord, in their review petition.
That is the part of this thing.
My lord, I would request your lordship not to have a look at the petition which they had filed. The review petition, my lord, the memorandum of review petition. My lord, perhaps, my lord, if your lordship were to take, my lord, RP, my lord, your lordship would find it, my lord, at page 269, my lord, in the same compilation.
Yes.
My lord, your lordship would turn to page 276.
Yes.
Your lordship would only find, my lord, that they say in paragraph ground number 2,
Yes.
that because of rejection of plaint as being barred by limitation, the compromise cannot be accepted.
Yes.
Then, my lord, in ground 4, wrongly they had asserted that only one trustee had joined. Your lordship would note, my lord, in this whole petition, there is no assertion made insofar as the second part or even, my lord, even the first part of the compromise. There is no plea that either the decision of the trustees to sell the balance land is wrong, breach of trust, or unfair. No plea is raised about it. There is no question raised about that. Nor do they say, my lord, your lordship posed a question. Will not this acceptance of this compromise imply as if a approval of the court is given? I would, my humble opinion, it does not. And my lord, I have no difficulty if your lordship had to clarify that aspect also. Because naturally, my lord, if anybody is aggrieved, my lord, as to whether these persons can be considered as interested in the trust for the purpose of section 92 petition is a separate matter, my lord, which I will be agitating in the section 92 court. Therefore, my lord, if the sale of the balance portion is assailed in section 92, this court's acceptance of the compromise will not take away the jurisdiction of the court if it is otherwise available to decide that question. And I have no difficulty, my lord, in your lordship also clarifying that to that effect. Because naturally it cannot, in law also it cannot take away. Because my lord, that's a question where, and your lordship would not, insofar as these petition, the original review petitioners, if I may use those words, my lord, to distinguish between us and them, because we are review petitioners now, but they being the original review petitioners, they were not parties to the compromise.
Yes. Yes.
Therefore, my lord, if they were to challenge, if that challenge were to be otherwise maintainable, and I'm not getting into it, in accordance with law, my lord, as it would be said. Naturally, my lord, no, even the 92 court cannot say, in view of the compromise entered there, that too between myself and the original purchaser, dealing with one portion of it, it is binding on all, and therefore that court is precluded from even looking at under 92, is not something not which that court can say, nor can I urge it. Therefore, not, that is always open. In fact, not, that is one of the grounds here, that this honorable court will not ought to review its orders, because these questions, if they are raised now, in fact, it was not raised in the review petition. That's what not, in fact, one of my grounds for review is, not if that compromise were to be challenged insofar the second portion of the land is concerned and the sale thereafter.
Yes.
There must be a pleading about it, assuming it is possible in review petition. Assuming it is even possible. In my humble opinion, it's not permissible in review petition. But assuming so, there must be at least a plea regarding that. I must be put on notice. I would then, my lord, in a section 92 petition, my lord, if they were to raise, I would have had my defense. Evidence would have been led. I would show whether they are interested parties, not interested parties. Perhaps what my lord, oblique motives they have, because section 92, my lord, court, Supreme Court has also said, it is meant for genuine. It's like, my lord, virtually a kind of public interest litigation. You must show you should not be a wayfarer. Some third party with some oblique motives. Whether they are with oblique motives or not, I would have led evidence. They would have had to step into the witness box. Cross-examination would have gone on. I would have placed my defense to say under what circumstances, whether if they were to raise any issue regarding valuation, not well, all the surrounding circumstances, justifying that I would have placed there. That is not an issue which can be gone into here in this in these proceedings. But assuming, for the sake of argument, they have to have at least pleaded it. There is no plea. That's why, I took the trouble of showing to your lordships the grounds in the review petition.
Yes.
So no whisper is made.
Yes.
Either that this compromise affects them in some other matter, or it will come in their way of their agitating in a section 92 petition. No ground is met. Therefore, my humble submission is, in the absence of pleading in the review, the order which is passed on that basis would not be sustainable in my humble submission. That would be a one without pleading, and therefore that itself is something you would call for review. Is my humble submission. Then, your lordship would note, insofar as the placing before the court, learned senior has already explained, this resolution forms part of the compromise petition. In fact, my lordship sees in paragraph 10 of the compromise. Page, just page 1, page 176, my lord. Your lordship would turn to page 178.
Yes.
At the end of para 10. The resolution, my lord, is made part of the compromise.
Yes.
It is produced before the court. And the lordship would note, again, my lord, I would take your lordship back to the review petition. It is not even the ground in the review petition that we have suppressed any aspect. Kindly see, if my lord, fraud, as your lordship knows, my lord, if it is a ground, it has to be pleaded, not only just pleaded, with full particulars. There is absolutely no pleading of that basis, my lord, in the review petition, saying that we have suppressed any aspect, that he did not bring anything to the notice of the court. While, my lord, it may have been argued orally. Of course, my lord, I was not there at that stage, my lord, but assuming so, that does not take away the requirement of having to be pleaded with full particulars of any fraud. My lord, nothing has been pleaded in the review petition. Therefore, my lord, my submission is, and factually also, my lord, it is not correct. The reason being, my lord, this was in fact placed before the honorable court. The resolution is not as was read out, clearly makes a reference to the sale of the balance. And the lordship would not. In fact, my lord, para 17 of the compromise petition, my lord, at page 180. In fact, my lord, this has been taken out from the resolution itself. The same wording is found in the resolution, my lord. It is placed here also. Because the lordship notes, insofar as what is being given to them, that is 6,000 and odd square feet.
Yes.
I am not receiving any further money. Whatever they have paid the advance and whatever not they have spent on the eviction of the tenants, I have taken it as consideration. Nothing more. So what I am referring to here as the sale proceeds will be used for the benefit of the really the sale of the balance. Therefore, not that has also been brought to the notice. But I would humbly submit, not assuming for the sake of argument that I have not placed it. That would not invalidate the compromise for the simple reason, insofar as they are concerned, what I have parted is this 6,000 square feet. If any issue is raised regarding that, that is the only which can be gone into by the court as to whether the giving up of the 6,000 is correct or not, because that again is something which in the background of the circumstance, one cannot say that that is something which should not be resorted to. Again, my humble submission is, at this stage, in a recall of compromise, what the court would see is whether there has been fraud played on any of the parties to the compromise or any of the other conditions for invalidating a contract. Now, my lord, my humble submission would be that if this compromise were to be brought before the court and some party would urge, no, this is not in the interest of the trust, that is not affecting the validity of the compromise. It is as to whether it is correct or not, which is a matter which the court, my lord, under section 92 alone would have jurisdiction. Not this court, my lord, while looking at a compromise, would not get into the question and declare that either this is a breach of trust or not a breach of trust. That is a finding which can be given after trial only by the section 92 court. Therefore, my submission would be that even regarding this 6,000 square feet, assuming for the sake of argument that rates such an issue, that's why, my lord, I am repeating, my lord, that in the review petition, your lordship finds this completely silent. Even on this aspect, let alone the other aspect of the sale of the balance, even on this aspect of this 6,000 being given up, not is completely silent. The only aspect which was raised was that because the suit had been rejected on the ground of being barred by limitation, whether the court could have entertained the compromise. There, my lord, my humble submission is, the position of law is very clear. An appeal is a continuation of a suit. I need not multiply authorities, not if required. That is a basic settled proposition of law. Now, insofar as what is the consequence of the court having rejected a suit on the ground that it is barred by limitation? Now, my lord, that very decision is in question in appeal. And my lord, it is also well settled in appeal. Also, a court can entertain a compromise. There is no difficulty about it. Now, my lord, I would only point out two judgments, my lord, of the Supreme Court, which would clearly say issue of limitation is not one, my lord, which goes to jurisdiction, but it is on maintainability. Therefore, not the power of the court, assuming, my lord,
Yes.
But I just first will not draw your lordship's attention, will not. But unfortunately, the main judgment which has been, we started the this thing as I think my colleague has not made copies. I'll just pass on judgment of the Supreme Court in AR 1999 Supreme Court 2089.
1999.
1999.
2089.
And this has been followed not by subsequent judgment, but your lordship would just have a look at this minute there. But in fact, this was a case where a recall application was filed.
1999 SEC ಇದೆಯಾ ಇಲ್ಲಿ ಯಾವ್ದಿದೆ ನಿಮ್ಮ ಹತ್ರ ಅಂದ್ರೆ ಇಲ್ಲಿ ಏನು ಇಟ್ಕೊಂಡಿದ್ರಿ SEC ಇದೆಯಾ
your lordship, if your lordship turns to paragraph
wait
there was this is a case
take this.
But in this reminds of earlier days, when we used to take out the books, know that. Supreme Court 2089.
Yes.
Budhiya Swain versus Gopinath Dev. Case nakala, AR 90 Supreme Court. But then I'll just, I have it open. But your lordship would see, my lord, in the first paragraph itself, my lord.
Yes.
This was a case, my lord, towards the end of the first paragraph.
Yes.
This was a case, my lord, a recall application was filed of an order.
Yes.
On the ground, my lord, that the order was passed without jurisdiction because it was barred by limitation. Dealing with that, my lord, the lordship kindly turns to, my lord, the second paragraph, my lord.
Yes.
It starts, my lord, the only provision for review would your lordship not get.
The paragraph is not telling.
I'm not, it's
No,
the,
the only provision.
yes,
is
ma'am.
clarified.
The only provision for review in the act should be found in section 38A, wherein read, review may be sought for within 1 year from the date of decision on order, but only on the ground that there has been a clerical or arithmetic mistake in the course of any proceedings in the act so and so. Then your lordship would not have a look at the paragraphs below that.
Yes.
It starts not with the OEA collector was satisfied. But towards the end of the judgment.
End of the judgment.
Yes, please. The OEA collector was satisfied of the notice having been published.
Yes.
Yes, ma'am. Assuming that notice was not published in the manner contemplated by law, it will at best be a case of irregularity in the proceedings, but certainly not a fact striking at the very jurisdiction of the authority passing the order. The appellate authority, that is the ADM, has in his order noted 2 other contentions raised by the appellants. That is, the application for settlement by the respondent number 1 was not filed within the prescribed time, and the application should have been treated as an application for lease and should not have been treated as a claim case. None of the 2 pleas were raised by the appellants in their pleadings. None of the 2 was urged before OEA collector. Therefore, there was no occasion to consider those pleas. Still, we may make it clear that none of the 2 pleas would have been a ground for recalling the order, which was otherwise within the jurisdiction conferred to the OEA collector. Though it is a disputed question of fact as noted by the High Court, that the application by the respondent number 1 was filed within the prescribed time or not, nevertheless, we are very clear in our mind that an order made on an application filed beyond the time prescribed for filing the same may be an illegal order, but it is certainly not an order passed without jurisdiction. A suit or proceeding entertained and decided in spite of being barred by limitation is not without jurisdiction. At worst, it can be a case of illegality. In Nitya versus Mathai versus Varki or so and so, AR 1974 Supreme Court, this court has held, even assuming that the suit was barred by time, it is difficult to appreciate the contention of learned counsel that the decree can be treated as a nullity and ignored in subsequent litigation. If the suit was barred by time and yet the court decreed it, the court would be consummating an illegality, and therefore the aggrieved party would be entitled to have the decree set aside by preferring an appeal against it. But it is well settled that a court having jurisdiction of the subject matter of the suit and over the parties thereto, though bound to decide right, may decide wrong, and that even though it decided wrong, it would not be doing something which had no jurisdiction to do. It had the jurisdiction over the subject matter, and it had the jurisdiction of the party, and therefore merely because it made an error in deciding a vital issue in the suit, it cannot be said it had acted beyond its jurisdiction. As often been said, courts have jurisdiction to decide right or to decide wrong, and even though they decide wrong, the decrees rendered by them cannot be treated as nullities. Therefore, not my supposition is the issue of limitation is not something which goes to the jurisdiction of the court. Now, my lord, the trial court, no doubt, my lord, rejected the plaint. But it does not mean the court did not have jurisdiction. The court had jurisdiction. My lord, because jurisdiction deals with subject matter jurisdiction, for which, my lord, we need to go to section 9 CPC. For example, my lord, if the suit were of a nature where it is barred under section 9 CPC, my lord, because perhaps some other statute creates a bar, then, my lord, that would be a case where the court may not have jurisdiction at all. But obviously, this is not a case, my lord, for specific performance. It is a civil court which has jurisdiction. Whether it is within time, without time, whether section 14 is applicable, not applicable, these are all questions, my lord, of fact, which would arise, mixed questions of law and fact. The trial court took a view, but that was open to question here before this court, which the defendant plaintiffs there did question. And that appeal is a condition of a suit. Therefore, my lord, it is not that this honorable court did not have jurisdiction to enter in the compromise, nor could it be said that only after upsetting the judgment of the trial court will this court have jurisdiction to enter in a compromise. No. The reason being, issue of limitation goes into admissibility of the claim, maintainability of the claim. But therefore, the court had every power, authority, or jurisdiction to take on record the compromise and decree the suit. Now, assuming for the sake of argument, my lord, the other side were to argue that no suit was barred by time. And let us assume, my lord, that somebody has compromised the suit. It's not a nullity, as the court has said, because limitation does not deal with jurisdiction. Therefore, my lord, and this, my lord, has been, of course, my lord, I have produced the 1964 judgment, my lord, which has been extracted here. Therefore, I will not trouble your lordship by reading that again, my lord. There is one other judgment, my lord, in the context of arbitration.
Yes, no, that is 1999.
This 1999 judgment follows that 1964 judgment.
Yes, yes.
And that by Leonard Senior has produced that.
64. Yes, yes, yes. Judgment.
2025.
Yes. Yes. Yes.
Your lordship would then have a look at the later judgment of this honorable of the Supreme Court, in 2021 5 SC, which I have just passed on a copy, your lordship. This, of course, dealt with the question as to, under Arbitration Act,
yes,
whether the question of limitation to the arbitration, does it go to the root of the matter, or is it a question dealing with jurisdiction or not? Your lordship would kindly have a look at paragraph. Kindly turn to paragraph 38.
38.
Yes, 38. 2021 5 SCC 738.
Yes.
Page 762. Limitation is not, when I just read, limitation is normally a mixed question of law and fact and would lie within the domain of the arbitral tribunal. There is, however, a distinction between jurisdiction and admissibility issues. An issue of jurisdiction pertains to the power and authority of the arbitrators to hear and decide a case. Jurisdiction issues include objections to the competence of the arbitrator or tribunal to hear a dispute, such as lack of consent or a dispute falling outside the scope of arbitration agreement. Issues with regard to existence, scope, and validity of the arbitration agreement are invariably regarded as jurisdictional issues, since these issues pertain to jurisdiction of the tribunal. Admissibility issues, however, relate to procedural requirements, such as a breach of pre-arbitration requirements, for instance, a mandatory requirement for mediation before the commencement of arbitration, or challenge to a claim, or a part of the claim being either time barred or prohibited until some precondition has been fulfilled. Admissibility relates to the nature of the claim or the circumstances connected therewith. An admissibility issue is not a challenge to the jurisdiction of the arbitrator to decide the claim. The issue of limitation, in a sense, goes to the maintainability or admissibility of the claim, which is to be decided by the arbitral tribunal. Therefore, not again, Supreme Court has said, limitation is not one issue which goes to jurisdiction, even in the context of arbitration. Kindly see the next line, Milord. For instance, a challenge that a claim is time barred or prohibited until some precondition is fulfilled is a challenge to the admissibility of the claim and not a challenge to the jurisdiction of the arbitrator to decide the claim itself. But therefore, Milord, the judgments of the Supreme Court will not clearly hold that limitation is something which does not affect the jurisdiction of the court. Therefore, Milord, the Lordship sees this aspect, Milord, this judgment, 2021 judgment, Milord, does not appear to have been noticed. Milord, of course, Milord, I should only, Milord, we can only put blame on ourselves, Milord. Milord, we should be, Milord, perhaps not assisting the court there, Milord, in that regard. This was, Milord, not brought to your Lordship's notice, Milord. In fact, what has been brought to your Lordship's notice is only the Ityavira Matai case, that is at page 125, Milord. I'm sorry, Milord, at page 30, internal page 33, Milord, of your Lordship's order, Milord, which is
Yes,
But
yes.
Your Lordship sees not at bottom of page 32 minute.
Yes, yes.
In the background, let me consider this case. In the case on hand, the trial court has rejected the plaint and order 7, rule 11 on the grounds of want of cause of action and barred by law. When the suit is dismissed as barred by limitation, it touches on the jurisdiction of the court. The appellate court, without deciding the question as to whether the suit is filed within time, it is maintained has no jurisdiction to pass a compromise. Not this, my humble submission would be contrary to the judgment of 1999 Supreme Court and not 2021. In the judgment relied upon by the respondent number 1 in the case of Vidyavihar Matai, this is the 1964 judgment. The apex court held that if the aggrieved party does not take steps to challenge the erroneous decree, the erroneous decree holds good. In this case, compromise decree has been challenged. But this challenge is by way of an appeal, as your Lordship saw, not in the 1964 judgment, not by way of a recall. 1999 judgment of the Supreme Court, not deals with the case of recall, where a order was passed that was sought to be recalled on the ground it is barred by limitation.
Yes.
And therefore, that would be the in this case, compromise decree is challenged. Hence, this judgment is not applicable to facts of this case. In the case of Atmaj honor relied upon by Supreme Court, respondent number 2, apex court held that it was not necessary for the court to say in express terms it was satisfied that the compromise is a lawful one. There is a presumption the court was so satisfied unless contrary is proved. In this case, compromise decree was challenged on the ground that it was not for the interest of the trust. Hence, the judgment is not. The Lordship just note not again one aspect here. When the Lordship not observed that the compromise decree was challenged, it was not for the interest of the trust. But what has not been noticed is there is no such plea which is taken up in the review petition. And therefore, that goes to the very root of the because without a plea, any finding on that would in my humble submission, be erroneous because it would be violative of principles and natural insofar I am concerned. Because had this plea been taken, as it should have been taken in a 92 petition, I point out here, even in the 92 petition till now, there is no challenge made to the sale which is of either the portion which has been given up in favor of the original purchaser or even the balance portion. No challenge is made. No prayer is made.
Yes.
In fact, we can produce a copy of the petition also. No, this property is not even questioned there in section 92 petition. And had that been done, I would have got an opportunity then. Now, in a review petition in my humble submission is not the forum for that. Section 92 is one where even subject to availability of the opportunity in law. If he has to seek for amendment and.
Right, in 92 petition, this was not there. This compromise. And
yes, no. Thereafter also is not questioned it.
This for later for them to.
Yes, therefore, my submission is that is the appropriate course. And the Lordship, I may just point out, in fact, the court has held that insofar as trust and all the issues pertaining to trust are concerned, it is the Trust Act and the court, there, civil court which would have exclusive jurisdiction, not other courts. In that regard, if I may just point out one judgment, that is 2016, 8 ACC 788. I should just turn to this is on
what point you are relying
on the aspect that insofar as issues pertaining to trust, beneficiary, interest of the trust, whether something is done in breach of duty of trust, it is the principal civil court of original which would have exclusive jurisdiction. And therefore, such issues could not have been gone into even had they pleaded. My submission would be, of course, there is no plea, but assuming that even pleaded it or even orally argued it, it is that court would have had jurisdiction. The context in which these observations are made, where the parties in a case of a trust, the trustees and beneficiaries, there was an arbitration clause, and they had sought to go for arbitration. In that context, the Supreme Court said there is no question because there is exclusive jurisdiction of the civil court under the Trust Act. Your Lordship turn to paragraph 50 in this judgment. At page 808.
Yes.
2016 8 ACC.
Para 50.
17. Yes, ma'am. When we examine the scheme of the Trust Act 1882, in the light of the principle laid down in condition 2, we find no difficulty in concluding that though the Trust Act 1882 does not provide any express bar in relation to applicability of other acts for deciding the disputes arising under Trust Act 1882. Yet in our considered view, there exists an implied exclusion of applicability of the Arbitration Act for deciding the disputes related to trust, trustees and beneficiaries through private arbitration. In other words, when the Trust Act 1882 exhaustively deals with trust, trustees and beneficiaries and provides for adequate and sufficient remedies to all aggrieved persons by giving them a right to approach the principal civil court of original jurisdiction for redressal of the disputes arising out of Trust Deed and Trust Act 1882, then, in our opinion, any such dispute pertaining to affairs of the trust, including the dispute inter se and beneficiary in relation to their rights, duties, obligations, removal, etc., cannot be decided by the arbitrator by taking recourse to the provisions of the Act. Such disputes have to be decided by the civil court as specified in the Trust Act 1882. Therefore, this judgment would also specify. I may also point out, even in so far as public trust is concerned, though proprio vigore may not, the provisions of Trust Act may not directly apply, but the Supreme Court has said all the provisions of the Trust Act will be applicable to a public trust also. Only thing not is insofar as that there would be a suit under either section 34 or not under section 9 CPC. Here it would be section 92. That's all. Otherwise, not. The whole scheme is these issues have to be gone into by that forum which has got exclusive jurisdiction. And therefore, my humble submission would be not, had they even pleaded in their review petition, which they have not pleaded, that this is not in the interest of the trust, not for the welfare of the trust, or it should have been done by a particular mode, or by calling for tenders. That is an issue which exclusive jurisdiction is there, not with this. And this court would have had to reject those contentions saying, your remedy is available in a section 92 petition, which they have already filed one, they can always amend it subject to the law, applicable law, whatever it is, if it is permissible to raise it in those proceedings, not by virtue of challenging a compromise on that basis, is my submission, insofar as this is concerned. And this aspect has not been noticed in the Lordship's judgment, and that's also not a ground for review. And the Lordship would note, when dealing with just a couple of more judgments, I will just point out on this aspect. That when dealing with
no, today I will not hear you, Mr. Udayola. You can, because after this, so many other matters, I will give a chance to tomorrow. Yes, yes. At least I will have.
Sorry, I didn't notice.
No, tomorrow, because at least another half an hour, some other urgent matters I can. Yes. Yes, yes.
Absolutely. But one more judgment, which point out that in dealing with compromise and recall of compromises, the court would not look into the correctness or the fairness of that compromise. Ultimately, the court would only see, is it something which is unlawful in the context of provisions of the Contract Act, whether it is vitiated by fraud, undue influence, coercion, mistake.
Yes.
Kindly turn to paragraph. This is 2008, 15 SCC 673. There a copy. Lordship, may kindly turn to paragraph 29. This was also a case where a compromise had been entered into in a partition suit.
Paragraph
29 at page internal page 690.
Yes.
The background facts are not that a partition suit had been filed.
Yes.
A compromise petition was arrived at between the parties. But some properties were settled between the different parties. They acted upon it also. And then one of the parties thereafter questioned saying that it is fraudulent. Kindly turn to paragraph 29. The fact remains that a consent decree was passed pursuant to a settlement arrived at between the two branches. They decided that the properties may be divided half and half. Indisputably, the said consent decree has been acted upon. Once that consent decree has been acted upon, the question of reopening the entire suit by setting aside the decree passed in the said so and so would not arise. I'm not pausing here for a moment. My humble submission was, in this case also, it has been acted upon in two ways. The original purchaser gave back possession. One portion has been conveyed in his favor. Another portion has been conveyed in a third party's favor, who is not a party here in these proceedings also. His interest is also not involved by virtue of the sale deed already executed in his favor. That has been acted upon. Once it has been acted upon, the question of now reopening the suit. But in fact, Leonard Senior also made a reference to it, saying that
what is the remedy for the persons who has agreed then?
Then not section 92. Insofar as a trust is concerned, it would be a section 92. Had it been another entity, they would have had to file a suit.
No, but Supreme Court said in respect of the compromise.
Please.
I think Order 23, Rule 3A.
Please.
Only remedy is to approach the same court.
Please.
Because the court which has passed in a compromise knows that what is the circumstances when is.
But that is on the basis if the parties to the compromise approach the court on the ground of a fraud being played in the compromise. It not insofar as now your lordship sees he is not a party to the compromise.
No, that doesn't say that only a party is to the compromise.
Not it says aggrieved party also not can be. Question not is who is then aggrieved. In fact, not I will point out the judgment. An aggrieved person can only be somebody who has got a direct interest in the property concerned. Not there, which your lordship has referred to the judgment of Supreme Court, where Union of India not filed a Union of India claimed right over the property. And therefore, it was affected by the compromise.
Yes.
Here, admittedly, my lord, that's where I would make a distinction. An aggrieved party can, my lord, file a review. There's no difficulty about it. Question is, who is aggrieved? Who is aggrieved, my lord, is a person who has a direct interest in the property. And insofar as trust property is concerned, Lord, Supreme Court has said, trustees are the owners. Even though if it is held, it's not a private trust where a person is identified as a beneficiary, it's a public trust. Therefore, no person, no member of the public, then the lordship would see, perhaps then the law should have been that if any trust were to enter into any compromise, first a public notice has to be issued. Everybody, because the whole world can then claim to be not interested, then anybody can say, no, this is not in the interest. Then there would be no possibility of such a trust entering into a compromise at all. That is not the law. If the trustees have the power, which admittedly there is no dispute about the fact that trustees have the power to sell. It is there in the trust deed. Once that is there, they being the owners, if anybody is aggrieved, their remedy is under section 92. Your lordship sees the judgment which was passed in the case Union of India was the aggrieved party which your lordship was referred to. That was not a case of where a section 92 kind of proceeding is maintainable. That was a case where Union of India was directly claiming a right. Here, they cannot claim a direct right because there is property is a trust property which belongs to the trustees. And in this, I would read the judgment along with this judgment because there is a caveat. The caveat is once it is acted upon, then the question of setting it aside does not arise and reopening the whole proceedings. Once that consent decree has been acted upon, the question of reopening the entire suit by setting aside decree passed in the said OS so would not arise. It is also not in dispute that the properties which fell in the share of the parties here to Srimati Vanajakshi are only 4 houses. It is also of some significance so and so. Then your lordship that is dealing with the facts of the case. Then your lordship would see just 2 lines thereafter. The basis for the entire suit being commission of fraud in obtaining the said consent decree, it was obligatory on the part of the plaintiffs to pray for setting aside the said decree. The pleadings of the appellants in the said suit in which their parties are binding on them in the subsequent proceedings proprio vigore, unless fraud was proved, they could not have got rid of the same. Said decree has been acted upon pursuant to or in furtherance of said decree, 10 sale deeds have been executed. Then your lordship would turn to paragraph 40 also. The others deal will not with the facts of those cases. And I'll not trouble your lordship with it. In the same judgment, page 694, para 40 at the bottom. Yes. When a fraud is alleged, the particulars thereof are required to be pleaded. No particular of the alleged fraud or misrepresentation have been disclosed. Not at page 694, para 40.
Yes.
We have been taken through the averments in the plaint. The plea of fraud is general in nature. It was vague. It is alleged by the plaintiff's signature was obtained on several papers on one pretext or the other, and they had signed in good faith, believing the representation made by the respondents, which according to them appeared to be fraudulent representations. When such representations were made, what was the nature of representation, who made the representation, and what type of representations were made have not been stated. Allegedly, on some occasions, respondents 1 and 2 used to secure the signature of one or more of the plaintiffs and defend 3 to 8 on several papers, but the details therein had not been disclosed. Therefore, not just pausing for a moment. Here, your lordship would note, in the review petition, there is not even an allegation of fraud, let alone particulars. Therefore, not the question of holding either the sale is fraudulent, would not be, then para 47, if I may just point out. At page 698.
Yes.
It is also not a case where the settlement was contrary to any statutory provision or was opposed to public policy as when stated in section 23 of the Contract Act. If the principal extra cause or non-extra action is to be applied in respect of consent decree, the matter might have been different. The courts will apply the statute for upholding a compromise unless it is otherwise issued in law. It is not required to go into the question as to whether the contents of the said settlement are correct or not. Only in a case where fraud on the party or fraud on the court has been alleged or established, the court shall treat the same to be nullity. Fraud is well known, vitiates all some acts, but the same must be pleaded and proved. Therefore, my lord, whether it was proper to sell this property, could we have made a better use of it? Why not, for the sake of raising funds, why not enter into a joint development agreement itself? But that is not the question to be gone into by the compromise accepting court. If at all, my lord, they have to raise it in a section 92 petition, not here. The power to sell, once it is undisputed, all other questions, my lord, would fade into insignificance insofar as this court were to be concerned. My lord, this is insofar as this judgment is concerned. My lord. Just a couple of more judgments, my lord, which I may just point out. My lord, that is in 2006, 5 SCC, my lord, page 566. Yes. Paragraph 17, my lord.
Regarding what?
My lord, on the question, my lord, that unless it is found the agreement which has been entered into is invalid, the question of recalling the compromise decree would not arise. Your lordship would just have a look at para 17, my lord.
Yes.
The position that emerges from the amended provisions of Order 23 can be summed up thus. No appeal is maintained against a consent decree having regard to specific bar contained in section 93 so and so. No appeal is maintained against the order of the court recording the compromise in view of the deletion of clause M of rule 1 of Order 43. No independent suit can be filed for setting aside a compromise decree on the ground the compromise is not lawful in view of the bar contained in Rule 3A. A consent decree operates in estoppel and is valid and binding unless it is set aside by the court which passed the consent decree by an order and application to the provision to Rule 3 or 23. Therefore, the only remedy available to a party to a consent decree to avoid such consent decree is to approach the court which recorded the compromise and made a decree in terms of it and establish that there was no compromise. In that event, the court which recorded the compromise will itself consider and decide the question as to whether there was a valid compromise or not. This is though because a consent decree is nothing but a contract between the parties superimposed with the seal of approval of the court. The validity of a consent decree depends wholly on the validity of the agreement or compromise on which it is made. Therefore, your lordship sees, even the question of jurisdiction, my lord, is not relevant. The only question, because it's a contract between the parties, the court only puts the seal of approval and disposes of the case. The question is, have you shown, have you alleged and proved that the contract is invalid? Because only if you show that the agreement or compromise is invalid, only then the compromise decree becomes invalid. Your lordship notes this line. The validity of a consent decree depends wholly on the validity of the agreement or compromise on which it is made. Therefore, my lord, unless it is found that the agreement is invalid, the question of assailing the compromise decree does not arise. Therefore, my lord, my humble submission is, I would humbly submit that the review petitioners original review petitioners have really barked up the wrong tree. It is not their case that this compromise is unlawful, agreement is unlawful. There is anything wrong. If they felt, my lord, some other method should have been adopted, again, my lord, is section 92 court. Because Trust Act gives the exclusive jurisdiction there, read with section 92 CPC. This aspect, my lord, has also not been noticed, my lord, by this Honorable Court, my lord, while accepting that. And therefore, my lord, my submission is the question of really suppression by us, though of course there is no suppression, my lord, because we have referred to the fact that there is a sale of the balance. That pales into insignificance. Because assuming, my lord, for the sake of argument, we had not pointed out that we are selling it to a third party. Also, then, my lord, the question is whether the agreement between me and the original purchaser, is it valid or invalid? Only if that is shown as invalid, on grounds, my lord, of the Contract Act, only then, my lord, the question of setting aside the compromise decree would be relevant. Lord, one other judgment, Lord, which I may just point out. A judgment, Lord, of 2022. This arose, my lord, out of a order, my lord, setting aside a compromise. Yes. Of course, intended to be in the Lok Adalat, my lord. Lordship would kindly turn to my lord para 33, my lord, of the judgment note at page 207.
Yes.
Para 33, my lord.
Yes.
This court in Ruby Sales and, my lord, this is judgment in 2022.
Yes.
This court in Ruby Sales and Services of State of Maharashtra, 1994, 16531, observed that a consent decree is a creation of creature of an agreement and is liable to be set aside on any of the grounds which will invalidate an agreement. Therefore, it would follow that the level of circumspection which a court of law ought to exercise while setting aside a consent decree or a decree based on a memo of compromise would at least be of the same degree which is to be observed while declaring an agreement as invalid. Therefore, the court should should approach with circumspection while setting aside a compromise. The court should ask, have they alleged, pleaded, and proved that the underlying agreement is invalid under any law? Only then, not the question of in Pushpadevi Bhagat, which has already been pointed out. This court held that since no appeal would lie against a compromise, the only option available for a party seeking to avoid such a decree would be to challenge the consent decree before the court that passed the same and to prove that the agreement forming the basis for the decree was invalid. It is therefore imperative that a party seeking to avoid the terms of a consent decree has to establish before the court that passed the same that the agreement on which the consent decree is based is invalid or illegal. Then not para 35. It is settled proposition of law that where an allegation of fraud is made against a party to an agreement, the said allegation would have to be proved strictly in order to avoid the agreement on the ground that fraud was practiced in a party in order to induce such party to enter into the agreement. Similarly, the terms of a compromise cannot be avoided unless the allegation of fraud has been proved. In the absence of any conclusive proof as to fraud on the part of the objectors, the High Court could not have set aside the compromise decree in the instant case. But on the aspect that the trustees are the owners, not just one judgment of the Supreme Court of 1958, 33 ITR 472. Of course, this arose under the Income Tax Act, but the question was, if there are trustees and there are beneficiaries of the trust, and there is some income which is accruing from some operations of the trust property, whether it jointly vests with both the beneficiaries and the trustees.
Yes.
Kindly have a look at paragraph 18 at the judgment.
Yes.
The case of the owner does not require any elaboration. He holds the land on his own behalf and also for his own benefit. He certainly cannot come within the scope of section 11 of the Act. The position of a trustee is also similar to that of the owner. A trust is thus defined in English law. A trust in the modern and confined sense of the word is a confidence reposed on in a person with respect to property of which he has possession or over which he can exercise a power to the intent that he may hold the property or exercise the power for the benefit of some other person or object. The property affected by the confidence is called the trust property or trust estate. It is usually in the legal ownership or in the legal control of the trustee. The sestequate trust is said to have a beneficial or equitable interest in it. A trustee is thus usually the legal owner of the trust property or the trust estate and holds it for the benefit of the sestequate trust. Reliance was, however, placed upon an observation of John Ramilly in so and so. Then your lordship kindly turn to paragraph 20 after quoting the judgment.
Yes.
The passage quoted above makes it abundantly clear that the legal estate is vested in the trustees and they hold it for the benefit of the beneficiaries. Whatever be the position in English law, the Indian Trust Act 1882 is clear and categoric on this point. Section 3 of the Act defines a trust as an obligation annexed to the ownership of property and arising out of a confidence reposed in and accepted by the owner or declared and accepted by him for the benefit of another or of another and the owner. The person who accepts the confidence is called the trustee. The person for whose benefit the confidence is accepted is called the beneficiary. The beneficial interest or interest of the beneficiary is his right against the trustee as owner of the trust property. The subject matter of the trust is called trust property or trust money. These definitions emphasize that the trustee is the owner of the trust property and the beneficiary only has a right against the trustee as owner of trust property. The trustee is the legal owner of the trust property and the property vests in him as such. He no doubt holds the trust property for the benefit of the beneficiaries, but he does not hold it on their behalf.
Yes.
Kindly now turn to para 23 also. The beneficiaries are also not necessarily persons who are jointly interested in such land or in the agricultural income derived therefrom. The term jointly interested is well known in law and predicates an undivided interest in the land or in the agricultural income derived therefrom, as distinguished from a separate or an individual interest therein. If on a true reading of the provisions of the deed of trust, the interest is created in the beneficiary is a separate or individual interest of each of the beneficiaries in the land or in the agricultural income derived therefrom, merely because they have a common interest therein, that cannot make that interest a joint interest in the land. Therefore, not my humble submission is, why I am reading this is to say, an aggrieved party can maintain a review, but the aggrieved party is one who should be interested in the property which is directly affected by the compromise. Here, they cannot be called as aggrieved parties because they do not have any interest in the property. As your lordship saw not from para 22, they may have a right against the trustee. That right is against the trustee, not in the trust property. Therefore, my lord, my submission would be that the judgment which your lordship referred to, my lord, for the sake of holding that an aggrieved party can maintain. That is true, my lord. An aggrieved party can maintain. But the question is whether they would be aggrieved parties. That, my lord, this judgment, if it is noticed, would show they cannot be considered as aggrieved parties because they must have a direct interest. Only then they can be considered as aggrieved. Therefore, not my submission would be, that is also an aspect not which has not been noticed. Not, therefore, my submission is subject to, of course, what they would say. This not the order not calls
on that judgment compilation and that.
I'll make, please, I'll do that. Not along with the proposition, not and the relevant paragraphs. Not I'll make a
tomorrow.
Please.
No, that Udayawalla complete. No, Udayawalla will come. Then we'll grant a time for you. Yes.
Grateful. But since your lordship has marked those, I'll make a separate compilation with the proposal.
Yes,
so
yes.
that both are available with your lordship.
Yes.
Great. For petition. Annexure M may kindly be seen. Suit for eviction.
Yes.
Petitioner has filed an application.
Suit for
Eviction. Ejectment.
yes.
For the direction of the defendant to deposit the outstanding arrears of rent towards his use and occupation of the plain schedule A property immediately, forfeit before this honorable court, and also direct them to deposit the monthly rent before this honorable court. We ask for 2 prayers, and the order passed at annexure N, my lord. Page number 82 may kindly be seen, my lord.
What is the order you are challenging?
Order passed by the trial court, my lord.
Yen order, yen application.
ಅಪ್ಲಿಕೇಶನ್ ಬಂದ್ಬಿಟ್ಟು ರೆಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ಕೆ ಒಂದು ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್ ನ ಕೋರ್ಟ್ ಮುಂದೆ ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ ಹಾಕಿದ್ದೆ. ಅದರಲ್ಲಿ ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಸ್ಟೇಟೆಡ್ ದಟ್ ದ ಪ್ಲೇಂಟಿಫ್ ಇನ್ ದ IA number 1 sought direction to the defendant to deposit the outstanding arrears of rent towards his house and occupation of plaintiff.
Number 2 dismiss ಆಗಿದ್ಯಾ? ಏನಕ್ಕೆ ಬಂದಿದ್ದೀರಿ? ಏನಕ್ಕೆ ರಿಟ್ ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲಿ?
ಅಲ್ಲ, ರಿಟ್ ಬಂದ್ಬಿಟ್ಟು we are sorting a direction to the court, to the defendant to deposit the monthly rent in the court, my lord. Is not depositing the rent because of this interim order.
Yes, you take notice. Yes. Notice.
That's all.
For the petitioner,
20.
your lordship had asked my colleague, this is regarding the commercial court has rejected the application for production of a board resolution.
Yes.
Your lordship, in this context, my colleague was asked if there is any supporting judgment. I want to place reliance on this judgment, if I may be permitted to.
No, that provision says it has to be produced along with that plaint. If the document is available, or if there is an urgency, you have to sort time of the court.
Yes.
Then it has to be
Me-
produced within 1 month.
Your lordship, the issue in this case is that if I may draw your lordship's attention to the plaint, there is a technical error which has happened in this. So may draw my lord's attention to page number 24. Satish, son of so-and-so, age so-and-so, partner Mahesh Home Appliances. Now what we are seeking is
Now, you are the plaintiff.
I'm the plaintiff before the trial court.
Now what has happened?
The application is for getting a authorization by all the partners ratifying the suit, filing of the suit. So we file that application is rejected on the ground. The relevant
Why,
But-
what is the stage now?
the stay, it's for final arguments. It is posted for final arguments
When?
tomorrow.
Yes.
The only reason
It
that
should notice stay of further proceedings in commercial suit number 1346 of 2023 pending in the file of 35th, 85 additional city civil and session judge Bangalore till next date of it. Yes.
obliged.
In this, the two petitions, we have complied with the office objections. Annexure C, a better copy of written statement has been sought. I think the legible copy is produced. That may be overruled. Your Lordship.
Yes.
Annexure C.
Yes.
The matter here is the petitioners are tenant. The dispute is here, Your Lords. There is a memo for calculations filed by the
Petitioner is a
tenant, Your Lords.
defendant.
Different.
Ah,
The tenant is a suit for eviction.
Eviction.
Please, there are three IAs that has been challenged. One is memo for calculation has been filed by the plaintiff, that is the landlord, stating that a certain amount of money has to be paid. There's a dispute with that regard because what they have stated in the memo for calculation is different from the plaint and different from the legal notice. So we have stated that undisputed amount we will pay. But the Honorable Court has stated that we have to pay the memo for calculations as per their calculations and therefore has struck off the defense. Then secondly, Lords, there are certain documents that has been sought to be produced because the property has been renovated by the tenant and that consent also has been given by the plaintiff number one. So because to show that we have spent money and that has to be set off, we wanted to produce certain documents. That recall application also has been rejected. Then at least in the cross, we wanted to confront that document that also has been rejected. Therefore, we are before Lords, before three applications.
Two cases are there here.
There are two premises, Lords, one on ground floor, one on first floor. It's a
Now, according to you, what is that rent admitted?
That's whatever admitted amount, 4 lakhs amount, two checks are placed before the Honorable Court, it's deposited. But they're not drawing that amount, stating that that amount is not sufficient. As per the memo for calculations, more amount has been payable. We have no objection for them to draw that 4 lakhs, what is before the court, and inquiry has to be held with respect to the balance amount. And our evidence that has been struck off has to be set aside and permit us to take the defense on record and lead evidence Lords. Subject to outcome of it, if we're able to show renovation was done.
Now, what is the stage in the suit?
Arguments for today, Lords.
Huh?
For arguments, for judgment, sorry. For judgment.
Now, what has happened?
For, out of part, we have made a mention that the matter is pending before Lords.
Yes.
Therefore, the matter is kept pending us.
Stay of heard issue notice. Stay of further proceedings in OS number 25901 of 2022. Pending in the file of additional city civil judge Mehal till next date of hearing. Learned counsel for the, in addition, petitioner is permitted to take out hand summons. You take hand summons also.
Please, sir, grateful.
Hand summons to the respondent.
Great.
Yes. Till next
Grateful,
date of
sir.
hearing.
Grateful.
Yes. This, you take hand summons, that's all. Stay is there in that one case, it's enough.
Same order for that.
No, here, why do you want to stay in that same suit for different suits or
Please,
same suits?
Same, different suits, Lords.
Different suits, different parties.
Same parties, but 2 suits have been filed by them, by the plaintiffs.
2 different premises.
Please.
Yes, same order.
Same order.
Yes, hand summons.
Please,
Yes.
grateful.
If the Honorable Court permit one submission, my Lordship. Serial number 75, my Lordship.
Wait, Madi, sir. Serial number 62, Somachakraya RP for petitioner, K.V. Narasimhan.
In this case, my lord, plaintiff petitioner here in my lord, we see plaintiff before the trial court.
Now, who has filed the memo for retirement?
Narasimhan, ma'am.
You are appearing now.
Yes, I'm appearing for them.
You are appearing for R1 to R8.
Yes, madam.
Yes. Learned Counsel KV Narasimhan has filed a memo for retirement. Memo is taken on record. So and so Learned Counsel is permitted to retire from the case. Yes. Yes, next week.
Next week, date may kind of be fixed, my lord, because it is at the stage of
28.
final hearing.
28.
Yes.
Right, interim order to continue.
Interim order granted earlier is extended till next date of it.
Serial number 63, Abhinay YT.
Non-compliance of that office objection.
The office objection is that I've not served a copy to KIDB. I've served it. I'll file the acknowledgement in the registry. And the second office objection is they've told I've not submitted the cost title, my lord.
Please served on KIDB, complete cost title of LAC to be filed.
Complete cost title in page number 49, my lords. The cost title comes like this in a reference case, my lord. Order sheet apply ಮಾಡಿದಾಗ ಅದ್ರ ಜೊತೆ page number
Yes,
49.
what is this matter?
My lords, this matter is, my lords, it is a reference case under 3031 for the apportionment of compensation. A joint claimant statement was filed by claimants number 1, 3, 4 and 6 on 28/7/2010. My allegation is that at that time she was a resident of United States of America. She was not there at the time of filing this claim statement. An admission is also made by her sister that she was not in India. To this objections, to this IA, she files an objection contending that my sister, the other sister who made the admission that she had come to Bangalore, she had signed the claim statement. ಅವರು ಅಮೆರಿಕಾಕ್ ಬಂದಾಗ ನನ್ನ ಹತ್ರ ಸೈನ್ ಹಾಕ್ಸ್ಕೊಂಡ್ರು. I file it here later on after 2 months. So when there are contradictions in the statement, my lords.
No, see, you are the claimant.
Yes, my lords, I am the claimant. I am one of the claimants.
One of the claimants.
Yes, my lords.
Now, what is your dispute is that?
My dispute is that the claim statement, what they have filed, one of the claimants has not put her signature. She was a resident of USA.
Who is under this, mister? You,
my lord.
Who is the claimant? You say, tell me that number.
Claimant number
The
6.
claimants don't have.
Claimant number 6. I am claimant number 5. Claimant number 4 is the other claimant.
No, in this, who is that respondent?
My lords.
You mentioned in referring to that respondent, mister. Who is the respondent who has not signed?
The respondent who was not signed here is my lords, respondent number 2, Maya Devi.
Maya Devi.
She is a resident of America. At the time of filing the claim statement, she was not in India, my lords.
Yes.
I've produced the extracts of her passport.
Yes.
Such a thing was also committed in another suit, which is a partition suit between the brothers.
Now, yes, now she has not filed there. You have raised an, who has raised the?
I have raised the objection.
Why? You are also one of the claimants.
I am one of the claimants, my lords, because after once this reference was filed, this property originally belongs to the grandmother of all the claimants. A document, a gift deed was produced, a discovery of gift deed was done. That also filed before the reference court. All the amount, once the property is gifted to a temple, a property is gifted to the temple, the amount has to go to the temple. Here, their claims is they have claimed the award in their individual capacity. At the time of filing the claim statement, she was not at India.
Yes.
My lords, if I can take my lords.
Is that claim petition?
Claim petition, my lords, is at page number 25. The signatures is at page number 25.
25.
The signature of the claimant number 6, who is the respondent number 2 herein, is claimant number 6.
You are also filed in a claim petition.
I have also filed the claim petition.
Claim petition has been signed by you also.
Not by me, my lords. I have filed, it's at my claim statement is at page number 26. It is not signed by me, my lords.
You are the claimant number 5.
I am the claimant number 5. I have produced.
You have filed in a separate.
Separately, I have filed the extracts of her passport. At
Then
that time,
what is
she's
that
not
order passed now challenging?
The order passed is that they say that I cannot question it. I cannot dispute it. The order is at, my lords, from page number 51, my lords.
She is not filed in a claim petition. If she is also an entitled for the share.
She is entitled for the share, my lords. But my lords, if such a thing is played in front of, if such a fraud is done in front of the trial court, it cannot be, she cannot be let scot-free, my lords. What I am telling is because, my lords, the original claim petition is in the custody of the court. If I have to refer this matter.
What is the order passed by the trial court?
The order passed by the trial court is that I cannot question this. If such a thing is played in front of a reference court, I cannot question.
Have you filed any application for striking off or something?
My lords, first, my lords, if the original claim statement is in the custody of the court. It has to be referred to scientific investigation and
That order of the trial court.
order of the trial court, my lords. Is that it starts from page number 51. The reasons is from page number 53, my lords. 53. If I can
filed
read,
an IA.
my lords.
You have filed an IA.
I have filed an IA to refer this to handwriting expert, my lords, because it is
have
in
to be mentioned. Mr. That's what I am asking.
yes,
for.
my
Is
lords.
that-
I filed an IA, my lords.
Yes. On that they have dismissed it.
They have dismissed
Now
it.
you are before, yes.
I am before this court. The IA is at page number, my lords.
Yes, heard. Issue notice. Stay of further proceedings. In LAC number 157 of 2010. Pending in the file of second additional city civil and session judge. Where session judge, where Bangalore?
Bangalore, my lords.
I have not mentioned what is that. Special judge Bangalore till next date of your emergent notice.
CCH 17, my lords.
Yes, that is not.
Serial number
That's okay.
64, VP Siddharamaiah.
Plaintiff's writ petition, my lord.
What is this maintainability?
My lord, the petitioner's suit has been dismissed for non-prosecution. They have filed an application under order 9 rule 13 CPC for restoration of the suit. The same has been rejected.
No, suit for what?
For permanent injunction.
That is dismissed.
Dismissed for non-prosecution at the time of leading evidence. For not leading evidence. We have filed a miscellaneous petition before the same court under order 9 rule 13 CPC.
Order 9?
Rule 13 of CPC. My lord, that application has came to be rejected.
Now you have to file in a CRP.
CRP is not maintainable, my lord. CRP maintainable only if it leads to final adjudication of the dispute in
No,
controversy.
if.
115 is
that
not maintainable.
Proceedings has been terminated by that order,
Yes.
then you have to file in a CRP.
No,
By
if CRP is filed-
dismissing, that case is closed. See,
No,
matter has to be pending before the court. Only
My lord,
interlocutory
C-
order has been
Yes,
passed.
I
then
understand, my lord,
227.
as far as the proviso to CRP is concerned, CRP is maintainable only in case if following the
No, that is
CRP,
full bench judgment of this court. If there is an order on interlocutory application in pendency of the suit, only 227. Otherwise, CRP, you read that Tamaya's case. You verify that 9 judges, this thing, next week.
yes, I will verify.
Yes, verify that. This is application filed under order?
9 rule 13.
Yes.
My lord, if it is a decree, then appeal lies.
Not decree.
Yes.
See,
Yes.
rejection of the plaint is not in a decree.
As the Supreme Court held that was as far as the proviso is concerned.
The rejection of plaint is closing of the case itself. It is not in a decree. Then they said that in appeal. Same principle, Mr. Yes, you verify that.
Yes, please.
Serial number 65, Basavanna KM.
My lord, appear for the petitioner, my lord. I'll challenge the order as per annexure T, my lord, page 108.
Yes, non-compliance office objection. What is that, Mr.?
My lord, I'm not party in the proceedings.
Is not a party to the trial court to be clarified. Yes.
Please, my lord. 2 days accommodation, my lord. I'll file the application for to leave of the court to.
Yes. At the request, please.
Tuesday, my lord.
Yes, yes, next week. Yes.
My lord, Tuesday, my lord. Urgency, my lord, in this matter, my lord. There is an appointment of commissioner is already allowed by
No,
the
if
trial court.
if you are not in a party to the suit.
My lord, the
then you
same.
file-
My lord, what happened, my lord? Two proceedings
Yes,
is.
yes. Yes.
My lord, two
Let us see
proceedings
that.
before.
Let them appoint commissioner. Yes, yes.
My lord, Tuesday, my lord, at least, my lord.
Yes,
Tuesday.
yes, yes, yes.
Please, my lord.
Hearing interlocutory application matter, serial number 66, LM Chidanandaya.
I appear for the petitioner. Let this interim order with all, with the permission of the learned senior counsel, Millet. After hearing this interim order is granted. Millet, hearing the application for vacating the interim order, hearing is one and the same. Your lordship may hear anytime, Millet. The issue is whether a person who is not a party to the award, can he be subjected to execution proceedings before the commercial court? The court has taken the view that the entire award is null and void and not binding on the petitioners. Now, in spite of the finding given, Millet, the amount was deposited, is given that a challenge before this court. This
No,
court, the
no,
actor came in.
Suit is for what?
These are all arbitration claims, Millet.
Arbitration claim.
We are not the parties to the proceedings. So without making us a party, the compromise petition is entered, compromise award is passed.
We challenged.
Compromise award is passed before that
arbitrator.
Hmm.
Then my lord, we filed a writ petition challenging that compromise petition. This court said you go and approach the executing court because under 47, executing court has all the powers to look into. Now the executing court, my lord, in the connected writ petition filed by the other side. So they have taken the court examining the law applicable, particularly section 19, took the view that without making them a party, without the resolution of the partners, invoking the arbitration itself is illegal. Award is void. That is a subject matter of other writ petitions. Well, after giving that finding, well, they made an application for release of the money deposited in collusion with the second respondent.
Yes.
So that we have challenged, well, this court granted a stay of the release of that money. Well, hearing of the malad application is one and the same.
Yes.
The learned senior counsel
My lord,
is ready to
Lordship,
address
Monday, my
argument
lord.
of the main
Yeah,
evidence.
Monday, even today I am ready on merits, my lord.
You have fixed some other day, this thing, 28th. Tuesday, 28th.
Tuesday, that's very
Yes. Leave this matter on Tuesday, 28th.
Serial number 67, Sachin BS for petitioner.
Your Lordship, I'm appearing for the respondent number 1, plaintiff in the suit.
Yes. What do you want? You want time?
Yes, Your Lordship, in this, a little background of the case, Your Lordship.
No, you are ready or you want time?
No, I'm ready, Your Lordship.
Huh?
I'm ready.
You want, you argue on that vacating?
Vacating, yes.
Yes.
Yes, I am also ready.
Ready? Yes, any date? Next week, now that time is, any date you want? I will have it on 28th, madam.
Your Lordship, the week after that. Your Lordship. The week after that, Your
Week after that. 4th February?
Yes, sir.
Yes, leave this matter on 4th February.
Serial number 68, Shivashankar K for petitioner.
Interim order be extended.
Interim order granted earlier is extended till next.
Respondent.
That's a very short point. Lordship can
No, my lord.
dispose
it
of this
requires
writ
the
petition.
hearing, my lord. I am also ready.
You are the
But-
plaintiff or a
The
defendant?
plaintiffs, plaintiff's writ petition.
Hmm.
That's after commencement of evidence, an amendment application has been filed.
Hmm.
Amendment only with regard to the property purchased by the petitioner. So that
Suit
is
for?
Suit for partition, declaration and other reliefs.
The amendment prior is.
Amendment only with regard to the property was purchased in the name of the petitioner's father.
Hmm.
Subsequently, the petitioner, without the knowledge of these petitioners, it's a joint family property. Father, the one of the party has obtained the unregistered GPA.
27. Yes, leave this matter on 27.
Serial number 69, B Ramesh for petitioner.
Yes.
For the respondent number 1, my lord.
Yes.
Respondent number 3, my
My lord, say, in a miscellaneous petition has been filed by the first respondent, my lords, to recall the compromise petition in passed in OAS after a lapse of 5 years. My lords, that compromise petition has been acted upon by the mother and other sister. Now, my lords, the respondent number 1 files a miscellaneous petition after, my lords, several transactions have been taken place in respect of the property which has been allotted to the mother and the sister. My lords, now petitioner is the brother of the first respondent. Now, my lords,
Now that has been recalled.
my lords, no, my lords. In miscellaneous,
We'll fix the date.
my lords, now what has happened? Interim order is there. Last
No, my lord, I am opposed for this.
Last occasion on appear agila.
What is
No,
that?
not 2 days, 3 days, my lord.
Wait. What is that increment?
Stay of the further proceedings in miscellaneous petition. For this reason,
Now what is happening there?
my lords, there, the petitioner who has filed the miscellaneous petition has cross-examined the RW1, that is
Now,
the son.
in view of that, not extending that, have the court taken that matter?
Lords, now it is listed in 28th of this month.
Yes, let it be there, interim order, we'll hear that
Because, my
matter.
lord, there was an interim order, because, my lord,
My lord,
mother files an application.
There is no interim order
My
granted by
lord,
this
mother
court, my lord.
files an application for recall.
Today is time, yes. Interim order.
But a short date may be given, my lord, always.
Lords, they have not filed any
28th.
application for extension of interim order, lords.
Yes, mister.
Extension of interim order, no application has been filed.
Argument ಮಾಡ್ತೀನಿ ನನಗೇನಿಲ್ಲ.
Yes, interim order granted earlier is extended.
There's no interim
No,
order granted by this
see,
court.
if there is any development has taken place, then it requires to see that. But here that matter is not yet posted after that.
Well, 28th it has been posted
No,
for
there is no-
cross-examination of RW1 by respondent number 2.
Interim order granted earlier is extended till next date of hearing. Leave this matter on 28th itself.
My lord, submit entire the order sheet, my lord.
Yes, yes.
Serial number 70, Vivekananda TP for petitioner.
Or there's no interim order granted by this court. That's what my this thing is, my lords.
For
In
R2,
which
my
case,
Item 69, my lords.
interim order, if there is,
There is an interim order.
if there is an interim order, that has to be extended. If there is
Alright.
no interim order, is
Lords, this is an interim order.
ಆಯ್ತಪ್ಪ ನಾವು ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ಬಿಟ್ಟೆ ಮಾಡ್ತೀವಿ. Yes.
My lords. Highly obliged.
Serial number 70,
Yes, what is this, Mr.
For R2, my lords. We have
Hearing of
filed
the
an-
application is as good as hearing the main matter. Monday or Tuesday, it will, lodge may have it.
My lords, we are ready, my lords. We have filed application
No,
for
I am also
vacation of.
ready.
Ready, but I am
I'm
not
also
ready. See, the time is over. Yes.
My lord, there's an urgency in this matter.
29th.
My lords.
That the interim order may kindly be extended.
Like in the next week itself, my lords, 21st.
Next week again, Mr. These spotted matters are there. You have to wait till 5 o'clock and you have to go out. Therefore, I'm saying that I want to finish up that spotted matters in that next week. Then after that, it may free. Yes.
Because 54,75,000 has been deposited, my lords. It is lying vacant.
Yes, yes.
That is the reason we are.
Interim
we are
order may
pushing
kindly be
for this
extended.
order,
lords.
Yes, leave this matter on 29th. Interim order granted earlier is extended till next date of it.
Please.
Other matters, whenever you want time, you seek for a date from the court officer.
Interim.
Serial number 88, interim order.
The interim order, you mentioned interim order will also extend it.
Date my lord, one date my lord.
See, you seek whichever date you want, the date will be given. And you also say that interim order, then interim order wherever there, it will be extended.
Please.
You have to mention and go.
Grateful.
And 1 week ಆದ್ಮೇಲೆ ಎಲ್ಲ ಡೇಟ್ ಕೊಡ್ತೀವಿ ಯಾಕಂದ್ರೆ this case, stamp duty.
Stamp duty, I appeal for the response. Lordship had directed my lords to be listed in preliminary hearing. However, it is listed in B group, my lords.
ನಾವು ಬಿರಿ ಗ್ರೂಪ್ ಅಲ್ಲ ಇವತ್ತು ನನಗೆ ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇತ್ತು ಬಿ ಗ್ರೂಪ್ ತಗೊಳಕ್ ಆಗ್ಲಿಲ್ಲ.
ಅದಕ್ಕೆ
25th. Yes,
Monday.
we'll have it on 24th. 23rd.
86.
No, that is there, that judgment is there.
Please, Manoj.
Civil court cannot do it. It has to be referred to that. That you, but I don't have any time to dictate on 23rd.
Lordship may have it in preliminary hearing, my lords.
Barley, 23rd will.
Please.
No, there is no special treatment for preliminary.
Serial number
Will-
83.
I will reach that B group because of that, yes.
83, my lord.
All other matter it will be urgent.
The trial court is not giving the time today. Prayer, Lord, take it up tomorrow, my lord.
No, there is no interim order.
There is no interim order. The notice is issued to them, my lord.
Hmm.
So therefore, my lord.
Who is
the
other side?
Counter claim is amended. The counter claim is.
No, for what it is posted?
The suit after completion.
Return statement ಅಷ್ಟೇ ಅಲ್ಲ.
Now, with the additional written statement, my lord, after completion of my evidence, counter claim is.
What is the
after
next
amended.
date? Next date?
20th it is listed. 21st it is listed.
Listed.
Yes,
Yes, list that on 21st. Yes.
please.
86 interim order.
ಹೇಳಿ.
Please.
Sir, serial number 74.
ಒಂದ್ ನಿಮಿಷ
ಆರ್ಡರ್ ಅಲ್ಲೇ ಕರೆದು ಬಿಡಿ ಸರ್.
71 ಇಂದ 1 week ಆದ್ಮೇಲೆ ಡೇಟ್ ನಿಮ್ ಇಷ್ಟ ಎಂಟ್ರಿ ಮಾಡಿ 71 72 ಇಲ್ಲ
73.
73 ಡೇಟ್ ನಿಮ್ ಇಷ್ಟ ಬರ್ಕೊಳ್ಳಿ ಡೇಟ್ ಬಂದ್ ಫೋರ್ತ್ ಎಂಟ್ರಿ ಮಾಡರ್ 74 ಯಾರಾದ್ರೂ ಡೇಟ್ ಹೇಳಿ 4 ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ಆಯ್ತು
75 22ಗೆ ಕೊಡ್ಬೋದು.
22 ಇಲ್ಲ ಸರ್ 1 week ಆದ್ಮೇಲೆ ಅಂತ ಹೇಳಿದಾರೆ ನೀವು 28 ಆದ್ಮೇಲೆ ಯಾವತ್ತಾರು ಡೇಟ್ ತಗೊಳ್ಳಿ.
28 ಕೊಡಿ.
76
Sir, entry order next time.
ಯಾವ್ದ್ರಲ್ಲಿ
76.
76
ಸರ್
Next week ಕೊಡಿ. First week of.
ಡೇಟ್ ಹೇಳ್ರಿ ಫಸ್ಟ್ ವೀಕ್ 5th February ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Yes.
77
बिस्पराट तुम्हारा
28 ರೀಚ್ ಆಗಲ್ಲ ಸರ್ 28 ಆದ್ಮೇಲೆ
बड़े बड़े केस आगे थे
ಮಾಡಿದ್ಯಾ?
तुम्हारा होने का एक जना खड़ को 1 घंटा आर्ग्यूमेंट कर डाले 3 केस.
ಸರ್ 78
ಹೇಳಿ ಸರ್.
ಸರ್ ಮಾರ್ಚ್ ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ ಸರ್, ಫಸ್ಟ್ ಇಲ್ಲ ಸೆಕೆಂಡ್.
ಯಾವುದು ಮಾರ್ಚ್ ಅಲ್ಲಿ? ನೀವ್ ಯಾರಿಗೆ?
ಸಾರಿ ಫೆಬ್ರವರಿ 2nd ನಾನು ಪೆಟಿಷನರ್ಗೆ ಸರ್.
Petitioner, February 10th,
Sir, interim order.
interim order.
Yes, sir. Interim
79.
order. Please.
ಯಾವ್ದು ಡೇಟ್ ಹೇಳಿ ಸರ್. 10th February ನಾ ನೀವ್ಯಾರಿಗೆ ಆಯ್ತು 80 ಆಗಿದೆ 81 ಆಗಿದೆ 82 29th ಆಲ್ರೆಡಿ ಯಾವ ವೀಕಲ್ 30th 82 30th ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ಇಲ್ವಾ 83 ಆಗಿದೆ 84 ಆಗಿದೆ 85 ಇಲ್ಲ 86
ಸರ್ 86 ಸರ್ 18th of February
18th of February
ಅಲ್ಲ ಈಗ ನಮ್ಮ ಮದುವೆ ಇದೆ ಮನೆಯಲ್ಲಿ ಅದಕ್ಕೆ
ಆರಾಮಾಗಿ ಸ್ವೀಟ್ ತಗೊಂಡು ಬರುವಾಗ
ಸರ್ 87 ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ 29th 30th ಕೊಡಿ ಸರ್. ಸರ್ 87 ಸರ್ 87 ಯಾವ ಡೇಟ್ ಸರ್?
ಸರ್ 89 ಸರ್. ನೀವು ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್ ಒಂದು ಕೊಡಿ ಸರ್. ತಮ್ಗೆ ಯಾವ್ದು ಅನುಕೂಲ ಒಂದು ಫಸ್ಟ್ ವೀಕಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಒಂದು ಕೊಡಿ ಸರ್.
ಫಸ್ಟ್ ವೀಕ್
ಹೌದು ಸರ್.
6th February
6/2 ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಸರ್.
ಸರ್ 87 ಯಾವ ಡೇಟ್ ಹೋಯ್ತು ಸರ್?
24 ಎಲ್ಲ ಮುಗಿತಾ? ಹೇಳಿ ಸರ್ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್. ಯಾವುದು?
87 ಸೀರಿಯಲ್ ನಂಬರ್ 87 ಸರ್.
87
ಹೌದು ಸರ್.
12th February ತಗೊಂಡಿದ್ದಾರೆ ಸರ್.
ಸರ್ ಎವಿಕ್ಷನ್ ಸೂಟ್ ಅದು
ಅವರು ಇದ್ರಲ್ಲ ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ. ಪಿಟಿಷನರ್ ಅವರೇ ಹೇಳಿ ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ.
ಸರ್ 75 ಏನ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಸರ್? ಹಲೋ
28
ಓಕೆ ವೆರಿ ಮಚ್ ವೆರಿ ಮುಗೀತು ವೆರಿ ಮಚ್
ಆಗಿದೆ. 21st ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಯ್ತೇನಪ್ಪ ಎಲ್ಲ ಮುಗೀತಾ? ಸರ್ ಹೇಳಿ. ಆಯ್ತು ಕೇಳಿದ್ರೆ ಗೌಡ್ರು ಬೇಗ ಬೇಗ ಮೇಡಮ್ ಬೇಗ ಹೋಗ್ಬೇಕು. 71 ಕೇಳಲಿಲ್ಲ ಅರ್ಜನ್ ಅಂದ್ಬಿಡಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಕೊಡಿ. 72 ಕೊಟ್ಟಿದ್ದಾರೆ ಬೆಳಿಗ್ಗೆನೆ. 70 ಬೆಳಿಗ್ಗೆ ಆಗಿದೆ. 73 42 ಎಂಟ್ರಿ ಮಾಡರ್. 74 42 ಎಂಟ್ರಿ ಮಾಡರ್. 75 28 1 ಎಂಟ್ರಿ ಮಾಡರ್ ಕೇಳಲಿಲ್ಲ ಅವ್ರು. ಆಮೇಲೆ 76 52 ಎಂಟ್ರಿ ಮಾಡರ್. 77 29 1 ಎಂಟ್ರಿ ಮಾಡರ್ ಗೊತ್ತಿಲ್ಲ. 78 10 2 ಎಂಟ್ರಿ ಮಾಡರ್. 79 10 2 ಎಂಟ್ರಿ ಮಾಡರ್. 80 81 ಬೆಳಿಗ್ಗೆ ಆಗಿದೆ. 82 31 30 ಎಂಟ್ರಿ ಮಾಡ್ರು ಅವರೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿ. 83 21 1 ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದಾರೆ. 84 23 1 ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದಾರೆ. 85 ಕೇಳಲಿಲ್ಲ ಅರ್ಜನ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ನೀವೇ ನೋಡ್ಕೊಳ್ಳಿ. 86 18 2 ಎಂಟ್ರಿ ಮಾಡರ್. 87 12 2 ಎಂಟ್ರಿ ಮಾಡರ್. 88 ಯಾರು ಕೇಳಲಿಲ್ಲ ಅರ್ಜನ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ. 89 6 2 ಎಂಟ್ರಿ ಮಾಡರ್. ಒಂದು ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಮಾಡೋದು ನಾವು ಅದೇ ಎಲ್ಡ್ ಅಪ್ ಮಾಡಿದ್ವಿ. ಇದೊಂದು ಮಾತ್ರ ಕಟ್ಬೇಕು ನಾನು. ಅದು ಅದೇ ಮಾಡ್ಬೇಕು. ಒಂದ್ ನಿಮಿಷ ಪಾಪ ಮೇಡಮ್ ಹಾಕೊಂಡು ಇದು ಪೆಂಡಿಂಗ್ ಹೋಗಲ್ಲ. ಅಪ್ಲೋಡ್ ಮಾಡೋದು ಇದು ಮೇಡಮ್ ನೋಡಿ. ಇದು ಮೇಡಮ್ ಇದೊಂದು ನಾನು ರೆಡಿ ಮಾಡಿರ್ತೀನಿ. ರಿಪೀಟ್ ಮಾಡಿಸ್ಬಿಡ್ತೀನಿ. ಫೈಲ್ ಇಲ್ಲೇ ಇಟ್ಕೊಳ್ಳೋಣ. ಬಾಕ್ಸಿಗೆ ನೀವೇ ಹಾಕ್ತೀನಿ. ನಾಳೆ ಹೋಗಿದೆ ಅಷ್ಟೇ. ರಿಪೀಟ್ ಮಾಡಿಸ್ತೀನಿ. ಬಾಕ್ಸಿಗೆ ನೀವೇ ಹಾಕೋದು. ಇದು ಮೇಡಮ್ ಕೊಡು. ಮೇಡಮ್ ಡೇಟ್ ಮಾಡ್ರಿ ಇವತ್ತು ಯಾವುದು ನಾಳೆಗೆ ಇದೊಂದೇ. ಹಲೋ ವಿಶ್ವಂ ಕೊಡಿ ಸರ್. RP 226 of 24 230 ಮಾಡಿದಲ್ಲ ಹಂಗೆ ರಿಪೀಟ್. ಇದೇನ್ ಚೇಂಜಸ್ ಇಲ್ಲ. ಒಂದೇ ರಿಪೀಟ್. ಹಾಕಿದೆಲ್ಲ ಅದು ಕೇಳ್ಕೊಂಡು ಯಾರು ಏನು ಫೋನ್ ಮಾಡಿಲ್ಲ, ನಾನು ಫೋನ್ ಮಾಡಕ್ ಹೋಗ್ಬೇಡ, ನಂಗೆ ಟೆನ್ಷನ್ ಎಲ್ಲ ಇದೆ, ಇನ್ನು ಇದೆಲ್ಲ ಸೈಟೇಷನ್ ಎಲ್ಲ ರೆಡಿ ಮಾಡ್ಬೇಕು, ಇದೊಂದು ಆರ್ಟಿ ರಿಪೀಟ್ ಮಾಡ್ತಾರೆ, ಫೈಲ್ ನಮ್ಮ ಹತ್ರನೇ ಇದೆ, ಎಲ್ಲ ಸೇರಿಸಿ 60 ಕ್ಲೋಸ್ ಮಾಡಿ. 52 ಆಗಿಲ್ಲ, ಇನ್ನೊಂದು 2 ಎಲ್ಲ ತೆಗೆದುಬಿಡಪ್ಪ, ಯಾಕಂದ್ರೆ ತಿರ್ಗಾ ಇದು ಆರ್ಟಿ ಹಾಕಿದಾರಲ್ಲ, ನಾಳೆ ಹೋಗುತ್ತೆ ತಿರ್ಗಾ ಎಲ್ಲಾರು ಮೇಲೆ ಎಲ್ಲಾರು ಡೇಟ್ ಇದ್ದಾರೆ ತೆಗೆದ್ರು. WB ಬಂದಿರ್ಬೇಕು ಅಂದ್ರೆ ಡೇಟ್ ಇರ್ಬೇಕು, ರೆಡ್ಡಿಂಗ್ ಇದೆ ನಂದು ಇರ್ಬೇಕು. ಆಯ್ತು. 1 ಪಾಯಿಂಟ್ RFA ಅಪ್ ಟು 8 ಇಯರಿಂಗ್ ಅಷ್ಟೇ. ಆರ್ಡರ್ ಸೈ ಅಡ್ಮಿಷನ್ ಮಾಮೂಲಿ ರಿಪೋರ್ಟ್ ಮಾಡ್ತಾರೆ. ತೆಗೆದು ಅದನ್ನೇ ತೆಗೆದು ಆಮೇಲೆ 17 ಇದು ಸಾರಿ RP 1 ರಿಪೀಟ್ ಮಾಡ್ಕೊ, ಎಲ್ಲ ಸೇರಿ 60, ಯಾಕಂದ್ರೆ RP ನಾಳೆ ಮುಗ್ದೋಗ್ಬೇಕು ಅದಕ್ಕೆ. ಅಲ್ಲಪ್ಪ ಅವ್ರು ಯಾರಿಗೆ ಏನ್ ಹೇಳಲ್ಲ, ಸೈಟೇಷನ್ ಕೊಡ್ತಾ ಇರ್ತಾರೆ, ಅವನ ಹೆಸರು ಗೊತ್ತಿಲ್ಲ ನನ್ಗೆ. ಆ ಸಾಹೇಬ್ರು ಯಾರ್ರಿ ಅಂತ ನಿಂಗೆ ಬರೆಯೋದೇ ಇಲ್ಲ ಅಂತಾರೆ ಸಾಹೇಬ್ರು.